Sanjay Chanal is appearing.
Write on a paper and give.
My lords.
Then write on a paper and give his name.
Yes, my lords. Sanjay Chanal.
So and so. The registry is directed to print the name of so and so. This is matter next week.
Next.
Look at it. If intermodal is the extent in there.
Acho plus.
Page number 20, serial number 69 to 75.
Lord, serial number 70. my lord.
70?
70.
Who has moved the memo?
CBID correspondent.
My lordship, serial number 66, my lordship.
Lords, I have also informed the other
Huh?
side. I have also informed the other side.
Both of you are informing to the other and moving the court. That's the whole problem.
Any date in next week may be good.
Here afterwards, any memo that is moved and still the advocate seeks time, I'll adjourn it at least in the month of June or July. I want to make it very clear.
Senior is busy.
Huh?
Senior is not here.
This is matter, 23rd February.
My lordship, serial number 66, my lordship.
Yes,
My lordship, another matter to be connected with this same matter, my lordship. The petitioner is same in the both the cases, my lordship.
no, why do you want adjournment?
One matter to be connected with the same writ petition, my lordship. Another matter is to be connected.
No, if
This
you hear
along with-
this, then whatever the order in this, that will follow in the other one. Why should we adjourn this?
Srinivas B. Naik correspondent.
Another matter to be connected, my lordship.
We will see when the matter reaches. Yes.
Please.
Page number 20. Page number 21, serial number 76 to 83. Page number 22, 84 to 90. Page number 23, 91 to 98. 24, 99 to 106.
My lords, serial number 99, my lords. My lords, the connected matter is also, my lords, serial number 99, my lords.
Tejeshwar.
Yes, my lords, serial number 99 and 100, my lords. The connector matter is also listed on 3rd, my lords. So I may be physically present on that day, my lords. Kindly have it on
Take
3rd,
that
my lords.
list along with so and so on 3rd.
Third.
Yes.
Page number 25, 107 to 113. Page number 26, 114 to 118. 27, 119 to 120. 28, 121 to 123.
My lordship,
Lord,
serial number 117. 117.
117.
Memo for withdrawal has been filed. Your lordship, I pray for permit it.
We will do it. We will do it with the matter because whether you sought for liberty or all, we have to see.
Okay.
We'll do it that time.
Much obliged.
Serial number 122 has become infructuous.
120,
122. 122 has become infructuous.
then counts for the petition submitted the.
I'm for the respondent, my lord. Petitioner already I have told.
What is, how it is become infructuous?
Lord, they had come on IA.
Eh?
They had come to this honorable court on the order passed by the ARCS, that is on IA. Now the main appeal itself is disposed
It is
on
submitted
16.
that against an interlocutory order, the present writ petition is filed. And the main.
Appeal
main
is
proceedings
disposed on
itself-
16th.
Main proceedings itself are concluded as the petition has become infructuous. Accordingly, the petition is dismissed as infructuous.
Great.
Yes.
Number 29, 124 to 126.
It's 125 minutes.
125.
In the last occasion, Lordship
137.
Lordship has heard this matter. Today they have given me the acknowledgement of that surface settlement, OTS settlement application. To seek instruction, my lords, a short accommodation.
Why again it should be adjourned?
The reason is that, my lords,
It is only for them to say.
please, my lords.
No, it is for the bank to say. You
Yes.
should have got the instructions by this time.
No, my lords. Today they have served the copy of OTS application. My branch says that, my
Not
lords,
serving on you, the bank should.
Please,
but
Minister.
Only one thing, whether that the scheme is available or not is the only question.
Please.
Irrespective of document is served on you or not.
scheme is not available, my lords, as per the
Scheme is not available, how will they consider?
They have issued the application.
Huh?
They have issued the application. They have accepted the amount also. Madam. I will place it on record. My learned friend want time to verify it. If you want to verify, let him verify. Otherwise, I will place it on record. It can be heard and it can be disposed of. I am not.
To get instructions, it have been unnecessarily, again, we have to adjourn this matter. This is the matter on 10th February at the request of
On,
non-council respondent.
my lords, on third, my lords, it will be.
On 3rd, no
Please.
further adjournment will be granted.
Let's may this matter be listed in preliminary hearing minutes. In,
It will reach every day I'm completing the list.
please, please,
Whatever are the number.
please, please,
Yes.
please, wait.
List 2 page wise adjournment from preliminary hearing.
Order matters don't fall in
Yes.
the second list.
Yes.
Call from.
Page number
preliminary-
3, serial number 12 to 13.
Yes.
Page number 4, 14 to 15. Page number 5, serial number 17, 16 to 17. Serial number 18. Page number 7, serial number 19 to 22.
Milord, serial number 20, I'm withdrawing, Milord.
Serial
Serial
number.
number
20,
20.
list to serial number 20.
Shivasiru,
Please.
Rajshekhar Burji for
We
respondent.
will do it. Now you are filing.
Yes,
Ayo,
ma'am.
take that. It is, a memo is filed stating that the petitioner is not interested to prosecute the matter, as they're exposing the feasibility of an amicable settlement. Hence, the petition, hence they were permitted to withdraw. Accordingly, memo is taken on record and dismissed as withdrawn.
List 2, page number 8, 22 and 24. List 1, orders matter, serial number 1. Prashant S. Vasmani, Chand Dharwad.
This philosophy, I appears for 1 week time, Your Lordship.
A week's time for taking steps in respect to the deceased respondent, or else the writ petition shall stand dismissed against the respondent.
And Your Lordship, the name of Prashant Vasmani may be deleted, Your Lordship.
Whose name?
Name of Prashant Vasmani.
Delete name of Mr. Prashant Osmani. Already is MM Kanur has filed the wakalat. Yes.
Serial number 2, Arunal Nilopan.
OS number 30, the writ petition is filed against an interlocutory order. OS number 33 of 2012 and OS number 2 of 26 itself are disposed as per the office note. Hence, the writ petition is dismissed as infructuous. The next 3, same order.
I am for,
OS
one
number-
submission, my lords. I am for the respondents 1 and 2. The suit itself is disposed of by the trial court.
That's what there is an office note.
Yes, yes. And it has become infructuous.
Same order. 4, this also same.
No, Milord, not Milord. For the respondent. Challenge, one more writ petition, Milord, the WP number 105-711 of 2019. Milord, what is happening, Milord, the execution, during execution petition, the Milord, the present petition filed an objection.
Execution petition is dismissed.
But,
disclosed.
but my challenge, the Milord, my objection, Milord, not considered by the execution court. Milord, the sale deed executed by the court commissioner beyond the Milord, the decree.
Which order is questioned before this court?
Milord, the interim order, Milord, my objection is not considered by the
Correct.
execution court.
What is that order?
Order is, Milord,
Give that, give the file.
the court commissioner, Milord, the executed sale deed beyond the decree.
What is questioned before this court? Order dated?
572. Annexure. Page 140,
140.
141.
After that, execution itself is closed.
Time being closed because,
You're not supposed to question it
please, time being closed.
unless and until you question it. What is the effect of this order?
But SLP is pending. SLP is pending.
That is not the concern. No, again, is this order, you need to file a writ petition. It was dismissed in the year 2021.
Execution has been closed, but my submission is sale deed executed by court commissioner beyond the decree. Suit for specific performance, Milord, the agreement is 1 acre 25 guntas. Court commissioner executed sale deed 1 acre 28 guntas. That is filed objection before the execution court. Please,
You have questioned an interlocutory order
Please.
arising in an execution petition.
please.
Execution petition itself is closed. Then what has happened? This order has culminated into that final order, isn't it?
Please, my submission is, if subsequently filed any execution petition, liberty to the Milord, the petitioner filed Milord, the objection. Please,
As per the
because SLP is pending.
note placed before this court by the office, execution number 38 of 2016 is dismissed on 1/10/2021. petition is before this court questioning an interlocutory order. As the main execution petition itself is dismissed, nothing survives for consideration in this petition. Learned counsel for the petition submits that if any execution petition is moved, the liberty may be granted to question the same. Such a liberty is not required because when a new proceedings are initiated, it is always for the party to assail the same. Considering the fact that execution case number 38 of 2006 is dismissed on 1/10/2021, nothing survives for consideration in this petition, accordingly dismissed as instructions.
Obliged.
Yes,
Seal number 5,
this also 104 of 2013
is there be party?
is dismissed for default as per order dated 20. Look at the note, you will understand. Yes, 6.
Seal number 6,
Yes.
awaiting service.
It's awaiting notice.
Srikanti Patil,
IA number filed in pleading by advocate for petitioner. Why the memo is moved?
My lord, some urgency, my lord, implementing application may be allowed.
Huh?
Implementing application may be allowed, but my lord, it's awaiting notice for respond number 22, 23 and. So, my lord,
That I understand. What is the order to be passed?
please.
Why the memo is moved? What is happening? I'm not able to understand. Await service of notice and 14, 16, 22, 23, 24 are not served. And the advocate will move a memo. Who has moved the memo? Look at it. I'm really not able to understand. Huh?
Petitioner, I have moved the memo.
Why?
Some urgency.
What the court has to do when no notice is not served? You should verify the status. Is it not, Mr. Counsel?
Apologize, my lord. Apologize.
Because it has become a routine practice, moving the memos. Memos are moved, court is moved when there is an urgency. Here it has become a routine practice to move the memos.
Please, apologize.
List after service of notice. No, in all the memos, urgency, what is the reason for moving the memo shall be mentioned. In any of the memos, if it is not mentioned, even today's memos also, again keep it outside the court. Let them take the memos, give the urgency, look at the urgency, then only it will be listed. Otherwise, memos for the sake of moving will not be entertained. Yes.
Seal number 7, AP Hegde,
Yes.
Lordship, since
Nagaraj
last
Appanam.
1 year, Lordship, not taking step, Lordship.
Let's see.
Suit is of the year 2013, Lordship.
2013.
Please, Lordship.
None appears for the petitioner. List this matter for dismissal tomorrow.
tomorrow, 28, 29.
Yes.
Seal number 8,
For the
Very good.
petitioner, Maladi, office objection is Maladi.
No, in a 2021 writ petition, why office objections are coming now?
Not produced the legible copy, that's make submission, Maladi.
What is your submission?
Submission, Maladi, or that copy is legible, Maladi, that is my submission. But in the meanwhile, Maladi, settlement going on between the parties.
Let me and look at it.
Please.
Where are those objections? Let's see. Legible copy of Annexure C to be filed. Where is Annexure C?
Annexure C is page 14, Maladi,
Page number?
page number 14. So, next page 52, Maladi,
Page?
52. Judgment and decree of RA Maladi, 30 of 2011.
Even for a legible copy also, council submission. Because these are all not properly done. That's why they asked
I will
you.
put 1 week, Maladi, I will.
The office objections or sustain the petition shall comply with the office objections within a week.
Interim order, maybe.
Wherever interim order is there, it will be extended.
Please.
Serial number 9, Sharana Basava, Angadi, Amit,
Please.
Thirty.
Amendment for 2023, not even for the first time the process is paid.
No, respondent number 1 and 2 is the government, my lords.
Huh?
Respondent number 1 and 2 is the government. R1 is the SLA and R2 is the deputy commissioner.
Yes. Who takes notice for R1 and R2? AGA takes notice for R1 and R2. Yes, let's this matter.
My lord, it is land
A
acquisition.
number 2 of 25 is filed seeking to withdraw the amount.
Please. And we had filed the impleading, my lord. Why? Because the respondent number 3 has been dead, my lord. The LRs have been impleaded, my lord.
They are not brought on record as of now.
No, my lord. No, the notices were not been served.
No. First you need to file an application to implead. Then you need to file an application for withdrawing the amount.
No, my lord. Earlier only I had filed the impleading. Afterwards,
There is an impleading application.
1 of 25, my lord. Serial
Number
number
1 of
4.
2025 is filed to implead the proposed R4A to R4C
Please, ma'am.
as LRs of deceased R4.
R4. And I know 2 of 25 is withdrawal of amount, my lords.
Is returned with bringing LR's application to be filed.
No, my lord. What happened means the notices were not served in the MFS, my lord. We got to know that the appeal was filed in the execution. After the knowing that we had filed the impleading, my lords.
What did you do with the office objection?
Please, ma'am.
Office has raised an objection and returned your IA. The office objection on IA number 1 of 2025 shall be complied with within a week. After the objections are complied, list the matter. List the IA for withdrawal of the amount and the implead petition.
Delay
Yes,
may
10.
be condoned. Delay may be condoned. IA2 for 2023 delay.
Yes, no, the government also has come on record. They also have to come on record. How can we
Please,
condone the
please,
delay?
please.
Yes, 10.
Similar
Number
matter. Similar
Same
matter, my
same
lord.
minutes. R1 and R2.
Same.
Same.
Yes, 11.
Please.
Serial number 11,
Much.
PC Chaklam.
A memo is filed stating that the R4 died.
R14 is report.
Then comes the petitioner shall take steps to implead the LRs of the deceased. List this matter. The same shall be done within a period of 3 weeks
3 weeks.
Please.
Serial number 12,
in all the matters. Look at it in terms of residence. Is 12.
In view of dismissal of RA,
Hisham Kulkarni.
the concerned writ petition has become infructuous. I have already filed certified copy of RA judgment and along with the memo for dismissal, my lord.
RA is dismissed.
Yes, my lord.
Where is that?
32.
This is arising out of RA.
Yes, my lord. This writ petition has become infructuous.
Complaint is hereby dismissed. No, where is the impugned order in this?
My lord,
Page number?
RA number 32 of 2022.
To quash the impugned order dated 5/10/2023 passed by the in RA number
32 of
2022. Then there is no representation on behalf of the petitioner. Then counsel appearing for the respondent submits that the present petition is filed questioning an order that's passed in RA number 12 of 2022 dated 5/10/2023. And the appellate court by order dated 3rd January 2026 had disposed the final orders are passed in RA number 12 of 2022, hence nothing survives for consideration in this writ petition. Accordingly, considering the fact that the RA itself is disposed of, the writ petition has nothing survives for consideration. Accordingly, dismissed as infructuous.
in fact.
Date, my lord.
Serial number 13,
It's serial number 13. I'm for the petitioner, my lord. I'm
Yes.
seeking 2 weeks
Tell me where is
accommodation
it?
to file the objections, my lord.
my lord.
I'm appearing for respondent.
Yes,
Serial number,
the
I'm
office
for the
objection
petitioner.
with regard to at serial number 7 shall be complied within a
Please.
week,
My lord,
Please,
or else
please.
the writ petition shall stand dismissed.
I'm appearing for respondent, my lord.
I will
I need
comply.
some directions from the petitioners. On 30th, my daughter's birthday, on the interim impugnal order, thus put some conditions and allowed. In condition number 3 has been stated by this honorable court, passed in interim order, but there is a condition that I may be permitted to meet her on birthday, my lord. On 30th one, my daughter's birthday. My lords, they are not given any address of that school, and even they have changed the address. But now the petitioner wife is got second marriage, and she
No,
is
no, no.
settled with her second husband.
Where is the petitioner residing?
No, petitioner is residing in Bangalore, my lord. I have stated in my petition also. She is admitted to the Bangalore school. I have given the particulars.
They have not given any particulars about the school.
With due respect, my lord, the respondent has not paid the maintenance awarded by this honorable court, confirmed by the appeals court till
Let us
this.
not go into all these issues.
Please, madam.
First issue, the court has stated only a particular condition that is laid
Yes,
down in
yes,
the
yes,
order.
yes.
Other conditions are not interfered with.
Till today, he has
You have
not
come to
complied. Even after the order passed by the trial court, he has not seen the face of the child till this date. That is recorded by the trial. I will produce the order sheet.
Now he wants to see the child. Where
He
is the
settled-
child?
Yes, we have no objection. He is at a liberty to see the child. I have stated
There
in
are
the
photographs.
that
Made.
Don't make it so complicated. All that not required.
Yes, madam.
Yes.
Yes.
Where is the address?
I will give the address. He is admitted to the Bangalore school. I have stated in the petition. I will provide the address.
Petitioner shall furnish
Please,
the
madam.
details where the petitioner along with the minor is residing.
Yes.
List this matter on, when is the birthday?
One more sufficient,
Yeah,
madam.
tomorrow.
The
This is
respondent
matter.
will be directed to pay the maintenance of the child as well as the
Not
wife.
already have-
Today he has not paid the.
Tomorrow.
Please,
Yes.
madam. I am told that more than 8 lakh rupees is pending.
But we will see. First of all,
Please.
furnish the address.
Please.
Still number 14.
Please, madam.
But I pay for petition, Lord. Pray for 2 weeks time, Lord. I want to produce some documents on record because the clear case of contempt.
This memo for disposal.
Yes,
filed
Lord,
by-
that I filed.
Entry model.
The EP is filed. In the EP, my lord, IA for impleading was filed by the petitioner. That was rejected. That order is challenged before your lordship. Now, my lord, EP is closed.
When?
My lord, on my lord, 3/1/2026, I filed the order sheet along with my memo. Lord, therefore, petition become infructuous.
The present petition is filed.
No, not so much. Kindly, because the interim order is granted, saying the further producing the execution proceedings, the court says, since the stay is granted, execution is closed for the time being. That is on that basis they are want to dispose of the petition. Interim order is there. There is stay is granted, but saying that further producing the execution. Because of the interim order, the execution is closed for the time being.
In fact, my lord, the
It has to
petitioner.
be heard. I produced some documents. My lord, on 25/6/2025, interim order.
This matter, on Tuesday, we'll hear the matter.
Please.
2 weeks, some documents are required. I applied for it, but kindly grant
Not
2 weeks.
required. In fact, they are already aware the alternative remedy
Clear
by
case of
filing suit.
contempt. It is clear case of contempt by the respondent to enter incident.
They will decide it on Tuesday, listed on Tuesday.
Please.
Interim order earlier granted is extended.
Third, fifth. Seal number 15. Srimati P.S. Jadhav.
I moved this matter because of the interim order is granted before the trial court 25,000 per month. She is a B graduate, my lord, and she is
No.
suppressing the.
Notice is await notice of service of notice on the respondent.
In-
What do you expect the court on this memo?
Because of interim prayer, stay is required, my lord. Because of stay is very much required. I prayed for interim prayer, my lord. Wherein
What stay is required?
because of the family court has granted 25,000 per month to maintenance to the respondent wife hearing, and petitioner here same is challenged before this honorable court, my lord. And last occasion, my lord. Last occasion, my lord, my name is not printed on the cause list, my lord. Hence, I am not appealed before the court. And
Why your name will not be printed? When it has come? It has come on 13/9/2024, 11/2024.
please, my lordship.
No, when what is not granted on that day, we will not grant it today. List after service of notice.
List after service of. Seal number 16.
I represent the petitioner, Lord.
Yes.
My colleague tells me all the office objections have been complied with. And my lord, I have moved the matter requesting for early hearing. A single parent mother, my lord, seeking to give her name to her child, that is refused by the respondent number 4 municipal corporation.
What is that? Where is that,
Lord.
where is that order?
Lord, the endorsement is issued at Annexure A.
Page number 11, my lords.
Page number 11.
11, my lords.
Yes.
Yes.
Now they cite the provisions of a statute saying that there cannot be any changes in the birth certificate. I have relied on 2 judgments of the apex court as well as some other judgments. Lord, they state that it's constitutional right of a single parent to give her name after separation from her husband. And the decree for divorce also has a stipulation saying that she is at liberty to change the name of the son, the minor. Now that governments have launched several schemes and cards, Lord, the records need to be put straight.
What, sir? In the divorce,
No, but in the divorce proceedings, when a particular clause is there mentioning it, you're just implementing it.
they ought to have considered.
You're just implementing it. Do it. Where is that clause in the divorce decree?
Kindly come to page number 15, my lord.
15.
In clause 8E,
What is the age of the child now?
10 years. And the Aadhaar card has already been updated, and that is the memo that I had filed, that the UIDAI has already, I'm sorry.
No, the child has already joined in the school.
Yes.
What are the under which provisions there when the name has to be changed? What is the procedure to be followed?
Now, my lord,
No doubt,
but
they have a right,
yes.
but it has to be implemented in the manner known to law.
Yes, my lord, I can demonstrate because it is listed in orders list. If it could be taken upon 3rd, my lord, I am also down with viral fever.
Yes, 3rd.
Please.
Obliged.
Number 17. Saurabh.
My lord,
Vajayapati.
there is no relief against the respondent 5. Respondent 5 is the owner of the insured vehicle. And
Take that.
kindly be dispensed the notice. And further,
In dispensation of notice to R5.
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 5.
Memo is taken on
My
record.
lord,
Notice is dispensed with. Yes.
Submission, my lord. The matter is posted for judgment that we are seeking for interim stay.
Are these the same cases the other day came?
No, my lord. This is where the petitioner filed a petition under section 166 that was dismissed. They preferred the appeal before the division bench. Division bench and before the pending of the appeal, they filed the application under order 6 to 17 to conversion of the petition 162 to 163A. And that, my lord, High Court has observed that liberty has given to file the application before the tribunal. Tribunal misunderstood to consider that the petition application is allowed and he has passed the order. May kindly produce the, my lord, internal page number 87. 26, last paragraph.
87.
86, last paragraph. On perusal of the order of the Honorable High Court, it appears that the Lordship Honorable High Court has pleased to direct this court to permit the claimants to convert his petition as one
What
under.
is your objection for this conversion?
Once the petition dismissed under section 166, that cannot be converted to 163 or 164 as per the Supreme Court. What Deepal.
So that order is set aside.
Which one?
That order is set aside by the division bench.
Division bench.
Let's see the division bench's order. Please
That
come
please.
to that.
My lord, page number 75, my lord. May I read second paragraph? Learner counsel for the appellant would therefore submit that a claim petition would have been filed under section 163 of the Act, where in terms of the subsection 2 of the said provision, claimants are not required to plead or establish that the death of permanent disability in respect of which the claim has been made was due to any wrongful negligence or default of the owner of the vehicle. Except in submission of the learned counsel for the appellant, the miscellaneous first appeal stand disposed of, reserve is liberty to petitioner to convert the claim petition one under the section 163 of the unamended act, and the appeal stand remitted accordingly.
This is a
That
positive
then being
direction.
we have filed the being spoken and the subsequent para 77 in the beings of second paragraph. Learner counsel for the respondent would also submit that while opportunity is granted to appellant to seek the conversion of the claim petition under the section 166 or to 164 of the amendment, liberty should be given to respondent to raise the objection. And then, my lord, that accordingly following changes, the appellant are permitted to convert the claim petition under section 160 new act of the amendment ME Act. Liberty also given to the respondent to raise an
What is the
objection.
purpose of remanding the matter?
That is not to be remanded, my lord. My submission is that once the petition is dismissed.
Why you should have agitated this before this court division bench only, that it is not maintainable.
Yeah, we have made a file application, but Honorable High Court has accepted our version, but not to pass that dismissed, but liberty is given to file the application before the tribunal. And then, my lord, the finding only this, my lord, the judicial has not applicable his mind. That is the para 87, my lord, last para.
What will they do? This is how confusing this order is.
No, my lord, that liberty is given me to file the objection. That my objection has to be considered and pass the order.
No, where will this earlier observation will go? In the for being spoken, they have not clarified in that way. It has to be, they've said that it is, the court shall take it into consideration is the first order.
No, first order, not first order, madam. They file application for amendment of the claim petition. That claim petition, matter was remanded to the tribunal to consider the fresh application, and liberty is given us to also agitate the objection to that petition. My submission, my lord, that
What I'm saying is, unless until this sentence goes, accepting the submission of the land counsel for the appellant, the miscellaneous first appeal stands disposed of,
Please.
reserving liberty to the petitioner to convert the claim petition, so and so.
this is
The learned judge is directed to permit the claimant to convert.
my lord, that will be a clarification. We have moved the being spoken. That in being
This
spoken.
is all futile exercise, wasting the court's, trial court's time also. When what is not, whatever, if you say it is not permissible to convert, the same could have been argued before this court. It's a legal issue, not that it is a
No, my
question
lord.
of fact that has to be decided by the court.
The finding of this, my lord, that we may clarify this in page number 87, my lord. 87, it is observation, my lord, that further it is significant to note here that the Honorable High Court has ordered a director to convert the court. That is
What is
incorrect.
the judgment? What is the judgment of the apex court? You that in,
My lord, I just clarify this judgment, my lord.
no, there is a judgment of the apex court which says that once you have stated that your income is above 40,000.
Yes, sir.
Later you cannot be permitted to amend it.
Deepal, Girish Bhai, Soni and others.
Girish by the Sony.
Yes, ma'am.
Give that.
Please, that's been referred in our judgment, the reported judgment, my lord. Para 20,
Give that.
para 22.
All are served. All the respondents are served.
Yes, ma'am.
The present writ petition is filed.
Mr. President, addition.
Agreed with the orders passed in I number 1 under order 6 rule 17 read with section 151 CPC, whereby the court had allowed the said application, observing that the Honorable High Court was pleased to direct the court to permit the claimants to convert the petition as one under section 163A of the MB Act. The facts of the case are, initially the petition has been filed under section 166 of the MB Act, but it came to be dismissed. Hence, the petitioners have approached the High Court in MFA number 103609 of 2023. An order was passed initially permitting them to amend the same. However, on a being spoken to that's moved by the corporation, by the insurance company, the court had modified the said order and observed that the respondent, the appellant, the petitioner insurance company is at liberty to raise their objections. Next, when counsel appearing for the petitioner submits that when this court has granted permission to the petitioner, to the petitioner insurance company to raise objections, the court, without considering the aspect, has observed that there is a direction from the High Court to amend the cause title. It is submitted that
Claim petition. Claim petition.
that to amend the claim petition. It is submitted that the court has failed to understand the order that is passed by the High Court, and there is no such direction. The court ought to have considered the objections that are filed by the insurance company. He had relied on the judgment of the apex court in Deepal Girishbhai Soni and others versus United India Insurance Company.
Please.
And submits that once a petition that if a petition is filed under 163A of the MB Act, then a petition under section 166 of the MB Act will not be maintainable and vice versa. It is submitted that in the light of the law laid down, the present the court ought not to have allowed the application that's filed under Order 6, Rule 17. It is submitted that the claimants are not entitled to amend the same, and the court ought to have considered it on the merits of it. Next para. Though notices are served on the respondent, no wakalat is filed. Next. The observation of the court that the High Court has directed the trial court, had permitted the petition and directed the court to accept the amendment or allow the amendment petition is contrary to the order that is passed with the division bench of this court. The division bench of this court, though initially had passed such an order, later on an application on a memo filed by them for being spoken to, in that it is clarified that the objections can be filed by the respondent and the same has to be considered. It is submitted that it is a submission of the learned counsel for the petitioner that the matter is posted for judgment. In the considered opinion of this court, the court ought to have considered the same on the merits of it by giving opportunity to both the parties. Accordingly, this court is passing the following order. The order dated so and so is set aside and the matter is remanded back to the trial court. The trial, number one. Number two, the trial court shall consider the objections raised by the respondent and also giving a fair opportunity to the petitioner shall pass appropriate orders within a period of 4 weeks from the date of receipt of the copy of the order accordingly.
Please.
Seal number 18, Tuhaske Osmani. Venkatesham Harvey.
My lords, I'm seeking withdrawal of this petition with liberty to file a fresh petition for the reason that the prayer as sought for has become partially infructuous, my lord. That the name of the respond number 7 association has again been renamed and there have been subsequent amendments done to the bylaws. So they also need to be challenged, my lords, since there is a change in the constitution of the association. So subsequent developments need to be challenged. So with the liberty, I want to withdraw this petition, my lords, to challenge the subsequent new developments.
The memo is filed seeking to withdraw the petition, wherein it is stated that after filing of the present petition and after issuance of the notices by order dated 23/12/2025, the name of the respondent number 7 association has been changed, and the committee for the administration functioning of the respondent number 7 association has been changed pursuant to the amendment of the bylaws. Hence, the petitioner wants to file a comprehensive writ petition questioning the subsequent changes. Hence, the present memo is filed to withdraw the writ petition with the liberty. The memo is taken on record and the writ petition is dismissed with as withdrawn with the liberty to file a fresh petition.
Seal number 19. Hemant Kumar L. Havargi.
Lordship,
What about this?
Lordship, I will file service notice. Service of notice, my lordship. I have served the hand summons to the respondent, my
Take
lordship.
that.
My lordship, kindly permitted to deposit the 5 lakhs amount, my lordship, before this honorable court, my lordship. Because of, my lordship, the petitioner have made an effort before the trial court, my lordship. Trial court has not taken, my lordship.
Huh?
Trial court has not taken. There is no specific order, my lordship.
No,
Kindly permitted to deposit. Today itself, my lordship, bring the,
not that. What did it say? He has accepted. Who is the name of, what is the name of the advocate?
lordship.
The advocate. To whom you have served the memo?
Before the trial court, my lordship.
To the trial court only. What is his name?
Lordship, our assets, I don't, I will not get
That
them.
is what is the memo.
We are appearing in the, before the trial court, my lordship.
Name should be there.
I will,
that
I will,
record
I will
on
get the,
served.
I will get the instruction.
File a fresh memo. This is matter tomorrow.
Oh, please, kindly permitted to deposit the amount before this honorable court. As per,
Petition shall deposit the amount of 5 lakhs before this court by today.
please,
Today
please,
itself.
please.
Yes.
lordship.
Yes.
Interim order may be extended.
Interim order is extended. List this matter tomorrow.
Oh, please.
Seal number 20. KL Patil, SCGP.
The parties have entered your memorandum of agreement for the mediation center, and the same is placed before the court. Considering the same, in the light of the agreement between the parties, the petition is disposed of. The copy of this shall form part and parcel of this order. Yes.
Seal number 21. Girish.
I appear for the petitioner.
Yes.
I appear for the petitioner's counsel, my lord.
Yes, yes, yes.
In a section 70 dispute with regard to whether they have voting rights, etc., an interim order is passed staying the holding of office bearers election. Normally, even this court under 226 elections are not stayed for such reasons, my lord.
See, where is that
Office
order?
bearer- Please, my lord.
Page 58, annexure J, my lord, sir.
58.
Yes, my lord.
Please, what are your instructions?
Your Lordship, today I will, officer will come, Your Lordship, today I will get instructions. And
Already notice is ordered to you?
For a
Please,
notice to the contesting respondents 9 to 12, this honorable court had directed to take hand summons. I have served and my lord filed acknowledgement also.
You have served the notice.
Served the hand summons issued by this honorable.
Where is that?
I have filed acknowledgement also. That is also noted in the orders.
It is already noted.
It is put up in the cost list.
When was the order passed for hand summons?
Previous order, my lords, was passed
14-1.
on 14/1/2026.
41/2026, an order was passed permitting the petitioner to take hand summons. And as per the same, it is submitted that the petitioner has taken the hand summons and a memo in that regard is filed. In respect of respondents,
9 to 12. They are the contesting respondents, my lord.
9 to 12.
Yes, ma'am. It was ordered to be served on the council appearing for them before the DRCS.
The council,
Please.
council's name,
Yes, ma'am. He is one Mr.
it is served on
Shashidhar Havargi.
Sashidhar
Havargi.
Havagi appearing for the respondents before the trial court.
contesting,
The-
contesting respondents.
For the contesting respondents. The same is taken on record. Print the name of that advocate in the cause list. The HCGP shall get instructions by tomorrow. This is matter tomorrow.
Please, Your Lordship.
Please. Maybe in the my lord, it may be listed in the same stage, my lord. Otherwise, they usually send it in B group, my lord, sir.
Yes, it's 21.
Please.
22. Not as Bichkatti, SCGP.
In these matters, Your Lordship,
Please, my lord. My
List
lord,
after service of
my lord,
notice.
please, my lord, guarantors challenging the auction come sale notice, my lord.
Notice is awaited.
Tomorrow it's posted for auction come sale. The only ground, my lord, I'm urging is,
No, if an interim order is not granted and it is notice is ordered means it's not a case for interim order, isn't it?
my lord, only ground is, my lord, one property in the three petitions is come under the acquisition proceedings.
I have only ordered notice.
Please, my lord,
I have only ordered notice, please.
please. Tomorrow it's auction, my petition will turn infructuous.
So what are the reasons to interfere?
No, only ground is, my property is come under the acquisition proceedings. Out of three petitions, my lord, one property is under the acquisition proceedings. So the value of the property as per the government award itself is much more than what has been valued by the bank.
Who has put this property to auction?
No, the respondent number 3, my lord.
3, Your Lordship.
One
Notice
property
has
is the
issued-
neighboring property to the acquisition proceedings. The second petition, my lord, the property in the second petition is under the acquisition proceedings. The government award itself is more, it's per acre 40 lakhs. So, but they have valued it quite much lesser than that, my lord. So the total put together, my lord, three petitions, it will come to around 7 crores. But if the value of the property as per the award itself, my lord, consent award, 40 lakhs itself, my lord, it will come to around 18 crores, my lord.
What is your amount? What is the outstanding amount that
My
has
lord,
to
the
pay
first-
for you?
For the first petition, my lord, the outstanding amount, my lord, is around 3 crores 71 lakhs. My lord, but the value of the property
So
will
first we
come.
will see about only the first petition.
Please, my lord.
First petition, what is the amount due?
Please. Yes, at page number 10, my lord.
Yes,
Yeah, 3 lakhs 71, 3 crores 71 lakhs, my lord.
3 crore, 3 crore?
3 crores 71 lakhs, 74,508, my lord. So they have valued it at 8 crores, my lord. 80 lakhs, sorry. My lord, the neighboring property, my lord, are under the acquisition at page 16, my lord.
So
16.
please tell which property is mortgaged? What is the extent of the property?
Lord, the extent of the property is at page 10 itself, my lord. Page 10, my lord. 18 acres, 15 guntas.
18 acres, 15
15
guntas.
guntas, my lord.
According to them, what is the rate fixed by them?
My lord, at page 16, my lord. This is
How
the
much
neighbor.
is it?
My lord, 40 lakhs per acre. This is the neighboring property to the acquisition proceedings. 40 lakhs, page 16.
Fixed by the government, Your Lord.
Fixed by the government. Page number 16.
According to you, what is wrong with this?
My lord, my property is, they are valuing it as at 80 lakhs. Whereas it is worth of 8 crores because it is 18 acres. Per acre 40 lakhs, my lord. So it's much quite higher than what has been fixed by the society, my lord.
No, before putting the property to auction under the act, you are not entitled for any notice.
Yes, the notice has been issued at A and B, my lord.
Hmm?
They have issued the notice at A and,
That.
this A and B, my lord, at notice 11, page number 11 is the notice.
Hmm.
Auction notice,
4th December 2025.
please, my lord.
Hmm. What you're supposed to do after that?
My lord, in the first week of the March, my lord, first week of the March, in the budget itself, my lord, we are getting the amount likely because 19-1 is also been, the file has been sent for the 19-1, my lord, almost a faggot of the land
What
acquisition.
do you say about this? When the adjacent land,
Your Lordship, we are not disputing that. At present, I am taking notice for respondent number 1, Your Lordship. We are not disputing that property or value of the property is higher side, Your Lordship. But as per the mortgage, already property is mortgage between the bank, Your Lordship.
no,
And
when
it
you are,
was,
when you are auctioning the land, you have to, what is the purpose of auctioning it at much lesser price? Who is going to be benefited out of it?
he has to arrange that amount also, Your Lordship, which he has to deposit the amount, Your Lordship. If it
Forget
is,
about him.
please, Your Lordship.
You are conducting the auction. When you're fixing a price for a particular thing, you have to fix it as per your, there should be a valuation done. As per that now, if it is, property is 80 lakhs
Please,
and
Your
it is 18 acres, how much the amount will come? And if any
More
excess he is
than-
entitled to,
Please,
he's
Your
not.
Lordship. Please, Your
So
Lordship.
he is affected by that. You need to get specific instructions. This is matter tomorrow. Or else I will set aside
Respond
that.
number 1 only I will take, Your Lordship. Only respond number 1, Your Lordship, I have
Who
taken.
is conducting the auction?
Conducting, respond number 3, Your Lordship.
This one number?
3.
3 million.
3 is who?
3 manager society, my lord, that's a cooperative bank.
Respond number 2 to 3.
Permitted to take out hand summons?
Please.
2 to 4,
on
Your
this
Lordship. Notice was already issued.
and shall file a memo to that effect. If you file the memo, it will come immediately.
Please.
Once the memo is filed, it's the matter.
This tomorrow at 1 o'clock it is scheduled, my lord. So top of the list.
But what are you doing till now? You, December notification is issued, you don't come before the court.
The moment.
And you don't even ask for hand summons when the matter comes up last occasion. You keep quiet for issuance of notice. Or the court can help. No, we can't take whatever you say as a gospel truth. We need to hear the respondent
Please.
also.
No, my lord, only request is tomorrow top of the list because it's scheduled for 1 o'clock, madam. That's why. Morning.
But 4th, 5th December, you waited till this end of January.
Please, the moment.
We can't, without hearing the other side, that is
Please.
not for the court to pass orders of that nature. Even if the auction is held, we can set it, if the procedure is bad, we can set aside.
Please.
Yes, next.
Please.
Seal number 23. R.M. Hiremat.
My lords, the office has raised an objection regarding maintainability, my lords. My humble submission is pursuant to the injunction order which was passed in the favor of plaintiff. He filed an application seeking police protection, my lords. That application was filed under wrong provision. He has filed an application under Order 39 Rule 2A. In fact, my lords, Order 39 Rule 2A, it provides for disobedience, a punishment for disobedience and attachment of property when there is breach of injunction orders, my lords. Now, my lords, any orders passed under that provision, my lords, is appealable, my lords. Now, in this case, my lords, since the relief which was sought was the police protection, the only remedy that is available for me is to invoke Article 226 and file a writ petition, my lords.
Office objection with regard to maintainability is overruled. Yes.
Please, my lords. My lords, the suit for declaration and injunction, my lords. The plaintiff claims that he is the owner of the suit property. He filed an application under Order 39 Rule 1 and 2. That was granted after fully hearing both the parties, my lords.
The appeal is preferred against.
It is preferred, my lords. Miscellaneous appeal is
Order
pending.
is granted in that.
No, my lord, since caveat was filed and both the parties consented to argue the matter on merits only, no interim order was granted, my lords. During pendency of that miscellaneous appeal, my lords, he moves an application for police protection, my lords. Now, my lords, my humble submission is since the TI order has not attained finality, the application filed is a premature application, my lords. Please, my lords, that's what the coordinate bench of this honorable court has stated in the guidelines.
No, when the appellate court does not grant an interim order, why it becomes premature?
Please, my lords, since the injunction has
The
not.
whole purpose of filing an appeal and an IA,
Please.
seeking the whatever interim order is that
Please.
purpose.
Please, my lords. My lords, they are pursuing.
Let's see this order. What
Please,
is
my
it
lords.
say?
Page number 13, my lords. The
Page number?
guidelines are framed, my lords. The factors which have to be considered while granting police protection has been envisaged, my lords.
Hmm.
In that paragraph F, my lords.
Paragraph number?
F. A, B, C, D, E, F, my lords. Page number 13.
Page number 13.
13,
Yes.
my lords.
Yes,
Please.
read.
The trial court shall also take note of the fact that whether the temporary injunction order granted has attained finality and the application needs consideration even during the pendency of the appeal against the order of temporary injunction granted by the trial court by recording the reasons for such urgency or otherwise. So only if the plaintiff make out a specific case which falls under these exceptions, my lords, in under such exceptional cases, police protection can be ordered. In the present case, my lords, plaintiff is not at all in possession of the property. He himself has.
We cannot,
Please.
you cannot say that.
Please, my lords.
Because,
My lords, the
order of the
please,
trial court.
I don't disagree, my lords. Since the
You have to seek an interim order. You cannot say let this be pending forever.
Please.
And we'll
please,
argue the main
please,
matter.
we are. That's why, my lords, we have advanced the matter in the miscellaneous appeal and we are pursuing there. In the meanwhile, my lords, what has happened?
He has filed an application for police protection. Where did you say that both the parties have agreed for hearing the matter? Where did you say in your objections?
That has not been stated, my lords, but.
Then what is not being said, we can't, which doesn't form part of
Please.
any of the proceedings, we can't consider it.
Please, my
And
lords.
in my view, when an injunction order is granted
Please.
and the appellate court has not interfered with it,
Please, my lords.
the party in whose favor an injunction is there, he'll get a right to file an application and also seek implementation of the order. One order is passed. Do you think that it has to attain finality means it shall go to the Supreme Court? And
No,
there
no,
it
my
has
lords,
to
no,
get
no,
an,
my lords. I don't intend to make that submission, my lords. My lords, my humble submission is he himself moves an application before the Tahsildar. We have obtained that under RTI, my lords. I've produced it at Annexure M. He says that the defendants have encroached the property, they have taken possession of it, and he has requested the Tahsildar to hand over the possession, which itself shows that he is not in possession of the
It's a
property.
good case for you.
Please, my lords. But
in your appeal.
please, my lords.
Not for this
Now, my lords, by virtue of this injunction order and this police protection order, if he dispossesses, my lords, I'll be constrained to again institute a suit for possession, my lords. So there will be multiplicity of proceedings.
What can't be done directly, we can't do it indirectly.
Please.
Directly you have to go before the appeal and get an order, which you cannot successful, that can't be granted in the writ petition.
Please, my lords. This again injunction or this police protection order will be subject to what will be decided in the miscellaneous
Purpose of
appeal.
granting orders by the court. If
Please,
this is a
my
manner in which High Court starts interfering in an order where he has an order in his favor. That is not interfered by the appellate court.
Please, my lords.
No, the offshoot of that order, you will question it in a writ petition. And what you couldn't get in an appeal, now we are granting in a writ petition.
Now, even in that miscellaneous appeal, my lords, we have already addressed our arguments. They have been taking adjournments, my lords.
I will please make sure that the orders are passed in that.
Please, my lords. My one more humble submission is, my lords, since he is not having in possession of this property and this document which we have obtained under RTI, my lords, this
about to go
please,
into all
my lords,
that.
this we have obtained after passing of the injunction order, my lords. We were not aware about that.
That's why it's all the more of a case to agitate before the appellate court.
Please, my
where
lords.
your appeal is pending.
Please, my lords. Till then, my lords, at least status quo order, my lords, not to dispossess us because he himself admits that he is not in possession. Now again, we'll be constrained to institute a separate suit,
What
my
is the
lords.
stage of the MA? Can't you ask it before the court?
Please, we are pressed for that, my lords.
Have
The
you
app-
filed for an have you filed for an IA before
Please.
the court where injunction is pending?
Please, my lords.
And the court dismisses that, you could have come.
No,
in
that
and-
is not dismissed, my lords. That
At least you
application.
could have filed a writ petition in the facts and circumstances. There shall be a direction, a manuals to the court to dispose of it because otherwise I'll be put to hardship. That you
Please.
don't ask.
My lords, that miscellaneous appeal is filed recently, my lords. It was filed in the month of
I
November.
understand.
And moreover, my lords, my humble submission is, in the miscellaneous appeal, we have already addressed our arguments. The matter is pending for their reply, my lords. Only till the disposal of this miscellaneous appeal, my lords.
If you want, at the best, I can pass an order directing that court to expeditiously pass orders. But we can't pass orders like this.
Please, and also, my lords, the order, the impugned order, if it is that, if it's subjected to the result of the miscellaneous appeal, my lords, the purpose will be served.
What you have to ask the appellate court, you're asking the High Court. That's a problem. The present repetition.
My lords, that application is pending consideration, my lords.
That you should have done. When was the order passed? Injunction order is when passed.
My lords, injunction order is passed, my lords. On 29th of March, my lords, 2025.
29th of March 2025,
Please.
and you will file an appeal recently.
No, my lords. Appeal is filed immediately after vacation, my lords. That is,
Recently, when I said when was
please,
it
my lords.
filed?
We have argued the matter recently. It is posted for their reply now, my
So
lords.
an appeal that's filed in the month of March,
Please.
till this day, when no interim order is there, why
Please.
can't the respondent execute the order? That means you were not vigilant in prosecuting the matter.
Please, my lords, firstly, my lords, the application which is filed is under Order 39 Rule 2A. For a moment, my lords, may I read Order 39 Rule 2A, my lords?
I will not be deciding the legality or otherwise of an order that is pending before the appellate court.
Such application under Order 39 Rule,
This is a consequential order.
please.
Injunction that is granted is a consequential order.
Please.
Unless and until that order, basing on which this injunction is granted, is interfered with or altered,
Please.
he can't pass any order.
Please, my lords, under Order 39 Rule 2A, whenever an application is filed, my lords,
But again, you're asking,
inquiry,
you're
my
arguing
lords,
on the merits of the matter, Mr. Counsel. I can't hear that merits. Where is the impugned order? Page number.
please, my lords. Impugned order is at page number 71, my lords.
31.
71, my lords.
71.
The operative portion is from 72, my lords.
The
Order on
petition
IACT.
is filed, agreed with the orders passed on an IA seeking police protection by so-and-so, dated 8/1/2026. The defendant in the suit is the petitioner before this court. The respondent herein, who is the plaintiff, had filed a suit for
Declaration and injunction, my lords.
declaration and injunction. In that, he has filed an IA seeking interim injunction, and the court, by order dated 29/3/2025, has granted injunction. Thereafter, the present IA is filed seeking police protection. By order impugned, the court had granted, court had allowed the application and directed the police to provide police aid whenever the plaintiff seeks, by pointing out that defendant and their men are interfering with his peaceful possession and enjoyment of the suit scheduled property. Next para. Land counsel appearing for the petitioner, defendant submits that against the order of injunction, they have filed an appeal before the appellate court, and the same is pending consideration. Recently, they have argued the matter, and the matter is now it is posted for the reply of the respondent plaintiff. According to the petitioner, the granting of injunction itself is bad. He is not entitled for injunction as he is not in possession of the property. Further, the court, without considering all this, has granted injunction. He relies on an order passed in WP number 51712 of 2019, dated 7th July 2024, by a coordinate bench of this court, and submits that unless and until the injunction attains finality, the court, while granting the police protection, the court has to consider the said aspect. It is submitted that the injunction cannot be, the police protection ought not have been granted. And this court may say that that is subject to the final orders to be passed in the appeal that is pending before the appellate court. Next para. Having heard the learned counsel, the petitioner perused the material on a record. Undisputed facts in this case are: an order of injunction is passed on 29/3/2025. Against that, a miscellaneous appeal is filed by them before the appellate court. That's pending consideration. Admittedly, the petitioner has no interim order, and the injunction that is granted by the trial court is in force, and it is staring at the petitioner. At this stage, this court cannot go into the aspect whether the granting of injunction is right, wrong, and what is the legality that is committed by the court. This has to be decided by the court where the appeal is pending. When the injunction that is granted by the court is in force, which is not interfered by the appellate court, the respondent is always at liberty to move an application seeking enforcement of the said order. just because the the appeal is pending, that itself cannot be a ground for the court to say that the plaintiff is not entitled to make this application. The whole purpose of filing interlocutory applications is for this purpose. And unless and until the orders are interfered, there is no embargo. The court is always at liberty to grant police protection. In the considered opinion of this court, the trial court had rightly granted police protection, considering the fact that there is an injunction that is granted by the court as in force. Hence, this court do not find any reasons to interfere. However, as the appeal is pending from the last 1 year, the appellate court, you see that number in so and so, is directed to dispose of the matter as expeditiously as possible within a period of 1 month from the date of receipt of the copy of the order. Yes.
Hearing on IS, seal number 24. Taker what I am Nagnuri, DL Lakhan, Girish Dharwad.
This petition, my lords, respondent number 6 had died, had filed LR application, my lords. No instruction to.
Notice has to go. I number? I number,
Number 1
on
to
I
3 of
number
22.
1, 2 and 3, notice to the respondents.
Connected matter, it is the respondent number 5. Parties are same.
On this also, I number 1, 2, 3, notice to the issue notice.
May I request your lordship, any date may kindly be fixed, my lord. Date may kindly be fixed, my lord.
Issue notice to the respondents. List is
Tenable by
matter.
either 10th or 12th, my lord. Either 10th or 12th. Only request is that small.
How can the notice be served by that time?
No, the point is that, in fact, I was expecting my brother to take notice because he is already appearing on behalf of the other respondents, contesting respondents.
18th of February.
Please.
Yes.
Please.
Seal number 25. Gangadhar S. Huskeri.
Lords, insurance company appeal.
Why should we entertain insurance company's appeal?
Please, lords, dismiss for non-prosecution, lords.
Yes. When was it dismissed for non-prosecution? This is a MFA of 2022.
Please, lords.
Dismissed when?
Lords, on 2/12/24, lords.
And you file an application. I can understand a private
Please,
party.
that's-
Insurance company
Please,
and doing it, why should we entertain the appeal?
Lords, conditions imposed, lords, within 2 days, lords, comply with office objections, lords.
What you have not done about 4 years back, why would you do it now?
Lords, by oversight, lords, it is not.
No oversight for the insurance company. Insurance company doesn't require that kind of any indulgence from the court.
During the course of the day, will comply,
I'll
lords.
impose cost of 10,000 on the insurance company for this delay. First of all, you will file frivolous appeals. And then on the second, you will file when was it dismissed? MFA of 2022. When was the order passed?
2/12/24.
October 2020 is the impugned order. And
2/12/24, lords. 2/12/24, lords.
And from 2022 till 2024, you will not comply with the office objection. And finally, on 2nd December, it is dismissed for 2024 for non-prosecution.
During the course of the day, will comply with office objection, lords.
No, by complying the objections, you are not doing any favor to the court. The petitioner, the appellant is permitted to comply with office objections pending I number 1 of 26.
Please.
If the office objections are complete, list the matter. Yes, 26.
Please, ma'am.
Till number 26.
Please, Your Lordship, and for the respondent number 2.
Yes.
Therefore, the respondent number 1 in the connected
File
matter.
an IA for withdrawal of the amount.
My lord, I'm challenging the liability, my lord. As on date of accident, my lord, there is no permit, my lord. There is no fitness certificate, my lord. Second one, my lord, in MEC number 388, my lord.
Third party.
They are third party.
My lord, as on date of accident, there are two vehicles, my lord. There are the motorcycle and tourist vehicle, my lord. The disease, my lord, disease is also a contributor negligence. He had no DL and no policy, my lord.
That contention has not been
My lord,
taken before the tribunal. Your Lord.
Contention is taken.
How much? How much is the amount?
My lord, in death case, my lord, 11 lakh, my lord. Please.
MFA number 102426. How much is the amount?
11,41,000, my lord, in that case, my lord.
You have deposited entire amount.
No, my lord. In 50%, I think, my lord.
No, even if you fix a contributory negligence, it won't be more than 50%.
Please, please.
So let them deposit, withdraw that amount. Ultimately, you are entitled only for pay and recover.
And the contention has
A
been
number
squarely
1/25 is filed,
covered.
seeking withdrawal of the amount. Land counsel for the insurance company submits that. The insurance company is on the ground of liability and they are not entitled,
Ma'am.
considering the fact that this is an accident that are taken prior to the amendment. Hence, the respondents are at liberty to withdraw the amount. Next
both-
matter also same.
In the both appeals.
Then there is no IA in this.
No, I filed a memo for disposal only, Your Lordship. The claimants are the third party, Your Lordship. It's squarely covered by the Mukul Devan judgment, Your Lordship, sir.
You don't ask for withdrawal of money and the court has to grant. What is the logic in
Lordship,
that?
the only contention is that
Application, that only one matter,
the date may be fixed, Your Lordship, sir.
it's a case of death or injury.
Injury, Your Lordship, sir. It's a minor injury.
One is death, another one is the injury.
The only contention is that he's not possessing a valid driving license, Your Lordship, sir. Section 3 and 118 has also not been filed
What
against
he
them.
wants to say,
My
you're
lord.
not even letting him
My
to
lord,
speak.
earlier, my lord, it is a case of death, my lord, but the claimants are the only for the claim by the brother, my lord. He is not entitled to the dependency, my lord.
He's the alone rider.
He is not entitled to
No, it was filed by the father, my lord. In the during the pendency of the case, the father died, my lord. Thereafter, the brother has been implemented. my lord.
Even criminal has taken, my lord, 50%, my lord, but in his independent income is there, my lord.
All of you are arguing on the merits of the matter where the court is not
My
even.
lord, on merits of
What is this matter on Thursday?
please, my lord.
Yes,
May kindly disposal on Thursday.
court for disposal on Thursday.
Please.
It's very.
Number 27. Okay, Kayak
I appear for the appellant insurance company. We have
My lords, I
challenged
have
on the
filed
grounds
the
of
application for the withdrawal of the amount.
Yes.
appeal may be disposed of, my lords. It's only on and contributory negligence.
My lords, in the connected matters,
So
they have
that I
admitted the
hear,
liability.
It's a case of death or injury.
Death, my lords.
List on Thursday.
Yes.
5th February.
Yes, 28.
Silma 28. Gracious Fulmani.
I number 1/24 is filed to condone the delay of 633 days in filing. Condone.
Please
For
wait.
the same, for condition that they will not be entitled for interest.
Please.
Admit, force of filing. No, don't admit. Just force of
Correct.
filing, call for 3CR. 29.
Silma 29.
Please.
Rajshekhar Bihari, AG.
Filed application for implementing the proposed respondent is the beneficiary under the impugned order. my
I
lord.
number 1/26.
Please, ma'am.
Filed to improve, to implement proposed respondent 7 who is a beneficiary. Notice.
Please.
Issue notice.
Yes, 30.
Silma 30. Some Kalwat. Ingraj Mardi.
Appeal by the beneficiary, my lord. This is appeal by the beneficiary against the reference court award, wherein, my lord, reference application is itself is submitted beyond the 30 days in violation of
Can
sections.
you from 2024, this is pending for the stay, stay is not granted.
First time it is listed for after compliance of subsection, since Corpio also
There is no
not,
urgency for you for a stay.
Ingraj Mardi.
There is no urgency for you for the stay.
but now the execution petition is filed by the respondent. my lord.
Usual order. Usual order of stay with all. Yes, next 31.
Please.
Who take, you take notice for whom?
Respond number 1, your lordship.
One and
Deputy
two.
Commissioner.
HCG, one
Please. Deputy Commissioner only, your lordship.
1 and 2, my lord.
Please, your lordship.
1 and 2. One
and
is a
two,
DC and another one.
GP takes
SL.
notice for other respondents. Look at it for the other respondents. Notice to the other respondents. Yes, 32.
Till number 31.
31, yes.
31. Prashant S. Usmani.
My lords, I appear for the appellant.
Girish Yadwad.
Impugned order, my lords, is in Kannada. My lords, I'll file, my lords, translated copy.
MFA, CPC. matter.
CPC, my lords. A week's accommodation, my lords, I'll file the translated copy.
After a week. Yes,
Please.
32.
Till number 32.
Date may be given.
Hanumant Latu.
List the matter on 10th.
Great.
It's 32.
10th February. Till number 32.
Notice.
Hanumant Latu. Issue notice. Till number 33.
Notice.
Ainapur. Issue notice. Till number 34.
Insurance company has challenged the liability in this case.
On the ground?
On the ground, my lord, there are two vehicles involved in this case, my lord. That petitioner is a rider of the our insured vehicle. He was contributed for 30%. That we cannot be compensated to him because for that he himself is a tort feeser.
It's a case of death.
No, injury.
How much is granted?
My lord, he was awarded 16 lakh 6,000. That 30% contributed on us 4 lakh 81,000. He was compensated 12 lakh rupees from the national insurance company. To that extent, we are not liable to compensate. We have challenged entire liability in this case.
But your liability is 30%.
No. He was a tort feeser.
So
The claim petition itself is not maintainable against me.
that is true. What did the court say? Court has 30% is fixed on whom?
Against the petitioner.
70% on you.
No, 70% against the national insurance company. They have compensated. They have accepted their liability and they paid. To extent of my liability, I am not, the petition against this petitioner is against me is not maintainable. Because he himself is a step into shoes of.
Able to pay that.
No, we have no liability to pay company. Here the court is awarded 30.
Asking the facts.
Here in the
Tell
trial,
me before this court when there is no liability on you.
30% is liability.
What I am asking, that 30% you have to bear you have to pay.
Yes. As per the trial court verdict.
So now only for that 30, as far as you only concerned, you
Yes.
stay.
Yes.
The petitioner, counsel appearing for the insurance company submits that the court has held that there is 30% contributory negligence on the part of the driver.
Petitioner himself is a rider.
I'm not able to understand what are this.
No, petitioner has filed a claim petition against the two insurance company, where one company where he was driving proceeding on the two-wheeler that was insured with our insurance company. He was not a third party to our insured company, but and he also have not claim against this appellant. However, the contributory fastener fixed on the petitioner, that 30% has been
It is submitted that the court has apportioned the contributory negligence at 30% on the claimant and 70% on the other insurance company. It is submitted that when the claimant himself is a tortfeasor and and he is not a third party and he stepped into the shoes of the owner, and when he is not a third party, the insurance company is not liable to pay the compensation. This aspect was not considered by the tribunal. Considering the same, there shall be stay of all further proceedings on the condition 50% 4 weeks and no permission for withdrawal.
My lord, 3 and 4 are the national insurance company may be directed to any panel advocate. 3 and 4 are
Dispensed with.
No, my lord, they are insurance company. They may be direct any panel advocate to take them.
Who are the panel counsels?
Kupilur, Soda, many are.
In your let notice go. Notice respond.
Sure.
Yes, sir.
Please.
Seal number 25. SS Poliwad.
My lord,
Vishwanath
appeal
Hegde.
filed by the insurance company challenging liability, my lord, as on date of accident for no permit and no fitness certificate, my lord.
And when was
The
date
injury
of
case,
accident?
please,
Date before amendment or after amendment?
before amendment.
It is submitted that as on the date of the accident, there is no fitness certificate and there is no permit. As such, the insurance company is not liable to pay the compensation. Consider the same, they should be 50%. Permission to withdraw.
Please, ma'am.
Yes, next, 36.
Seal number 36.
Your Lordship, delay of 137 days in filing the appeal, Your Lordship.
Warrant.
Notice. No, it is notice were issued, Your Lordship. It may be condoned. Served.
served?
Please, Your Lordship.
Number 1 of 2025 to condone the delay of 137 days, condone, admit final hearing. No condition in this.
Stay has been also granted. Stay was also granted.
Yes, admit final hearing TCR.
Seal number
That is also, Your Lordship.
number 37.
Notice.
Issue notice.
Lordship, appeal by insurance company, Lordship.
Ravi Hegde.
Lordship, kindly stay may be granted in 37, Lordship.
On what ground you are before the court?
Lordship, appeal on liability, Lordship. As on the date of the accident, Lordship, driver was not having a valid driving license, Lordship.
Before amendment.
It is after amendment, Lordship.
It's submitted that the driver is not having a valid driving license to drive the vehicle. and the accident had taken place after the amendment, and the insurance company is not liable to pay the compensation. Considering the same, they shall be stay 50%, no permission to withdraw. Yes, 38.
Seal number
Also
38.
prepare for petition, Lord. I filed an application incidentally for seeking interim prayer on the background of this. My Lord, on merits, my Lord, I have only 3 points. One is, my Lord, I have challenged.
One, let me understand what is the
Yes.
writ petition.
Yes,
what
my
is the
Lord,
prayer?
I will narrate
No,
facts in
before
brief.
we can come to the prayer.
It is annexure D.
Who are the respondents?
Yes. My Lord, the facts in brief, may I explain, my Lord, in 2 minutes. Petitioner is a company, my Lord, which was started in 1955 and employing around 2,500 employees, apart from, my Lord, the contract laborers who have been licensed by the licensed contractors. My Lord, there are 7 unions operating in my mill. My Lord, results were declared in 2022. Annexure A is the, my Lord, the 7 unions names are mentioned. And there was a agreement between unions and management. The union which secures, my Lord, 15%, 30% of vote in the votes polled in the elections, they will get one representation in JNC. JNC means, my Lord, Joint Negotiation Committee, which bargains with the management on behalf of all the unions. This was a settlement, my Lord, which was from 1991. Then, my Lord, the JNC has submitted a charter of demands. After expiry of the previous demands, my Lord, in 23.
Before all that,
Huh.
this is according to your registration is granted by the Assistant Labour Commissioner.
Yes.
Under the Act, what is the framework?
Yes, my Lord, that is precisely my question. The registration is done on, my Lord, Annexure D, page 98. That is 19/7/2025.
Yes.
By the Assistant Labour Commissioner, who was a designated registering authority for unions. Then, my Lord, on 19/5/2025, that is, my Lord, may I pass it on, my Lord, the translated version of this notification which I have produced along with the writ petition.
Let's see the Act.
19/5, my Lord, the notification itself is
Act.
produced. Yes.
The Act.
151, actually it has not been brought in, my Lord. New book has not been published. It has not come in the books. My Lord, page 151, kindly take, my Lord, Annexure H.
No.
On 19/5/25.
To understand is, what am I trying to understand
Please.
is, no, a registration is granted by the Assistant Labour Commissioner.
No. Assistant Labour Commissioner.
So, any registration that is granted by him,
Yes.
what is the remedy available to a party?
Remedy available to the party those who are party who has filed registration if it is not done or cancelled.
Always it deals with aggrieved party. What is the remedy available to the aggrieved party?
My Lord, aggrieved party is, my Lord, appeal is provided in respect of refusal to register. Refusal to
That's
register.
why let's look at the Act.
Yes.
Yes. Which section deals with registration?
9A, my Lord.
What are these rules called? Act called?
My Lord, Certificate of Registration, Section 9 of Trade Unions Act, 1926.
Trade Unions Act.
May I read it, my Lord, in the meantime? The registrar on registering a trade union. It starts from 8, my Lord, registration. The registrar, on being satisfied that trade union has complied with all the requirements of this Act, in regard to registration, shall register the trade union by entering in a register to be maintained in such form as may be prescribed. The particulars relating to trade union contained in the statement accompanying application for registration. Then, my Lord, certificate of registration. The registrar on registering a trade union under Section 8 shall issue a certificate of registration in prescribed form, which shall be a conclusive evidence that trade union has been duly registered under this Act. Then, my Lord, 9A assumes importance in my case also. I have urged that point. A minimum requirement about the membership of trade union. A registered trade union of the workman shall at all times continue to have not less than 10% or 100 of the workmen, whichever is less, subject to a minimum of 7 engaged or employed in an establishment or industry with which it is connected. Cancellation of registration. A certificate of registration of a trade union may be withdrawn or cancelled by the registrar on application of the trade union to be verified in such a manner as may be prescribed. If the registrar is satisfied that certificate has been obtained by fraud or mistake, or that trade union has ceased to exist or has willfully and after notice from the registrar contravened any provisions of the Act, allowed any rule to continue in force which is inconsistent with any such provisions, or has rescinded any rule providing for any matter, provisions for which is required by section 6.
So please come to 9A.
9A.
Yes.
A registered trade union of a workman.
10.
10.
We'll read 10 again.
10. 10A. On application of the trade union to be verified in such a manner as may be prescribed. It is available to trade union, my lord, my humble submission.
A certificate of registration of a trade union may be withdrawn or cancelled by the registrar. One, on the
application of the trade union.
To be verified in such manner as may be prescribed.
Yes.
Next.
If the registrar is satisfied that certificate has been obtained by fraud or mistake, or that the trade union has ceased to exist or has willfully and after notice from the registrar contravened any provisions of this Act, or allowed any rule to continue in force which is inconsistent with any such provisions, or has rescinded any rule providing for any matter, provisions for which is required by section 6, provided that not less.
Power is vested with the registrar.
The registrar, it is only at the instance of, my lord, the trade union, they can do it.
No. First, one is with trade union. 10A is with trade union.
Yes.
3 is
Yes.
suo motu powers of the
Yes, suo motu.
registrar. Yes.
If the registrar is satisfied that register of trade union must see, workman ceased to have been requisite number of members. Appeal, any person aggrieved by any, my lord, section 11, which speaks of appeal.
Yes.
Any person aggrieved by any refusal of registrar to register a trade union, or by the withdrawal or cancellation of a certificate of registration, may with such a period as may be prescribed.
That is, no, when it comes to 10.
Yes.
10. You can bring all this to the notice of the registrar, saying that what has happened in this. He would provided if you satisfy, he would take a suo motu
Yes, my lord,
cognizance of it and issue notice to the concerned registrar.
Yes, my lord, we have also requested the registrar.
Where is that?
Registrar to cancel the registration because it has been done without the authority of law. Precisely, my lord, my grounds are this. Section, my lord, has been amended, giving power to the labor officer instead of assistant labor commissioner by virtue of the amendment dated 19/5/2025. That is Annexure H, page 151. May I read it, my lord? The amendment was brought in with effect from which was published on 19/5/2025 in the official gazette. Then, whereby, my lord, the assistant commissioners who were registering authority prior to this, labor officers have been designated as a registering authority by virtue of this amendment, which has come into effect from 19/5/2025. Thereafter, the labor commissioner, who is the highest authority, issues notice to all the assistant labor commissioners. The files which are pending in respect of registration of unions, you send it to the labor officers, which are now designated as a registering authority by virtue of this amendment. That is Annexure J, my lord. It was issued on 11/6/2025.
Yes.
Page 152. The labor commissioner notifies, my lord, all the registering authorities to transfer the files to the labor officers which are pertaining to the registration of unions. They are now designated by virtue of amendment. Despite all this, the first respondent doesn't transfer the file to the labor officers. He himself registers it on 19/7, my lord, page 58. May kindly see the date of registration.
What are your instructions?
Please, Your Lordship, I'll get instructions, Your Lordship. for
Then,
the
my lord,
objections.
now,
Respondent, the HCGP appearing for respondent number 1 shall get specific instructions.
now, my lord, my problem is this. I have a settlement with all 7 unions,
So when this
which,
writ petition is filed?
my lord, it was filed on, my lord, immediately after coming to know of this union being registered.
Is a notice ordered to the HCGP?
My lord, notice was ordered in this background. I was directed to serve a hand summons also. We have served it. And the regular notice has also gone to them and it was served. Despite all this, they are sending, my lord, almost 25 notices of demands. Every day my IR department is engaged in answering the Labor Commissioner's office by virtue of this. The settlement which I had with 7 unions, which prohibits, my lord, any.
Matter day after tomorrow. By the time HCGP shall get instructions. By this time, you should have filed your objections.
Please.
9.
Defendant's writ petition, divergent findings on injunction. My Lord, one of the order of the land tribunal is in Kannada. My Lord, I have directed, my Lord, the office to translate it. May I request on Monday, my Lord, I will go on with the matter.
Let's list it on Wednesday.
Good.
At the request of the council petitioner. 40.
Seal number 40. Shuraj S. Balloli.
Filed recalling I, my lords, dismissed for non-prosecution.
For that also one memo.
Sorry, my lords. Pardon. Will comply the office objections, lords. Maybe kindly recall.
But don't move a memo again. Pending consideration of IA 1 of 2026, the petition is permitted to comply with the office objections. Once office objections are complied with, list this matter. Case 41.
Seal number 41. Gayatri Asa.
My lord, I appear for the impleading application, my lord, in this case.
Impleading application is not served on me. They've not served the copy of the impleading application. They have moved the matter. They've not served the copy.
I'll serve the copy, my lord.
I think for the Dharwad bench, court CH mode, I think that has to be defined. What are all the reasons on which a court can be moved? It is not a mechanical like this giving. There should be some reason for moving the court. Just like that, what will happen? The quality of the work of the judge will be hampered because all the matters are listed. Court has to complete the list. Matters which requires attention, they will not have. List this matter on 17 February.
There is an interim order, my lords.
Interim order earlier granted is extended.
Grateful.
Admission matters. Seal number 42. P. Anam Reddy. M.K. Saudagar.
My lords, it's a minor injury case, my lords. The date of accident year is 2019, my lords.
Admit for post of final hearing, call for the TCR. List 43.
Admit TCR.
43, I am for the appellant, my lord. Relationship of employer and employee challenge.
Lord, in this case, respondent claimant is yes, 60 years old, my lord. She is suffering ill health.
There is no relationship at all. Even the complaint itself, he was boarded the vehicle as to go to that place.
Please.
Yes, 44.
My lords, in this matter, I appear for the for respondent number 1, my lords. I seek for adjournment, my lords.
TCR, call for TCR.
This also call for
Seal number
TCR.
45.
45 TCR.
45 TCR, call for TCR.
46 also same. Admit final hearing TCR.
Admit TCR, final hearing.
47 notice.
47. Anjaneyam, issue notice.
48 notice.
48 notice.
49 notice.
49 also notice.
50 notice.
50 notice.
Why all these matters are listed without even dates? Huh? No memo. Why are they listed? I can understand date given matters. Without date, all these matters are listed. And then the list goes to 150. Who has taken this call? Let them come to the chamber. Yes, next. 51.
Cell number 51.
51, my lord, I have filed wakala in respect of my lord respondent on my lord 3/1/2026.
It is submitted that so and so has filed wakalat in respect of.
SC Bhuti for respondent.
For all respondent, only
One respondent.
For respondent, yes. Admit file nearing TCR. Yes, 52.
52, there are other connected matters, my lord.
Huh?
There are other connected matters in the.
List along with.
From 52 to 58, they're all the same connected matters and they may be connected.
52.
And
58.
and in 55, stay has already been granted.
Yes.
But still again, that application has been.
Yes.
Posted.
50 till 55 or 56.
58 till 58.
Till 58.
Huh.
52 to 58.
Admit file nearing TCR.
And connected matters may also be posted. Along. I've furnished
List
the
along
numbers.
with connected matters.
Yes, yeah.
Yes.
Cell number 59.
Yes, this
Preeti
also.
Shashank.
55, call for the TCR, post for final hearing. 60.
Cell number 60. Girish Arlord.
Other side have moved the matter.
Uh-huh.
Senior is held up in other legs of this court, my lord.
Senior is?
Senior is arguing before the division bench of this court.
What do you want?
Kindly next week any date. Other side has moved the matter, my lord.
This is,
Mahatesh R. Patil.
the respondent has moved the matter. When the matter is called, there is no representation. List this matter in the month of May, in the month of June.
There is interim order is there. No?
Interim order earlier granted is extended till then.
Please.
Cell number 61. Subhash J. Baddi. Subhash J. Baddi.
No representation list in the month of March.
Cell number 62. G.N. Raichur.
My lord, I am for
Same.
the
GN
appellate
Raichur.
insurance
Yes.
company. The
Yes, on all-
appeal is filed challenging the liability involvement of the vehicle itself. There is no damages to the vehicle.
Before the court, questioning the involvement of the vehicle itself, considering the same stay 50%, no permission to withdraw, notice to the respondents. Yes, 63.
50%. Preliminary hearing matter. Cell number 63. H.M. Dharwad. Every family.
Yes, no representation. List this matter in the month of April. 64.
64. Cell number 64. Y. Lakshmikant Reddy.
This also no representation. List in the month of March. Not April. April all matters. Yes.
65. Adjourn. Cell number 66.
My lord,
Sangram S. Kulkarni.
66. I am for petitioner, my lordship. My lordship,
For
another
the
matter to be
respondent.
connected with this. Please list along with the
Along with so and so in the month of March.
Lord, interim
May I
order
request
kindly
it
be
any
extended, my
specific
lordship.
May I request it any specific date? My lord allotment of the petrol bunk is been stalled. NOC is lord state.
List along with so and so on 16th February.
My lordship,
16th,
interim
lord,
order
it would
kindly be extended.
Because lord time would be lapsing. I'm required to pay lord 5 lakhs and lord for issuance of NOC lord. Any date next week lord. Please.
My lordship, interim order is there, kindly be extended.
67.
67.
Please. Lords, I may permitted to withdraw with the liberty to file before the same court, my lords, because for recalling, my lords, I thought it has been settled before the Lok Adalat. But, my lords, it was done in the open court. So the remedy lies before the same court, my lords. So
Memo is filed seeking to withdraw the petition with the liberty to move the very same court.
Please.
Memo is taken on record and the liberty as sought for is granted.
Please, great.
My lord, seat number 59, my lords.
68. 68. Put on. Cell number 68. S.M. Kalwat.
Yes.
Petitioner, my lord, they are devotees of the respondent number 6, Mutt, my lord. And in the earlier case, my lord, the administrator was appointed for the management of the affairs of the Mutt, my lord. Subsequently, that appointment administrator is withdrawn.
P. Guru Ganta Swami Parameswar Swami. Peetakipati. Writ petition is filed seeking what is the relief? Issue an order in the nature of so to quash the order dated 7/2/2025 passed by respondent number 1 Under Secretary, Department of Revenue, Government of Karnataka. What is the order passed?
Wherein, my lord, earlier appointment of the administrator is withdrawn by virtue of this annexure Y, order annexure Y11, my lord. Earlier, administrator was appointed. Subsequently, appointment of the administrator was withdrawn.
Administrator to which institution?
Withdrawn. However,
Administrator to which institution?
district.
Respondent number?
6 month, my lord.
No, respondent number 6 is not the MUT.
Now he is a self-claimed Pitadipati, my lord. He is managing the
So where
affairs.
is the MUT?
That is in Nagalur village.
Where is it a party? Which arrayed as which party? Respondent.
That respondent 6 itself is managing the affairs of the department. Respondent number 6, Shivogi Gadigaya Hiremat. Now he is self-claimed.
This is Swami.
But
There
he
must be-
is in charge of the MUT. Now he is discharging the duty as a Pitadipati.
No. MUT should be a party to the score, to the represented by so and so, I can understand. MUT should be a party to the writ petition. Without making a MUT party, a MUT is a notified institution according to you.
Yes.
So it should be a party. How can a writ petition be maintained against all these private parties?
I will implement them.
The petition shall implead the MUT. List this matter after 2 weeks. By the time the MUT is not impleted, the writ petition shall stand. Yes, 69.
Number 69. Jagdish Patil.
For the-
Dodati.
For the petition, Manoj.
Who moved the memo?
We have moved, Manoj.
Who?
We have moved, Manoj. Petition has moved.
You have moved. Yes, what is urgency?
Manoj, in fact, on the previous occasions also, this honorable court had directed the government to file the affidavit of principal secretary, Manoj. It is filed. The land, Manoj, the only relief that we have sought is to
When is the
issue-
order to file the
On 20th 11 minutes.
20th November.
20th November 25 affidavit.
What is the issue?
Manoj, we had sought for an NOC, Manoj. NOC that our land has not been acquired for any of the projects by KIDB, Manoj. Manoj, they gave a reply saying that in year 2011, the land which is mentioned, the subject land, that has been acquired in the preliminary notification. Subsequently, Manoj, no compensation is given, no possession is taken over, Manoj. So the very proceedings of acquisition has lapsed, Manoj. Now, Manoj, they are not even ready to issue NOC that they have not acquired the land, Manoj. Now, Manoj, we intend to
Let's
get
see your affidavit. What is that you are seeking? The petition
please, Manoj.
directing the respondent to issue NOC for not having acquired the.
Please, Manoj.
Now, how can there be a
Manoj,
mandamus of
that
this
is the
nature?
required, Manoj, for a moment, Manoj. Annexure F may kindly be seen, Manoj.
No. Why should the court tell them shall that they have not acquired the land? That's you can't seek relief in this nature.
Manoj, what has
What you
happened?
sought, what you are supposed to seek, saying that my properties are not though acquired, the land acquisition proceedings are lapsed. So, in spite of that, like it is under the impression that it is acquired, please clarify under the Right to Information Act. That will cut the
Manoj, we have
issue.
given numerous representation, Manoj. For
Was it done under the Right to Information Act?
no, Manoj, the direct representation.
To give a Right to Information Act an application, they are supposed to answer. If they don't answer, you
But
have
they,
a remedy.
they have already issued a reply, Manoj. They say that it was acquired in the 2011 preliminary notification. But pursuant to that, no acquisition has been done.
Then I'll pass an order saying that earlier notification lapsed. As of now, their lands are not acquired. Where is the letter of the principal secretary?
My lords, the affidavit I filed on my lords on 20th November 2025. 20th November 2025, my lords. Affidavit as per direction of this honorable court. My lords, the principal secretary of the Department of my lords, the Commerce and Industries has filed a my lords
Where is
affidavit.
that? Look at it. That you have a copy of it.
Yes, I have a copy.
Please pass it on.
Please. Relevant portion starts para 3, my lords. Affidavit.
No, No, why do you want this information?
My lords, we have applied for converting the land into non-agricultural use, my lords. One of the requirement is that we have to get an endorsement to the effect that land has not been acquired, my lords. Annexure F may kindly visit. All the list is provided, my lords. In that, at serial number Serial number 6, my lords, certificate from the Assistant Commissioner regarding not acquired land for any scheme. Annexure F, my lords, page number 23.
This affidavit filed by him.
Though the land was acquired in there 2011, my
What
lords.
does what exactly
Please.
your officer, principal secretary to the government is communicating by this?
Yes.
Is he trying to say that we want his land, we may require his land in future? 2011 acquisition, part of it is already lapsed, but the adjoining lands are already developed or acquired. So forever, we will not give NOC and we will keep this land when we, if at all we require. Is this whose land? Is it a government's land? But it's very unfortunate, being a senior of a IAS officer, a principal secretary to the government, files this kind of irresponsible affidavit before the court.
In fact, it's
I'll record this. I'll list this matter day after tomorrow. Tell your principal secretary. He'll let him come up with an affidavit in a manner known to like any person with some wisdom. Or else I will record that this kind of an affidavit from a senior IAS officer is very irresponsible. And I'll record it in this order.
I will convey the manor's anguish.
When the court by order dated, the writ petition is filed. The petitioner wanted to convert his land from agriculture to non-agriculture, and one of the criteria for the same, along with the application, he has to make he has to enclose the NOC given by the respondents saying that the particular property is not acquired. In that regard, the petitioner has made several representations to the respondents, and when they have not given any NOC, he has come before the court. Then a coordinate bench of this court, by order dated
18/11/2025.
8/9.
18/11/2025.
8/9, I think, in this.
Please, Manoj.
8/9/2025.
Subsequently, one more order is passed on 18/11.
I'm looking at. An order was passed on 8/9/2025. Observing that, it is rather shocking that the Karnataka Industrial Areas Development Board, which qualifies as a state under Article 12 of the Constitution and is the acquiring authority, has issued an endorsement indicating that acquisition proceedings have been pending since 2012, based solely on the issuance of a preliminary notification under Section 28(1) of the Act without any further progress. Hence, respondent number 1 is directed to examine the matter and file an affidavit clarifying its stand on such cases. For that, an order was, the present affidavit is filed by the Principal Secretary to Government, Commerce and Industries Department. It is stated that before acquiring the land in question already for industrial purpose, 952-33-00 acres of land acquired in the same village by issuing the notification under section 28(4) dated 28/5/2010 and subsequently to cater industrial demands, again further 37-22-00 acres acquired by issuing the notice under section 28(4) dated 3/6/2011 in the same village. It is stated that the petitioner's land or adjacent to the already acquired lands, taking into account the anticipated demand for industrial areas, again 63-34-00 acres land were acquired, including the petitioner's land by issuing the preliminary notification on 3/6/2011. It is stated that various industries are functioning and still developed plots are vacant and getting allotted. In view of the above circumstances, much progress did not happen for the acquisition of the land, which includes petitioner's lands. The delay is bona fide, unintentional, and beyond the control of the acquisition officer. It is stated that the honorable court be pleased to place this affidavit on record and dismiss the petition in the interest of justice and equity. It is so unfortunate that an affidavit of this nature is filed before the court. A person's property for which a preliminary notification is issued in the year 2011, and he made to run from pillar to post for obtaining the NOC. And when he comes up before the court, this is the affidavit that is filed. The respondent, the learned AGA, shall inform the same to the respondent and shall get specific instructions and shall also file an affidavit. What he is expected to answer in the affidavit, he has not at all answered. If it is understanding of the officer who holds the rank of a principal secretary that a preliminary notification that is issued in the year 2011 is continuing till 2026 without paying the compensation to the parties.
Sorry, I appear for the bold notes.
You appear for the?
Bold, KIDB notes.
KIDB.
I filed my statement of objections in this matter.
No, your statement of objection is not required. That's what is the principal secretary is required. What did you write? What did you write? By filing, what is the purpose for which the court asks the affidavit to be filed? And what is the affidavit that is filed? I think with the experience of the officer, he must be understanding what are the contents and the effect of it. Necessary affidavit shall be placed before this court by Monday, or else the court will be constrained to pass appropriate orders basing on the affidavit that is filed by the principal secretary. This matter on Monday.
It's 1 week, or at least Tuesday or
He doesn't require that also. I should have passed, he should rush to the court and pass it. Or else on Monday, I will record about his,
yes.
Yes.
Second. Seal number 70 adjourned. Seal number 71. Anand Kumar. Yeah, Anand Kumar, please.
Challenging the election. See, my lord, Lok Adalat order, my lord. Lok Adalat order. I am challenging the annexure C Lok Adalat. My lord, in this.
Why? Only.
Hello, only 35.
All Lok Adalat awards are challenged by you.
My lord, as per the judgment of this honorable court, Lok Adalat matter challenge before the maintainable. Kindly say.
I didn't say that it is not maintainable.
Please.
It can be, it is maintainable. But on what ground it is maintainable is the question.
Abuse process of law, because with the.
Let's see, what is abuse? Where did you read that abuse of process of law?
The defendant number 1, the
What is the suit for?
Partition and separate position.
Are you a party to the suit?
Please, my lord.
You are read as defendant number,
Plaintiff,
you are the plaintiff.
plaintiff.
And you entered into a compromise.
Please, my lord.
Now, on what ground you are saying that the compromise is bad?
My lord, as per the legally, they have not divided the property. Legally, they have not divided property. Because the defendant number one, there is
They
a
have not legally divided the property.
property.
Why did you sign the compromise award?
No, in the para, in the complaint petition, para number clearly stated that survey number 3.
Council, I think you better take a chance. I'm going to dismiss it. That's why I'm adjourning it to March. Yes, this is matter in the month of March.
Please,
Number 72, this is Jnanaya Swami.
at least issue notice.
Not a case for notice.
Please.
Yes, 72.
Jnanaya Swami.
My lord, permitted to withdraw the petition with liberty to approach same court, my lord.
Yes. A memo is filed seeking to withdraw the writ petition with the liberty to assign the order before the very same court. Yes, accordingly dismissed as withdrawn with liberty as sought for. Yes, 73.
73. Hirematak, Mahantesh.
Request for 2 weeks, my lord. Same pertaining to that, RSA is pending before this honorable court and RSA issued the notice in the RSA, my lord.
No, what is the writ petition about? Let
This
us
is the, my
see.
lord. Challenging the annexure E.
Annexure?
E, my lord. Wherein my application is rejected, that is,
Page
the
number?
petitioner had filed application under section,
Page number?
page 34, 33, my lord.
Page 33.
Please, my lord, that is the impugn order, my lord.
Under
And,
order 97.
please, my
seeking
lord, for
implead the
impleading, my
applicant
lord.
as JDR number
Please, my lord,
to
which is,
adjudicate the matter properly.
yes, my lord, which is dispute in this case, my lord. I am the owner. I produced that RTC records, that is annexure A to A3, my lord. That is, I am the owner of that properties and the title is in my name. And the here, my lord, the suit is for partition.
Why will the JDR has filed the application for executing the judgment?
Sorry, my lord. Judgment holder.
Holder will file. Why would the JDR file?
Because I'm the owner of that property which is disputed before this execute.
You said, read point number 1. The proposed applicant has stated that the JDR has filed this petition for executing the judgment and decree.
Point number 1. The proposed applicant one has stated that the JDR has filed this petition for executing the judgment and decree. They passed in RA, that is RA 67, 68 and 103 model, dated 1/9/2020. Behind the back, these applicant 1 to 4 model. And the applicant 1 is peaceful in possession and the enjoyment of the suit properties bearing survey number 72/2 measuring 3 acre 35 kuntas and now the said survey number is 38 measuring 7 acre 20 kuntas of out of 2 acre 20 kuntas and other obstructor number 2 and 3, 4 is the lawful possession and enjoyment of the survey number 78 measuring 7 acre 30 kuntas out of these 2 acres 15 kuntas as such as the possession of the suit land since long year and the same is also well within the knowledge of the public and large Budangatti village Taluku Hameri. The fact is the judgment holder has obtained the judgment and degree from the learned honorable additional district and
Please
session
come
judge.
to paragraph number 9.
Please,
Paragraph number 9.
yes, my lord. If once the applicant have to prove their independent right as they are owner and in the possession of the suit properties, then applicant have to produce the title over the suit properties better than the judgment holder. This case when OS 154/2014, which was disposed of on dated 21/4/2018 by party declared the suit. Thereafter, the plaintiff has prepared the RA 67/18, 64 and 103. Wherein the district session court Hamere has modified the
In
judgment.
this case, the applicants, except
Yes, madam.
stating that in the affidavit that as per the revenue records,
Yes, my
They
lord.
are in possession of the suit property
Yes, my
since
lord.
long years, but they have not produced to show
I
that as per
produced,
the revenue records, they are in possession of the suit property.
yes, same wherein I produced before the execution court, same is produced here, that is annexure A to A4, my lord.
Page number.
Page number 11, my lord. That is survey number 78, 1. And page number 13 is, sorry.
Is it filed by you before the court?
Yes, my
Shall I
lord.
record it in the
Yes,
order?
please, my lord. Same is not considered by the execution court, my
Then
lord.
counsel appearing for the petition submits that he has filed the documents to show, he has filed the documents asserting his right to the property. And this aspect was not considered by the court. And in fact, it is stated that along with his petition, he has filed the relevant documents. In the order, it is observed that as per the revenue records, it is the case of the applicant that they are in possession of the property since long years, but they have not produced to show that as per the revenue records, they are in possession of the suit property. It is submitted that the said finding of the court is contrary to the evidence on record. Considering the same, they shall be stay of all further proceedings. Pursuant to so and so, so and so. Notice to the respondent, petition is permitted to take out hand summons on the counsel appearing for the respondent. Once the respondent enters appearance and it is brought to the notice of the court that such revenue records are not placed before the court, the writ petition will be dismissed with exemplary cause.
Bill number 74. Madan Mohan Arnold.
Yes, I appear for the petition, my lord. It is the petition filed by the NWK Corporation, my lordship.
Huh?
It is petition filed by the corporation, Road Transport Corporation. The respondent, your lordship, was a artisan and he was requested to work for additional work, your lordship, but he refused.
What is the award?
That, your lordship, regarding the reducing one increment with cumulative effect was imposed, your lordship.
Notice respond.
I sought for stay.
Stay of what?
Annexure B, your lordship.
What is
Because
that?
he approached the tribunal allowed his application, your lordship.
Application, let's see the order.
Annexure B, your lordship.
The reference so and so may be understood. Consider the impugned order of punishment dated by reducing one annual increment with cumulatively and suspended treated as not on duty is hereby set aside. Workman is entitled to the monetary benefits which are denied consequent upon the impugned order or the equitable monetary benefits if any and extend the same. When is the award published?
Annexure A, your lordship, is Kannada, your lordship.
No, award is which date?
Award is, your lordship, 13/11/2015.
2015.
Yes, he has the annexure A, your lordship.
No, this
Present, your lordship, 3/12/2024, your lordship.
it is when?
3/12/2024, annexure B.
The time also elapsed now. It said within 6 months from that.
Yes, I will issue a notice.
Notice.
Number 75. GN Raichu.
My lord, this is a writ petition filed challenging the condonation of delay in filing the MUC petition, my lord.
No, that's what a coordinate bench of this court has passed an order saying that it can be condoned. That's why I posted these matters.
But still the matter is before the Supreme Court in appeal. Supreme Court has.
Because anyone no stay is granted, let this also has to go. Why should we interfere?
Not interfere. Suppose if Supreme Court comes to a conclusion that once if there is no condonation of delay, then again the petitions will be dismissed.
No, that's what I'm saying. That already there is an order passed by a coordinate bench of the court.
Yes, ma'am.
Why should we deprive this writ petitioner?
No. Till Supreme Court has to say regarding this, because this is a mandatory provision.
Notice. Bill number 76.
Kindly pass over, madam.
76.
Pass over.
76 pass over.
77.
77. Umesh P. Hakkar ki. Umesh P. Hakkar. 77.
No, again from here, come to this, again from here. Why you on this listed? It's not pressure, it's all 25 matters. There is no rule in right. Where are the dates given in this? 77, 78, 79, 80. Then it should say date, then it need not be after vacation today. You should ask. Ask that fellows to come in now. Yes. 77,
77,
no representation list in the month of March. 78,
78, Jayant Kamble. Shuk Singh.
The petitioner herein has challenged the annexure H, my lord, compromise petition, my lord. During pendency of the appeal, my lord, regular appeal, the respondent herein has filed the one more suit, my lord, collusively and got the compromise decree, my lord. My lord, in this case, my lord, in the year 2009,
where is the compromise decree?
page number 58, my lord.
58. Are
Yes.
you a party to the compromise decree?
No, my lord, I am not arrived as a party in the
What is the suit for?
suit for partition and separate possession, my lord.
For you, what is the relationship between you and the other party?
I am the one of the son of the deceased propositors, my lord. I am permitted to pass the genealogy, my lord, in respect of the deceased Tirkappa, my lord, who is the father of the respondent and present petitioner.
You are not a family member.
I am the one of the family member, my lord. What I am, my lord, in the year 1998, my lord, the respondent herein has filed the suit for partition and separate possession.
Where are you in this family tree?
I am the Manjunath, my lord. Sorry, my lord. I am the Manjava Tirkappa Malagi wife, and Ravi is the son of the deceased Tirkappa, my lord. My lord, what happened, my lord? In this case, my lord,
Manjua Tikkappa Malgi, you say his wife, you say Ravi. What is that?
my lord,
What is this?
she is the whether she is the second wife or first wife. I don't know that, my lord. But in the pendency of the appeal, we have filed the impleading application, my lord. Impleading application is pending, my lord, and they are not appeared, and they have filed the one more suit, my lord, suit for partition and separate possession. You mean between of the Manjunath and Mallikarjun, my lord.
I'm asking you, what is the relationship between you and the family? You are not able to say that.
Manjava is the wife of the Tirkappa Malagi, my lord. And Ravi is also one.
Kappa Malgi.
Yes, my lord. And Ravi is also his son, my lord. And Prema and Manjunath Mallikarjun, they are also wife and children, my lord. What a my lord, I will explain it, my lord. In the year 1998, my lord.
Respond and come and explain. Notice.
My lord, what happened? I sought for shame, my lord. What happened, my lord? My lord, one submission, my lord. Kind permission, my lord. What happened, my lord?
Permitted to take out hand summons on the
My lord.
council appearing for this
My
matter.
lord,
No.
my lord, one submission, my lord.
Relationship itself is not clear. Why will we interfere in that?
My lord, one submission, my lord. Kind permission, my lord. What happened, my lord? They have already filed one more petition, my lord. It was withdrawn, and they are seeking only mutation of their names in the record of rights, my lord. There is a possibility of multiplicity proceedings, my lord.
If the court grants an
My lord,
order,
I am seeking only for the status quo order till their appearance, my lord.
notice to the respondent.
79,
Is permitted to take
79.
out hand summons on the council appearing for the respondent and shall file a memo to that effect. Once the memo is filed, is the matter. 79.
79, Sadashiv S. Patil. Says Patil.
No representation in the month of March. Yes, 80.
Bill number 80, DJ Nayak.
Petition. In the similar case, the order is passed by this honorable court.
What is that order?
That the liberty is given to
Oh, that is the matter.
107 of the CRPC.
What is the number? Give that number.
Please,
Same
ma'am.
order in like the other one. It's 81.
Bill number 81, Rahul. Good question.
Yes, no representation in the month of March. It's 82.
Seal number 82, Ram P. Gorpade. 82.
Same order. 83.
Seal number 83.
My lord, I appear for the petition in serial number
Yes.
83, man. This is a
Yes.
matter, my lord, wherein the coordinate bench has passed a judgment. It is binding, my lord.
Generic medicine case,
Mm.
Janaushar.
Janavadi Kendra matter.
Same order. Same order.
Same order. 83 and 85.
Medical,
Generic medicine, my lord, center.
Please,
the
ma'am.
petition is filed in the following prayer. When the matter came up in council appearing for the petitioner placed before this court, in order passed by a coordinate bench of this court in WP number 105933 of 2025, dated 10/12/2025. And the petitioner before this court is entitled for the same order. Learned AGA appearing for the respondent does not deny the same, considering the same. The writ petition is disposed of in the light of the order passed by the coordinate bench of this court as follows. Whatever is operative portion.
Grateful.
Yes.
And for the petitioner in this case, madam, sought directions against respondent number 2 to refund the amount of rupees 1 crore 10 lakhs, my lord. As per the directions issued by this honorable court at annexure C page number 42, my lord.
You can't maintain a writ petition when there is an order of the court. If they are not complying with the same, you should file a contempt. You can't file another writ petition.
No, my lord, this is a case where the petition, the allegations is that, my lord, petitioner has made theft of electricity. They have filed the special C before the trial court. He has acquitted in the said proceedings, my lord, that holding that he has not committed the.
No. Order is dated 15th March 2022.
Please,
Now,
ma'am.
what is the prayer that you are seeking?
Directions to refund the amount of rupees 1 crore 10 lakhs, my lord, which was deposited as per the direction of this honorable court in writ petition number 70828 of 2012.
You want this relief, what you are supposed to do? You should supposed to give a representation to.
We have given the representation.
Then what is the order you
Then-
should seek? You should seek an order to consider your representation. Court cannot pass a positive order saying that you refund that amount. What is the business of this court to pass such kind of orders? Who appears for the respondent? The executive engineer, which
Respondent number, JESCOM.
JESCOM, who appears? Who is this council, panel council?
BS Kamte.
Yes, come on.
To take notice. And so takes notice on behalf of the respondents. The petition says, serve him the copy.
Please.
Is get instructions.
Please.
This matter on Tuesday. Yes, 85.
Seal number 85.
Same, my lord. Same as 83 serial number.
Like 83, same order. Yes, 86.
Pledged.
Pass over, kindly pass over, my lordship, 86, remember. Kindly
Yes,
pass over, my
86
lordship.
pass over, 87.
Pass over 87.
Please.
Request day after, some person inconvenience today.
Huh?
May I request day after tomorrow, some person inconvenience.
Which one? This one.
87,
87.
This is matter on Tuesday.
please.
Yes, 88.
Third. Seal number 88. Kalmesh.
No representation. This is the month of April.
Seal number 89.
For petitioner, my lord, writ of mandamus, my lord, seeking direction, annexure of my lords. After investigation, my lords, please.
Yes.
The respondent number 2 submitted report to respondent number 1, my lord. After investigation, my lords, the husband of the
Directing
petitioner.
respondent number 1 to take further action on the report submitted by respondent number 2. Who is respondent number 2?
Respondent number 2 is the, my lords, deputy.
Deputy Electricity Inspector.
Please. He submitted.
Lords, this writ petition is not maintainable. His claim is for damages. Damages cannot be written by this honorable court. My lord, civil court can,
They are seeking an action.
seeking my lord's consideration of my lord's writ of mandamus, directing to consider the my lord's annexure F. Annexure F is the report submitted by the my lord's the authority saying that,
Anything can be filed as a writ petition.
yes,
That's what I'm seeing the trend.
this court cannot, my lords, not in a position to, my lords, determine the total, what is the compensation to be paid to the, my lords, the LRs of the deceased, my lords.
But they are not seeking a positive direction.
They are
What-
seeking only to,
Representation is dated 6/9/2025.
second prayer is concerned.
Release, no, that we will not grant.
Yes,
We will grant the first relief.
yes.
The present writ petition is filed, seeking the following prayer. It is a case that petitioner's husband had land and there was a borewell in that. He obtained electricity connection for respondent number 3 to take the borewell. On 19/6/2025 at about 10:30 a.m., petitioner's husband went to the land for flowing the water to the crops in the land. And because of leakage of electricity and earthing, the petitioner's husband died due to died.
Electrocution.
The brother of the deceased filed complaint before respondent number 4 regarding the incident. And the respondent number 4 had registered the UDR under section 194 of BNSS 2023. And after getting the information of the incident, respondent number 2 visited the spot and after inquiry, the respondent number 2 submitted a report on 6/9/2025 to respondent number 1. In the said report, respondent number 2 opined that the rubber bushing was not installed at the entrance of the starter box of the service wire pulled to the irrigation pump set plant on the land on Shivalingaya's land. When the wire shook in the wind, the wire repeatedly touched the sharp entrance box, the installation was destroyed, and the phase wire came into contact with the box and electricity leaked. When Shivalingaya's petitioner's husband,
Please, madam.
petitioner's husband touched the box, whenever that Shivalingaya name there, no? Petitioner's husband touched the box, he died due to shock. And respondent number 2 further opined that because of the negligence and mistake of the respondent number 3 department, the accident occurred. If they maintained the wire properly, the incident would have been avoided. It is a grievance of the respondent petitioner that the respondent number 2 is not, the one is not taking any action pursuant to the report of the respondent number 2. Hence, there may be a direction to respondent number 2, respondent number 1 to act upon the report dated 6/9/2025. Next part, Leonard AGA, representing the respondent, submits that the petitioner cannot seek a direction to respondent number 1 to release a compensation to the petitioner, as the same has to be done as per the procedure. As far as taking further action by the respondent number 1 in accordance with law is concerned, a time frame may be fixed, considering the submission of the Leonard AGA and the fact that already a report dated 6/9/2025 is submitted to the first respondent. The first respondent ought to have taken action in accordance with law. Considering the same, this court is passing the following order. The writ petition is disposed of, directing the respondent number 1 to take further action on the report submitted by respondent number 2 in accordance with law. As far as other prayer is concerned, the petition is not entitled for any relief from this court. Accordingly, disposed of.
Yes. Disposed. Number 90, MS Harvey.
Petitioner, my lord. The petitioner was appointed by my lord as a president of the my lord, third respondent government school, as a chairman of the my lord, president of the my lord, school management and monitoring committee. And once he is appointed, his period is 3 years. He was appointed on my lord 24/11/2024. But during the 2025, the third respondent school has removed the my lord from the post of my lord president on the ground that my lord, though the my lord petitioner daughter was studying in the my lord SSLC in the various kids school, but she has been passed out. Therefore, she is not no more parents of the my lord said school. Under the my lord Right to Education Act, once the my lord he has been appointed, he has to complete his tenure till the
One of the condition is that when he has want to become a member or the president of the SDMC committee, their children should be studying in the school. That is the condition, the precondition. As the daughter of the petitioner passed her SSLC, 10th standard, and he discontinued to be a parent. Hence, the order passed, my lords. It's
My
right.
grievance is, parents or the guardian, there is under the act, my lord,
Parent,
or guardian, my lord, guardian of the, my lord.
your guardian.
But the one, my lord, Rakshita, who was studying in the 8th standard in the very school, the petition has taken as a, my lord, guardian after that school.
Does your name reflect in the records as guardian of so and so?
But that father of that child has given them consent, did in.
That is not, you should, what is a consent? You should be, if, when she was admitted in the college, school,
Please.
record should say that you are the guardian. Not for the sake of being a president, somebody will not give you
The father of the very said child has executed agreement.
Not, guardian is officially a guardian as per the records, not somebody giving you a permission to continue as a president.
Since on that ground, he has made application to the respondent.
No, what is the purpose? I don't understand. Why you want to be a president in a school which you are unconnected with any of the affairs of the school? The purpose of it is the parents or the guardian of a particular ward should be the president. You have nothing to do. Her father is there. He will take care of her.
Since my tenure was completed in the year 2027, my lord.
Yes, please come. The present petition is filed, seeking the following prayer. It is a grievance of the petitioner that petitioner is a resident of Kottur town and is also the president of Government Girls High School, SDMC Committee, Kottur. The SDMC committee headed by petitioner has been constituted. Now the easy way is, when all these petitions are filed, now you have got instructions.
Please.
Whenever the instructions are brought like this, unnecessary litigation won't be there.
My lords, this is out of my experience. I am only submitting. In other cases, my lords, instructions are required. Copies are served yesterday and matters listed today.
No. It is like objections or concerns,
Please.
it's a different aspect.
Yes.
Now on an issue, now if this is the case,
Yes.
his term has 3 years.
Yes, please.
Now it has been, now he has been removed.
Yes, please.
Then automatically it's a case for stay,
Yes.
isn't it?
Yes, please.
Because you got the instruction.
Yes.
There is difference between instruction and objections.
Please.
If you got the instructions, prima facie,
Yes.
court is convinced.
Yes.
Then no interim order will be passed.
Yes.
So that is what is expected.
Please,
That's what I'm saying.
We will try, my lords. We'll make efforts to.
The SDMC committee headed by the petitioner has been constituted a committee on 14/11/2024 by passing the resolution in the parents meeting. Thereafter, the second respondent has approved the SDMC committee on 10/12/2024. The tenure of the committee is 3 years as required under section 13 of the Karnataka Right of Children to Free and Compulsory Education Act 2009. The petitioner committee is monitoring the fourth respondent high school effectively and the interest and welfare of the student. The tenure of the committee is going to be expired on 3/12/2027 when the facts are fourth respondent is unnecessarily interfering with the administration of the committee without any reason. The fourth respondent is discharging the duties detrimental to the interests of the students and not properly utilizing the government grants, and even without the knowledge of the committee, the fourth respondent has taken several decisions against the interests of the students and their parents. Agreed by the illegal act of the fourth respondent, the petitioner and his committee members have made complaint before the second respondent, requesting to take action against the third respondent in the better administration of the fourth respondent high school. The petitioner's daughter was studying in the fourth respondent high school in 10th standard and she passed out SSLC during the academic year 2024-25. And as such, the petitioner has submitted application to the second respondent requesting to continue him as the president of the SDMC committee till completion of the tenure on the premise that he has taken the care and custody of one student by name Rakshita, who was studying in 8th standard with the permission of her parents. The students of the parents of the said student have executed consent deed in favor of the petitioner, agreeing to take care of the care and custody of his daughter till completing the 10th standard. It is stated that as per section 13 of the Act, tenure of the committee is 3 years after its formation. In spite of it, the The third respondent has called for the meeting for formation of the new committee. Next par, land council appearing for the petitioner submits that this action of the third respondent is contrary to the provisions of the act. When the petitioner is now the guardian of a girl who is studying in her
Eighth standard. Kumari Rakshita,
which class?
8th standard, madam.
Studying in 8th standard. There is no, the third respondent ought not to have called for the meeting. It is submitted that this action of the respondent is contrary to the act. And as such, the writ petition needs to be allowed. The AGA on instruction submits that the petitioner, the precondition as per the act to be a president or a member of the same is the child shall be studying in the school. In the petition itself, it is stated that the petitioner's daughter has completed her 10th standard. As submitted by the petitioner, that a consent letter is given by one of the student, that is parents of one of the student cannot be a ground, and on that he cannot be considered as a guardian, and they have rightly, and he ceased to be the president, and the third respondent has rightly called for the meeting for the formation of the new committee. And now it is not constituted.
No, it is constituted on 14/11/2025.
And then a resolution was passed on 14/11/2025, constituting a committee. It is submitted that the action of the respondent is in consonance with the provisions of the act, and the petitioner and the writ petition needs to be dismissed. Next para. Having heard the land council on either side, peruse the material on record. The whole purpose of what is this act called?
SDMC Act, School Development and.
Paragraph it is mentioned.
Is under section 13 of the Karnataka
Right of Children to Free and Compulsory Education Act 2009.
Please.
The purpose of this committee is to see that the grievance of the children and the parents is effectively addressed. And for that purpose, as rightly submitted by the AGA, the prerequisite is that this child must be studying in the school. When the petitioner's daughter has passed out, the petitioner has no right to continue as a president of the society. It is the submission of the land council that some parent has consented him to act as a guardian. That is not the purport of the act. To continue as a president, he cannot be appointed or consent as consent be given by some other parent to be the guardian of a daughter of a girl. If the act says guardian, the parent oblique guardian, that means as per the records, a particular person should be a guardian. But what the learned counsel with the petitioner is submitting is unknown to law, and the same cannot be considered. In the considered opinion of this court, there are no grounds to interfere with the writ petition, with this writ petition, and the petitioner is not entitled but any relief from this court. Accordingly dismissed.
Take notice for R1 to R.
Under the act, parents or guardian, there is a mention in the
That I
section.
have given an interpretation for that.
So I take notice for R1 to R3.
AGA takes notice for respondent number.
1 to 3.
1 to 3.
1, 2. Seal number 91. Abhinandan, Hiramat.
Yes.
My lords, in the last occasion, my lords have directed me to file an affidavit. I've served on the government, my lords.
Take that.
The affidavit is regarding when the police authorities have disturbed the day-to-day activities of the recreational club.
Please come. The present writ petition is filed, seeking the following prayer. Land council, as per the order passed by this court, filed an affidavit before this court, and it is stated that on 16/9/2025, at about 12 p.m.,
one of the respondent police officials visited the premises of the petitioners club and verbally warned the management and members to stop the activities without issuing any written notice or order, and further told that there is on instruction from his higher official that the petitioners club shall remain closed and forced all the members to vacate the club. It is stated that on 18/11/2025, the police constable who was in Mafti again visited the club premises and threatened to close the club, stating that the club would be sealed if activities were continued, despite the club holding valid registration, renewal, and operating lawfully. It is the grievance of the petitioner that the petitioner club is running after obtaining the license, and as per the terms and conditions of the license, when the club is functioning, the respondent has no authority to interfere with the same. If there is any violation on the part of the petitioner, the respondents have to issue a notice and follow the procedure known to law, and then only they can take an action. It is submitted that this action of the respondent is high-handed, and in fact, in a similar writ petitions, a coordinate bench of this court, where is that order?
There are 3 cases, my lords, wherein it belongs to same locality.
In a coordinate bench of this court in WP number 100682 of 2025 dated 6 February 2025 has passed a slew of in WP number 12241 of 2018 dated 27/3/2018, a slew of directions are given to the respondent. It is submitted that in similar lines, the present writ petition may be disposed of. Learned AG appearing for the respondent submits that, as stated by the petitioners, they are not high-handedly interfering with the activities. Even as per the directions that are issued in WP number 12241 of 2018, the police have a right to visit the premises and premises whenever there is an information that the illegal activities are taking place. Next paragraph. Having heard the counsels on either side, but is a material on record. According to the petitioner, he has a license and he has been following the procedure. He has been doing the business as per, he has been running the club as per the terms and conditions of the license. If the petitioner, the petitioner cannot stop the respondent officials from entering into the business. However, if they want to take any action on any illegal activities, they have to issue they have to follow the due procedure, and then only the respondent police can take action. But high-handedly, they cannot stop the petitioner from conducting conducting the activities of the club. In that view of the matter, in the light of the order passed in WP number 12241 of 2018, the present petition is disposed of. You will find that from point number 1, you take all that accordingly disposed of.
Disposed.
Highly obliged.
Number 92, Srivatsa Hegde.
I represent the petitioner, my lord. Petitioner is requesting for grant of BH series registration to his vehicle with the respondent number 4, which came to be declined for the reason that I am a servant of a private bank. Lord will notice that I am one of the categories entitled or eligible.
Yes, do you have any instructions?
My lord, no instruction. I will get the instructions.
Please get instructions. I think this is already has come up on the last occasion.
Yes.
High Court shall get necessary instructions. Finally, list this matter on Wednesday. By the time specific instructions, the respondent shall have specific instructions, or else the writ petition will be disposed of basing on the material on record.
Please.
Number 93.
Please.
93, my lord. I am for the respondent.
My lord.
I will collect the copy of
My
the
lord.
affidavit. Kindly have it on tomorrow, my lord.
My lords
I'm
had directed
seeking
me to
only
file an
this.
affidavit stating that if the plaintiff is to succeed in the suit, I will not claim any equity. I am
I will
filing an
collect the
affidavit, my lords,
copy.
to that effect.
Kindly have it on tomorrow, my lord. I will collect the copy.
My lords.
If you are there in the court, you could have taken the copy. For that,
Yes,
why
no,
tomorrow again?
I will come, but kindly have it on tomorrow.
Because it
I
is,
will go.
again, we have to, we are, one more case is added to the list tomorrow. Land counsel for the petition is placed
Much
before the court.
obliged.
The
I'm sorry.
affidavit stating that he will not claim equities.
Please, filed.
And a copy of the same shall be served on the
I
counsel
will
for the
collect.
respondent list market tomorrow.
Please.
Much obliged.
Yes,
I'm sorry,
94.
madam.
94.
Your Lordship, in this matter, as per the order passed under Rule 28 and 27 and 28, Your Lordship, and there is appeal provision is also there. And as per the conditions laid down by the department, Your Lordship, he has to fulfill all the conditions. The tutor who has to be appointed, stay has been granted by this honorable court.
Counsel,
Please, Lordship. Short
agree with the
accommodation.
argument?
Lordship, senior is out of station, Lordship. Next week, Lordship.
Because as stay was granted by the
Stay in this.
earlier bench, Your Lordship.
Stay in this.
Please, Your Lordship.
Tomorrow.
Tomorrow.
No further time will be granted.
Please, Your
Day
Lordship.
after tomorrow, Lordship, please.
Day after tomorrow, no further
Please,
time.
please. Much.
Yes,
Please.
95.
Still number 95.
Cell number 95, my lord, I am appearing for the petitioner. The respondent is, my lord, the outsourced employee of the petitioner corporation. And imply, my lord, earlier she has filed the writ petition before this honorable court, seeking for, my lord, the regularization and also, my lord, continuation of her service in the corporation. That, my lord, the writ petition, my lord, your lordship may kindly send annex D, at page number 54. It is, my lord, already been dismissed. My lord, thereafter, my lord, she made a reference to, my lord,
On what ground it is dismissed?
my lord, dismissed on the ground, my lord, she is outsourced employee.
An employee of fourth
Yes.
respondent, she is the role of manpower supply was so and so.
Yes.
In the light of Uma Devi's judgment, they said you have no right.
My lord,
In the light of Uma Devi's judgment, you have no right seeking
yes, my lord,
regularization.
she is not having any right.
This order is not questioned.
No, this order is not questioned. My lord, it is questioned in writ appeal. Writ appeal is, my lord, it is still, my lord, it is in office objection compliance is only. Thereafter, my lord, she, my lord, invoked, my lord, the provisions of Industrial Disputes Act. My lord, without making her, my lord, the contractor as a party, she directly filed the case against, my lord, the petitioner corporation, wherein she has sought for regularization. Contrary to, my lord, the decision of this honorable court, my lord, now the labor court has passed an order for regularize her service in the petitioner corporation. My lord, it is,
Yesterday I filed the wakalat. Yesterday I filed the wakalat, Your Lordship. Weak recommendation to file the objection.
Stay is granted in
stay is not yet, my lord. In fact, now they are trying to, my lord, execute it.
The writ petition is filed by the corporation. Which respondent is this?
My lord, only one respondent.
The respondent herein has earlier filed a writ petition before this court seeking regularization of her services. That is WP number 147241 of 2020, and that came to be dismissed by this court by a coordinate bench of this court dated 5th September 2022, wherein the court has given a specific finding that as per the decision of the Honorable Apex Court in case of Secretary State of Karnataka and others versus Uma Devi, deported in 2006 4 SCC 1, the petitioner has no right to seek regularization of her services. And further, fourth, the corporation is of the opinion that her services are no longer required and has accordingly communicated to the same to the agency through which her services have been taken on contract basis, and there is no error in the same. It is a submission of the land council appearing for the corporation that now the respondent has raised the idea without making the agency as a party and sought for regularization by order impugned. The regularization is ordered. It is submitted that the order that is passed in this writ petition against that a writ appeal is filed, and the same is still under the office objections. Next, for considering the fact that already an order was passed in the writ petition that she is not entitled for regularization, without bringing this to the notice of the without making the agency as a party, and without bringing this to the notice of the industrial court, the present order is obtained. In that view of the matter, there shall be stay of all further proceedings. Motion to so and so.
Still number 96.
Admit, call for this post of
Please,
final
madam.
hearing.
96.
Please, my lords. The present petitioner is the father, my lords, challenging the interim order of maintenance of rupees 15,000. The respondent is the daughter, my lords. In the said order is given at page number 34, my lords. During the course of proceedings in the trial court, family court, my lords, the petitioner filed affidavit, my lords, assets and liability. The mother of the respondent, who is earning 2,25,000, my lords, she have not filed the affidavit, my lords.
How much is earning?
2,25,000, my lords.
What is your income?
My income is 85,000, my lords. I am having a dependence of aged father who is undergoing bypass surgery, my lords.
Pay half of it.
Yes, my lords. He's ready to pay till she appears and files the affidavit, my lords. At least interim order may kindly be granted, my lords.
On what ground? On
On
what
ground
condition?
that she have not filed in
Whatever
affidavit, my
it
lords.
is, that is not, you are the father. You have a
And-
responsibility towards
Please,
the child.
ex-
So it would be proportionate between both the parents.
Please, my lords.
So court has granted 15.
Please. Oh, and
What are, according to them, what is the expenditure of the child?
expenditure of the child, they are claiming 30,000, my lords. And they have placed the wrong submission before the trial court stating that she is living in Ballari, whereas she is staying in Bangalore with her mother in her own flat, my lords.
So for the petitioner submits that, when the mother is earning
25,000, my lords.
2,25,000 and the father is earning an amount of rupees
85,000, my lords.
85,000 per month, the court had directed the father to pay 15,000 per
15,
month.
please, my lords.
It is submitted that the mother has not filed her statement of assets and liabilities. Considering the fact that the income of the child, the expenditure of the child 30,000, considering income of both the parties, there shall be stay of all further proceedings on so and so on the condition that he shall continue to pay 10,000 per month by 5th of every succeeding month. And the arrears at 10,000 shall be paid within a period of 12 weeks from the date of receipt of the copy of the order. The petitioner shall take out hand summons on the counsel appearing before the trial court and shall file a memo to that effect by 19th of February. If the petitioner either fails to pay the amount as directed by the court, and the stay granted by the court stands vacated.
Okay.
Yes, next.
So 97, Sridhar Prabhu. 97.
My lord, this is electricity matter, my lord. Challenging the regulations passed by KARC. In a set of matters, my lord, coordinate bench has passed interim relief order. May
Who represents the respondent?
AGA for state.
Your Lordship,
Yes,
I
Comte
appear for the
for
respondent
R2.
number 3 and 4. I have instructions to appear on behalf of 3 and 4, Your Lordship.
You appear for whom?
Respondent number 3 and 4, Your Lordship, KPTCL and SLDC.
Who is the counsel for 3 and 4?
Shahbaz Hussain, Your Lordship, Shahbaz Hussain.
So and so.
Shahbaz Hussain.
3 and 4, it is submitted at the so and so as instructions to appear for 3 and 4. Then what about 5?
Of emergent notice for 5 and R2 it is BS Comte.
5 issue emergent notice. Then what about 1? AGA takes notice.
Please.
2 electricity
BS
regulator.
Comte, sir. BS Comte.
BS.
And so is directed to take notice. Let's just matter on.
My lord, interim order, my lord. Annexure C is the order we have challenged. One of any demand notices in furtherance of that order
You
to be
say
stated.
covered by judgment.
Yes,
Interim order is covered.
interim order is given in that. I've passed on the interim order at page number 3.
What do you say?
Your Lordship, similar orders are present in multiple cases, Your Lordship. We don't oppose to this interim order.
Yes.
Demand notices in further.
Order is passed in connected matters. That is WP number 15205 of 2025 in connected matters. Then counsel appearing for the respondent also does not dispute the fact. Hence, there shall be a direction pending disposal of this writ petition. The second respondent
Please.
shall not insist. How will the second respondent will insist? Regulatory Commission is insisting.
KRC
What
order.
respondent is he?
Third respondent, my lord.
Your Lordship.
Third respondent.
Third and fourth.
Third and fourth respondents are directed. Shall not insist for payment of money on monthly rateable proportionality as indicated in, which are the annexures?
Annexure C, my lord.
Annexure C.
Please, my
So
lord.
long as the petitioner pays a monthly amount continuously as per the old rates from April 2025 onwards till till the pendency of the writ petition.
Please.
Yes.
Obliged, Your Lordship.
Number 98,
Yes.
Umar KS.
My lords, challenging the extendment order at Annexure C, my lords, wherein the petitioner is directed to go to the Raibag, my lords, from the Bellary. He was charged for the offences punishable under section 78, subclause 3 of the Karnataka Police Act. All the offences are the non-cognizable offence, my lords. Annexure C is at the page number 21, my lords.
Passing the order dated 216 and so pass the second respondent. Order of externment.
Externment,
Yes.
not the order passed by
Against this,
appealable order under
the
section
government.
59 of the Act.
To the government.
To the
Have
government.
disposed of several matters of that nature.
Similar matters.
An order
my lords.
passed under
Yes,
56
similar-
or 7.
Similar orders, my lordship, pleased to pass on earlier occasions, my lords. Under section 59, there is a appeal provision under the, my lords, the Act.
The represented petition is filed seeking the following relief. An order is passed under section 56 by which respondent?
By the, my lords.
Second,
the
my lords.
Second,
By the second respondent.
yes.
Again, is this under section 59 of the Karnataka Police Act 1963, there is a right of appeal to the government within 30 days from the date of such order. When was this order passed?
My lords, 2/1/2000.
2026. Still you have time till February.
My lords,
22nd.
till then, stay may be granted, my lords, for that period.
Okay,
No
let
order.
me- when something is not maintainable, you can't pass an order. The petitioner, accordingly, the petition is disposed of in view of the right of appeal under 59. The petition is disposed of, giving liberty to the petitioner to file appeal under section 59 of the so and so accordingly disposed of.
Let's take notice for R1 and R2.
So and so takes notice for
99,
yes.
9900, urgent seal number 101. Srinivas Naik.
My lords, in my matter, even it is, writ petition is also maintainable, my lords.
So it is
Even-
that writ petition, then you have to make out that extraordinary grounds in spite of an availability of alternative remedy, why a writ petition has to be entertained. No, that is it's a bold proposition. In spite of an alternative remedy, writ petition is maintainable. How? On what grounds?
My lords,
Why
it
you
is
are not
covered by
going there?
judgment, my lords. Kindly pass over, I will.
Pass over.
produce, Please.
Possible.
That is settled law. For that, no, this thing is required. Why it is exceptional that it should come here? Why it is not an effective remedy? That you have to see. In fact, that should be stated in your petition. Because when you write in the writ petition, I have no other effective alternative remedy but to come before this court. In that you should write what is that extraordinary reason you are coming here. Yes, pass over.
Please.
Next. Pass over.
Yes. Srinivas Naik.
Lord, I am challenging the Lord entry of my name in the rowdy sheeter, covered by entry of my name in the rowdy sheeter.
We need to have objections from them.
Yes,
Yes, notice to the respondent. So and so,
Notice.
you take notice for all the
yes,
respondents.
all the respondents.
It's Leonard AGA takes notice for the respondent and shall file their objections. Lisses matter after 4 weeks.
4 weeks.
Yes, next.
102.
Lord, this
Srinivas
is, Lord, petitioner, Lord, is a society.
Hmm.
Not challenging them, Lord, remand order passed by the Lord appellate authority. Lord, on one count, Lord, the authority, Lord, the tribunal,
Who are all the respondents?
now first respondent is the contesting party.
Assistant Registrar of Cooperative Society.
No, he is the authority who has passed the order under section
Who
70
represents them?
on the government.
Yes.
R2, Lord,
Instructions. Please, get instructions. This is matter day after tomorrow.
Please.
Leonard,
It's easy.
so and so is directed to get instructions. Yes. Then on that day, we'll issue notice to the other parties.
may I just, Lord, request not to precipitate, Lord, after remand.
Tomorrow.
Yes,
Yes, we'll
in
have
the,
the
in the same
instructions.
stage, your Lordship,
Huh?
in the same
In the
stage,
same stage.
please,
Let it prepare in the same stage.
please. Great.
103. Hope Joshi.
Yes.
Amog,
Please. Challenging the annexure D, my lords, page number
Yes.
49, my lords. The present petition is petition number 1 and respondent number 1 is the sisters, my lords. They have purchased one property, my lords.
Issue a writ of mandamus directing the respondent number 5 to demarcate the share of the petitioners.
Please, my lords. This is
It is
DRT.
arising out of DRT proceedings.
Please, my lords. It's one submission, my lords. The present petitioner and respondent number 1 each.
In DRT proceedings, High Court will direct them to demarcate the land.
Please, my lords. Kindly see annexure D, my lords.
Issue a writ of certiorari cashing the paper publication.
I am not the
Directing
borrower, my
respondent
lords.
not to initiate any possession proceeding against the property till completion of the suit bearing number OS so and so.
I am not the borrower, my lords.
You are not the?
Borrower, my lords.
Uh,
The present petitioner, my lords, me and the present respondent number have purchased this property, my lords. The present respondent number 1 had colluded with the respondent number 2, my lords. They have got the GPA, my lords. I have not signed in GPA. The present respondent number 6 sub-registrar office of Ballari, my lords. They have created the GPA, my lords, and they sell the property to respondent number 3, my lords. They are the same while the respondent number 4 has purchased this property, my lords. The present respondent number 4 has mortgaged the deed in favor of the respondent number 5, my lords. The respondent number 5 is the
much water has flown. How can this court cure all these defects? And how can there be any adjudication can be done by this court?
yes.
You have to go before the appropriate forum.
My lords, the auction date is 3/2, my lords. Hence, I have taking stay, my lords. 3/2/2026, my lords.
How can the court say that too in DRT? Repeatedly, Supreme Court is saying that the High Court has no business to deal with all this.
Because I am not party in this case, my lord, since I am not borrower.
Oh, yeah, who is not a party can't go before the DRT.
Breathing time is granted. Auction date is 3/2/2026, my lord.
All are private parties.
Please. The sub-registrar officer is the second, respondent number 6, my lord.
Deputy General Manager, Karnataka Finance Corporation, Sub-Registrar Ballari.
No relief
And
against.
a direction to stay the auction.
Respondent number 5, my lord.
And you say, where is the relief? Where did you say one line that you have nothing to do? What you say? Directing the respondent to demarcate the share of the petitioner.
They have mentioned totally 20 shares, my lords. In that property, I have got 2 shares, my lords. Only that demarc share I have requesting, my lords. Kindly page number
When was
14.
the auction notification issued?
3/1/2025.
When did you come to know about this?
Recently, within 1 week, my lords. Kindly see annexure F, my lords. We have got Nakalu copy, my lords, and 2020 showing.
Then when you are the owner of as per the decree in OS, that is still pending.
Please, my lords.
It is not determined what is the share of who.
No, my lords. You have filed partition and separate possession in Ballari court, my lords. This allegation, my lords. Still, the name of the petition number 1 and response number 1 showing in the annexure F.
It is submitted that the petitioner is not a borrower, but the bank is auctioning the property. The auction may go on, but the result of the same shall be subject to the result of the writ petition. Issue emergent notice to all. You appear for whom, sub-registrar?
I take notice for R6.
6. AGA takes notice on behalf of respondent number 6. For all other respondents, issue emergent notice.
Much obliged.
Yes.
104.
The petition here is a recreation club, my lord.
Huh?
Recreation club. The respondent police authorities insisting the.
Yes. Any instructions?
Similar orders, my lords, please to pass in earlier case. Similar orders, my lords, please to pass in, my lords.
Have any instructions whether you are interfering, not interfering?
As per my instructions, we are not interfering.
The present writ petition is filed. Seeking the following relief. It is the case of the petitioner that the petitioner is running a social club that on 3rd week of December 2025, the law authorities visited the petitioner's club
and without any authority of law. They are insisting that the petitioner should obtain license either under the Karnataka Police Act or under the provisions of the licensing and How is it a similar order?
Please.
How? No, it is interference. No, you have a license or not?
Yes, under.
What license you have?
So under section, under Karnataka Society Registration Act, as per Annexure B, there is registration to run a
No,
social
when
club.
you're running a recreational club,
Yes, ma'am.
police, the license from them is not required.
Not necessary in Karnataka.
Yes, it is not required.
Not required.
Not required.
Not required.
Not required.
What are the activities?
Like as in page number 10, my lord.
Page number?
10, that is memorandum of association. Last line, my lord. Indoor games like shuttle, badminton, table tennis, chess, draughts, carom, rummy, and other skilled games.
Where are you getting that?
In page number 10, last para. Last para. That is a memorandum of association.
Indoor games like shuttle badminton, table tennis, chess,
Yes, that is indoor game. In outdoor game, that is B. To
rummy and other skilled games.
skilled game. Indoor games like ball, badminton, volleyball, football, hockey, tennis, coco, etc. As per memorandum of association. In case there is any illegal activity, then police have right to take any action under Karnataka Police Act.
What did you write? Petitioner should obtain license either in the Karnataka Police Act or in the provisions of licensing, public amusement order 1970 from police department for running the club. It is stated that the petitioners already have a license and it is registered under the society's registration act, and no separate permission is required as they are only they're running the indoor and outdoor games. In spite of that, the respondents are interfering with the same. Next, 11 HCA appearing on behalf of the petitioner of the respondent submits that the respondents are not interfering with any of the activities of the petitioner. They submitted that if any illegal activities are carried out, they have every liberty to approach the to visit the premises. He has relied on the it seemed like in the earlier order, so and so in WP number so and so the orders are passed. Same.
Much
after lunch. Any signatures?
My lord, the serial number 61 in admission, my lord. I have not been attended this.
Serial number?
61. In admission, that EP is filed. Company has challenged the liability. Due to inadvertent, I have not attended the 61. Interim order may be passed, stay application.
Interior to be passed the interim order, I should hear you.
At least day after tomorrow may be listed.
Yes, day after tomorrow.
Serial 61.
Yes, give it to the court officer, that number. Yes.
Lordship kindly seal number 14, my lord. Adjourned to 3-2, interim order is not extended.
Huh?
Seal number 14, adjourned to 3-2, my lord. Interim order is to be extended.
No, I think you were there when the matter is, you were not there.
I was there. It will adjourn to 3-2. By mistake, I have not mentioned interim extension.
Already interim order is there.
Yes,
If it is there, it will be extended.
Please.
Yes.
Submission, my lord. List number 2, my lord, as hearing number 19, the learned advocate is not keeping well, my lord.
But the difficulty is, I am repeatedly telling the advocates not to make a mention, because morning, that was a slot for making mentions. Look at it, whatever it is.
I am Mullah, 19. I am Mullah. Next.
City of Bangalore and other areas for which a commissioner has been appointed under section 7 of the commissioner and in other areas or areas to which the government may, by notification in the official gazette, extend the provision of this sanction to the district magistrate or the sub-divisional magistrate having jurisdiction and specially empowered by the government in that behalf, that the movement or acts of any person are causing or calculated to cause alarm, danger or harm to person or property, or that there are reasonable grounds for believing that such person is engaged or is about to be engaged in the commission of an offense involving force or violence or an offense punishable under chapter 12, 16, 17 of the Indian Penal Code, or in the abatement of any such offense, and when in the opinion of such officer witnesses are not willing to come forward to give evidence in public against such person by reason or apprehension on their. That is there, my lord. He has not committed any offense against a person,
Can't read
not a
that.
property.
No, A, B, C. What do you say about A?
That's what I mean. He has not committed against a person or any property, my lord. And no cases such registered.
Movements or acts of any person and causing or calculate to cause harm, danger to harm. What is the reason given? You must have passed a recent order.
No, my objection is not considered. That is what, my lord.
No. Let's see what is the reason for which he has passed an order. What did you say?
That's in page number 25.
20?
25. And particularly, my lords, column number 11, sorry, para number 9. That is in Kannada.
Yes.
So I will read and explain to my lordships. So and so, rounds ಮಾಡುತ್ತಾ ಜುಮ್ಮಾ ಮಸೀದಿ ಬೀದಿಗೆ ಹೋದಾಗ
Page number 20?
Page number, my lords, 25.
25.
25 of the, my lords,
Yes.
running page, my lords. And he was, my lords, making ಮಸೀದಿಗೆ ಹೋದಾಗ rowdy and he is working, my lords, behaving like a rowdy, and he was threatening the people. ಮುಂಬರದಿನ ಗಲಾಟೆ ಉಂಟು ಮಾಡಿ ಶಾಂತತೆಗೆ ಭಂಗ ಮಾಡಿ ಆಸ್ತಿ ಪಾಸ್ತಿ ಉಂಟು ಮಾಡುವಾಗ ಪ್ರಾಣ ಹಾನಿಯಾಗುವ ಸಂಭವ ಇರುತ್ತೆ ಎಂದು ತಿಳಿದು ಬಂದಿತ್ತು. ಈ ಬಗ್ಗೆ ಗುಪ್ತವಾಗಿ ಬಾತ್ಮೀದಾರ ವಿಚಾರಣೆ ಮಾಡಲು ಜನರು ಮಾಹಿತಿ ನೀಡಿದೆ ನಿಜವೆಂದು ತಿಳಿದು ಬಂದಿತ್ತು. ಠಾಣೆಯ ದಾಖಲಾತಿ ಪರಿಶೀಲಿಸಲು ಮೇಲ್ಕಂಡ ಪ್ರತಿವಾದಿ ಠಾಣೆಯ ರೌಡಿ ಶೀಟರ್ ಇದ್ದು ಈತನು ಹೀಗೆ ಬಿಟ್ಟಲ್ಲಿ ಮುಂಬರುವ ದಿನಗಳಲ್ಲಿ ಸದರಿ ಏರಿಯಾದಲ್ಲಿ ಗಲಾಟೆ ಮಾಡಿ ಸಾರ್ವಜನಿಕ ಭಯವನ್ನು ಮಾಡಿ ಸಾರ್ವಜನಿಕ ಶಾಂತತೆಗೆ ಭಂಗವನ್ನು ಉಂಟು ಮಾಡುವ ಸಂಭವ ಇರುವುದರಿಂದ ಆತನನ್ನು ಹೆಚ್ಚಿನ ಮಟ್ಟದಲ್ಲಿ ಬೆಳೆದು ಸನ್ನೆ ಅಪರಾಧವನ್ನು ಮಾಡುವ ಸಮಾಜಘಾತಕ ವ್ಯಕ್ತಿಯ ಸಂಭವ ಇದೆ ಎಂದು ತಿಳಿದು ಬಂದಿದೆ. This is the report, my lords, secured from the police, saying that he was, my lords, behaving like a rowdy and my lords, violating the peace and tranquility in the area. This is the reason, one of the reason. My lords, that is the, my lords, the section 55 explains. And moreover, he has been served with notice and he filed his explanation. And thereafter, my lords, appeal is under section 59 to the government. He can urge all these grounds before the appellate authority and get the orders, my lords. And he cannot bypass the, my lords, the procedure.
No, absolutely not, my lord, because no case is registered under IPC provision, my lord. It is only 78(3).
No, not necessarily. You please tell the court where it says that a case should have been registered against you. It doesn't say so.
It is not registered. That's even if he peruse the section 55 also, my lord.
No. First of all, please understand. Look at the act. What it says, an order can be passed under 55. For what? We read it. About to commit.
Yes. There is no.
No, they say, according to them, you are behaving in such an unruly manner, disturbing the peace and tranquility of a particular area. Further, they have relied on something. And if you say, and here the cases registered against you are not the concerns, are not the concern at all. So, when once an order is passed, any of your grounds are not considered, under 59 or 60,
59B.
59.
59.
you have an appeal.
Yes.
First of all, why did you not state in your affidavit, in your petition, that you have an effective alternative remedy? In spite of that, you are coming before the court because it is not efficacious.
Because
without that, how can a writ petition be maintained?
No, the reason, my lord, is completely, it's a fundamental right has been violated, my lord. His freedom has been curtailed, my lord.
That is true. No, you can come, but you should state so.
Based on only 78(3), my lord. Based on only 78(3), that is a completely petty offense, my lord. He has not been convicted also, my lord. Kindly peruse the section 56 also, my lord. He is not a convicted offender.
And it is not
They
required.
say that he is roaming,
it is not required, my
he
lord.
is roaming like a roadie shitter. That is completely, not even single complaint by any public person.
My lords,
It is on complete bias
55B
report.
space.
Yes.
55B specifically state that there are reasonable grounds for believing that such person is engaged or is about to engage in commission of the offense involving the force, violence, or offense punishable under the chapter so and so of the Indian Penal Code, or in the abatement of any of such offense, and when in the opinion of such officer, witnesses are not willing to come forward to give the evidence in public against such person by reason of apprehension.
It is the case of the petitioner that respondent number 2 has issued a notice on 28/10/2025 to the petitioner, mentioning that many cases are pending against him and an order of externment as per section 55A of the Karnataka Police Act will be passed, and ask him to reply for the same. The petitioner appeared before the authority and filed detailed objection dated 16/12/2025 stating that notice is not maintainable since, as per section 56 of the KP Act, the petitioner is not convicted of any offence. It is a case of the petitioner that without considering the same, the impugned order dated 2/1/2026 is passed. Land counsel appearing for the petitioner submits that the respondent number 2 has not applied his mind before passing the impugned order dated 2/1/2026 and has not considered the statement of objections filed with the petitioner herein. And according to the petitioner, the order is without following the due process of law and has abused the power. It is submitted that the respondent number 2 has deliberately violated the rights of the petitioner enshrined in the Constitution of India, and without considering all these aspects, the respondent number 2 has passed the impugned order dated 2/1/2026. When the AGA has raised an objection with regard to maintainability of the writ petition in the light of the alternative remedy available to the petitioner under section 59, Land counsel for the petitioner submits that when the citizens' fundamental rights are violated and the police, without even considering the objection that is raised on behalf of the petitioner, has passed an order, petitioner can approach this court, notwithstanding the fact that there is an appeal under section 59 of the Karnataka Police Act 1963. It is further submitted that as per section 57A of the
55. 55.
Yes. B, no offences are registered against the petitioner punishable under chapter 12, 14 or 16 of the IPC. As such, as no offences are pending against him, which are under these chapters, the police ought not to have, the second respondent ought not to have passed an order. It is submitted that the order that is passed is contrary to the provisions of, contrary to section 55. He has come before this court. And AGA, representing the respondent, submits that the petitioner was behaving in an unruly manner and disturbing the peace and tranquility in the locality, and basing on the report, the impugned order is passed. It is submitted that if the petitioner is aggrieved by this order, there is a remedy of appeal under section 59, and the petitioner has not able to say how it is not an efficacious remedy under section 59 to go before the government. Next para. Having got the counsels on either side, there is a material on record. According to the petitioner, there are no offences punishable under chapter 12, 14 or 7 or 17 of the IPC against the petitioner. This order that is passed by the second respondent is bad. Before considering the said submission of the Land Council, it is appropriate to look at section 54 as well. 54, 56, also 59. A bare perusal of section 55 of the Act, it doesn't refer to any of the crimes. It only says that the movements or acts of any person or causing
or calculated to cause harm, danger or harm to person or property, an order can be passed. When it comes to 55, it refers to the offences under the chapter. According to the petitioner, this order is passed under section 55A of the Act. If an order is passed under section 55A of the Act and the petitioner cannot raise the grounds that are enumerated under section 56. Now, when an order is passed by the second respondent, exercising the power under section 55A of the, not exercising power under section 55A of the Act, then a right of appeal lies to the government under section 59. In the entire affidavit, in the entire petition, the petitioner has not stated why a writ petition is filed in spite of an alternative remedy under section 59 of the Karnataka Police Act. In the considered opinion of this court, this is not the case where the court has to exercise a jurisdiction under Article 226 of the Constitution of India, though there is an alternative remedy available. No circumstances or have been placed before the court which warrants interference of this court under 226 of the Constitution of India. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy under section 59 of the Karnataka Police Act 1963 before the government.
I take notice for response. Huh? Take notice for response.
Yes. Is that passover matter, same order applies to you? Passover matter, what is that number? Give that.
Yes,
50?
98. 98.
If the conditions under the section 16 is not complied, then petition is maintainable.
What is that?
Coordinate.
That I have seen the judgment. What happened in your case? You tell not about that judgment. In your case, or what ground you are before this court?
My lords, like witness is not examined, my lords. Is not, my lords, as per the section 60 of the APF, my lords, they have to prove that witness is not ready to give the evidence, my lords. Here in this case, nothing is like that, my lords.
Now let us see, what did you say in your petition?
My lords, I agree that I have not mentioned anything about
no, basing on judgment, you will not get ground. You should be basing on your facts of your case. What is your ground to come before this court? Let us see, what did you say? Yeah. It is submitted that mere apprehension of the police is not enough for passing an order of externment. As equate for making the order of, there must be a clear and present danger based upon which makes a movement and acts of the person in question alarming or dangerous. What did they say? Please come to the order. Yes, Mr. AGA, what does the order say?
My lords, section 55(2)(b) is very clear. Mere apprehension is sufficient. And behaving like a my lords rowdy.
What did he say in this?
Please, in this case, my lords.
Page number 13, I think.
Please, 13 is the my lords.
Page number 26.
Last para, my lords. Last para. Sadri ಡಿ ಮಲ್ಲಿಕಾರ್ಜುನ್ ತಂದೆ ಮಲ್ಲಪ್ಪ ತನ್ನ ಜೂಜಾಟದ ಚಟುವಟಿಕೆಗಳಿಗೆ ಅಕ್ರಮವಾಗಿ ಗುಂಪನ್ನು ಕಟ್ಟಿಕೊಂಡು my lord, for the purpose of my lords the run the matka, he was engaged in my lords the unlawful assembly and used to my lords roam around the area and used to my lords threat the people. ಸದರಿ ಮಲ್ಲಿಕಾರ್ಜುನ್ ತಂದೆ ಡಿ ಮಲ್ಲಪ್ಪ ತನ್ನ ಜುಜಾಟದ ಚಟುವಟಿಕೆಗಳ ಅಕ್ರಮವಾಗಿ ಗುಂಪನ್ನು ಕಟ್ಟಿಕೊಂಡು ರೂಢಿಗತ ಅಪರಾಧವೆಸಗುವ ಪ್ರವೃತ್ತಿಯಲ್ಲಿ ತೊಡಗಿರುತ್ತಾನೆ. ಪ್ರಚಲಿತ ಜಾರಿಯಲ್ಲಿರುವ ಕಾಯ್ದೆ ವ್ಯವಸ್ಥೆಯಲ್ಲಿ ಸದರಿ ಎದುರುದಾರನ ನಿರಂಕುಶ ಸಮಾಜ ವಿರೋಧಿ ಚಟುವಟಿಕೆಗಳನ್ನು ಪೊಲೀಸ್ ಕಾಯ್ದೆಯಿಂದ ನಿಯಂತ್ರಿಸುವುದು ಕಷ್ಟ ಸಾಧ್ಯವಾಗಿರುತ್ತದೆ. ಸದರಿಯವರನ್ನ ಕಾನೂನು ಬಾಹಿರ ಚಟುವಟಿಕೆ ನಿಯಂತ್ರಿಸಲು ಅಸಾಧ್ಯವಾಗಿರುತ್ತದೆ. ಕಾರಣ ಇವನ ಮೇಲೆ ಅಂಡರ್ ಸೆಕ್ಷನ್ 55A it is an order passed, my lords. Since In order to run his the Mataka business, he used to form unlawful assembly and to engaged in the in that activities That is in page number 14. That is last para of the reasoning.
Well, you're relying on 60. 60 will come into play after the appeal.
Yes, 60 comes to only after the appeal is over.
60 will come into play after 59.
Please, my
59
lords.
is the appeal
My lords,
version.
may I pass on one judgment, my
And look
lords?
at it. Pass on.
Good evening.
My lords, para 7 may kindly be seen, my lords.
1 minute.
For the same offence, my lord, 78 subclause 3.
No, that is what is, this refers to your, an order is passed under section 56 or 55A, no, the 55A or 56.
55A, my lords.
And then this is all refers to this, all the offences and all, you will find it in 56.
My lords, even though 59 appeal is available, my lords, under section 59.
But I'm
but
not done the appeal, I'm saying this is an order passed under 55A.
Please, my
That
lords.
the moment of acts of any person or causing or calculating to cause harm, danger or so and so. Now what you are referring to, this order is pertaining to 56. Removal of persons convicted of certain offences.
Please.
The present petition is filed. Agreed with the is filed. Seeking seeking the following relief. The petitioner is accused for having committed offences punishable under 78(3) of the KPD Act, and several cases were registered against him for same offences. Hence, the respondent has made recommendation for externment order. Even that is also not extracted in this writ petition. Why order is passed against you? What he has read now and what you have stated here is not one and the same. Several cases for externment order against the petitioner for preventing antisocial activities and to maintain peace. Based on the same, the second respondent has issued the notice to the petitioner directing the petitioner to appear before the authority on 11/11/2025. Pursuant to the notice dated 28/10/2025, they appeared before the second respondent authority and filed the objection. The second respondent, by order dated 2/1/2026, has passed an order of externment, and that the second respondent has reason to believe that the petition is involved gambling of cases, and that on the basis of the information collected to police officer, it is found that the petition has continued with the matka gambling, and the act of the petitioner are detrimental to the public order, and also there is a possibility that petitioner will disturb the public peace. It is stated that on the report of the second respondent, the third respondent passed an order of exturning the petitioner from the limits of Ballari to Raibagh Police Station, Belgavi, for a period of 3 months, that is from 2/1/2026 to 1/4/2026. It is the contention of the petitioner that apprehension of the police itself is not enough for passing the order of externment. The respondents have not produced necessary documents while issuing notice. The report showing that petition is dangerous to the public and is causing the abatement with respect to playing of gambling is not, the documents are not produced by the respondent. It is stated that total 8 cases were registered against the petitioner, but offences punishable under section 78(3) of the KP Act, and out of that 8 cases, 6 cases are closed and only 2 cases were at criminals were pending. In 6 cases, the petitioner has paid the fine amount, and on all those offences are non-cognizable offences. It is stated that this court in case of Shankar versus Athini versus Shankar versus State of Karnataka, arising out of which petition?
Arising
That
out
is not
of
required.
criminal petition
It is submitted
101340.
it is submitted that the court, the externment order is without any basis and contrary to the provisions of the Karnataka Police Act. Learned HE representing the respondent submits that the court had rightly, submits that the second respondent giving reasons have passed an order of externment stating that the petitioner is involved in the activity of gambling and is continuing to do so, which is not in the interest of the, he is disturbing the peace and tranquility of the place. He submits that apprehension is sufficient. And further, if in the order that is passed is bad, he could have filed an appeal under section 59 of the KP Act. It is further submitted that the order that is impugned in this case is a well-reasoned order. Next para. Same like earlier one. You have taken or you have only taken before this? So extract all the provisions in the light of the above. The petitioner has an effective alternative remedy under section 59.
My lords,
I take notice for order.
some protection may be given, my lords, until the appeal is preferred, my lords. My lords, coordinate bench of this court has granted the protection, my lords.
Coordinate bench grant.
I take notice for respondents.
So,
My lord, serial number 76, password matters.
password matter is not called now. It's only that matter. Yes, next.
109, this is Jnana Swami.
This is also same,
Similar.
similar offense, KP Act.
Same matter.
until-
The writ petition is filed seeking the following prayer.
Until the Millers filing the appeal before the Millers.
You should have gone. Why should we interfere in that? You have a remedy.
Already he has
Put
extended from the Millers, Ballari city.
The writ petition is not maintainable. Why should we grant an interim order? So and so, the writ petition is filed seeking the following prayer. The petition is before this court questioning an order passed by the second respondent. Whereby the second respondent is passed an order of externment. Where from where to where? Where do you get that?
From Ballari to Millers, Hiriyur, Chitradurga
Where do
district.
you get? Where did you say so in your petition?
So the synopsis, page number 1. Third column.
2126.
From Ballari to Hiriyura rural PS area for a period of 3 months. All contentions with regard to the same. Yes, next.
Not 10.
In this case, take notice.
In all the matters it will
Please.
come. Yes, 110.
110.
No representation.
Allapura.
This in the month of March. Yes.
111.
Submission.
Sundappa Mali.
Will appear for petitioner's counsel in this matter.
Memo farmers, interning of documents before the years. Anybody be given minutes.
Which matter?
Certificate, 109, Muro Mata.
Oh, entire document. And what do you want?
Certificate copies of minutes to file appeal before the.
Immediately. These two orders, today itself, those shall be uploaded. Earlier matter, tell them in all these 4 matters, 108, 109, in all the matters, the document shall be returned.
Please.
Yes. You will get the order by today itself.
Please.
111 mullahs. Plus senior is
I appear for-
111.
111.
I appear for
Yes.
petitioner's counsel, my lord. No, this is a
Yes.
case where your factory has commenced discretionary operations. But by the release orders, monthly release orders of the Union of India, it is not able to make the payment to the farmers, and it has to discharge the financial obligation to the farmers within 14 days from the date of supply of sugarcane. And now, as on today, it is almost 200 crores outstanding dues to the farmers.
Switch on this.
but around 200 crores is outstanding as on today. Is unable to liquidate the stocks and then pay the farmers. But in identical cases, this honorable court has granted and
We're
permitted.
questioning clause number 5, 7 and 10 of the
My lord,
control order.
that may not be considered at the present, my lord. I am only requesting my lords for an interim prayer, only to permit me to sell and to discharge the.
No, unless we understand what is this order, what is the main prayer, we can't grant the interim prayer.
Please, my lord, I will take your lordship to. Kindly see the sugar control order. It says there is an embargo to sell the sugar unless until there is a permission by the Union of India. Page 159, annexure K. That is a sugar control order 2020.
161.
My lord, your lordship will see that 161, class 6.
Who appears for the respondent? Union of India? Who appears?
Union of India.
MB Kanvi. MB Kanvi.
MB, so-and-so is directed to take notice on behalf of both the respondents.
Please.
This is matter tomorrow.
Please.
In the name of so-and-so. Given the papers.
Already given, Mullards.
Tomorrow,
Sir,
let
please.
it come. I'll hear it in past orders tomorrow.
Please, Mullards. Plus
Let-
in
let-
preliminary
let
hearing
it-
list. Matter preliminary hearing list, Mullards. Matter to be listed in preliminary hearing list.
Yes.
Please.
Yes,
Please.
next.
Contentor,
Obliged.
Girish Dharwad.
Lord, petitioner before my lords is the plaintiff who has instituted the suit seeking, my lord, permanent injunction against respondent. But the suit claim is that, my lord, abutting the plaintiff's property, there was a road, which, my lord, was handed over to the panchayat by the plaintiff himself for the purpose of general public for usage, and a resolution to that effect was passed. But after completion of evidence, the application came to be filed seeking appointment of court commissioner. That was allowed. Court commissioner was appointed, my lord, he conducted survey, but he filed an erroneous report according to the plaintiff. Therefore, my lord, the plaintiff filed objections to the report, sought for, my lord, reappointment or redirection to, my lord, conduct fresh survey, and also filed an application seeking examination of the court commissioner. During his examination, my lord, certain irregularities in his report were pointed out. Thereafter, my lord, the trial court, instead of, my lord, proceeding with the main matter, but hears the matter on the report submitted by the court commissioner midway during the trial, and, my lord, passes the impugned order, holding that, my lord, the report of the court commissioner is accepted. That is what is questioned before this honorable court. My lords, the order starts from page 50 and operative portion, my lord, on page 54. Now, primary submission, my lord, for my lordship's consideration is, my lord, this procedure, my lord, is not known to law, because along with all other material, if the trial court wanted to consider, it had to consider at the time of, my lord, passing the judgment. Court commissioner's report in isolation could not have been either accepted or refused by the trial court midway during the trial. That is the position, my lord, it has been considered.
What is the prejudice now if it is?
Prejudice is, my lord, this report is prima facie against me now, but he says there is no encroachment. And now, my lord, the trial court, by passing this order, my lord, has already been prejudiced, my lord, against me. Before, my lord, dismissing my suit, my lord,
What is the stage now?
no, stage is for arguments. Now, there are other materials which I have placed before the trial court to show that, my lord, there is a road. I have produced the resolution, I have produced hand sketch map and all other materials.
What I'm not able to understand is
Yes.
giving a finding on the commissioner business report. What is the?
Now, my lord, the trial
same
court,
thing- The same thing they will do. at
no, my
later
lord, the
point
trial
of
court
time.
ought to have discarded this report and ought to have redirected for, my lord, fresh commission work in view of, my lord, his examination. He says, my lord, though he notes the resolution passed by the Gram Panchayat, he says, I did not measure the road.
That's why what I'm saying is you have to argue on the merits of this, not that
Yeah.
the court has passed an order at this stage. It
No,
should
but
be kept it,
operative portion may kindly be seen what the court says, my lord. It says, my lord, page 53,
Yes.
the object, therefore, last line, my lord, therefore, objections raised by the learned counsel for plaintiff is not acceptable one. Accordingly, commissioner report submitted by the Taluka surveyor is accepted. Now, my lords may kindly see my objections, which I have filed to the court commissioner's report.
Did you read, where are you reading?
Page 53, my lords.
53?
53, 50,
No, let's see, let's read the order.
yes, yes. Ma'am.
The present suit is filed by the plaintiff, I think from 52.
But
we
that
can
is
read.
all, my lord, the earlier application and allowing of it, my lord. From page 51, second paragraph, on due perusal.
Court has given you enough opportunity when you're objecting.
Yes,
He
ma'am.
was called, he was summoned, examined.
Examined. Now, during his examination,
Come to this, on due perusal of
yes,
I
ma'am.
number
On
2.
due perusal of file number 11, it appears that the said application was filed by counsel for plaintiff for seeking the relief of appointment of commissioner to measure the suit property and public road in suit property and ascertaining the alleged encroachment made by defendant number 1 in the suit road. Accordingly, as per the commissioner warrant, Taluka surveyor has been went to the suit property after issuance of notice to the plaintiff and defendants. On perusal of cross-examination of CW1, it appears that counsel for plaintiff not disputed the fact that issuance of prior notice by the Taluka surveyor to plaintiff and defendants and statements given by plaintiff and defendants and their signature obtained by Taluka surveyor during commission work. But specific defense of the counsel for plaintiff is that Taluka surveyor has not conducted the survey as per memo of instructions given by the plaintiff and not measured the defendant number 1 house property. Therefore, he has contended that said commissioner report is not legally acceptable one. However, the present suit is filed by the plaintiff for seeking relief of permanent injunction against the defendant number 1 and mandatory injunction stating that defendant number 1 has encroached the 9 into 20 feet public road which is situated in suit property, therefore which shall be removed through mandatory injunction. Accordingly, predecessor of this court framed issues as that whether the plaintiff proves that he is in lawful possession and enjoyment of the suit property and alleged interference by the defendant number 1 and alleged encroachment by defendant number 1 in the suit property. Therefore, this fact has to be proved by the plaintiff through cogent evidence. However, plaintiff has filed I number 1 for seeks the court assistance for obtaining measurement report from Taluka surveyor, and this court also appointed Taluka surveyor, and he has specifically mentioned in the report as that there is no encroachment by the defendant number 1 in the suit property of the plaintiff. Accordingly, when the said report submitted against the version of the plaintiff, the counsel for plaintiff unnecessarily raised his objection and elaborately cross-examining the CW1. But in present case, this court has to be decide that whether the plaintiff is in lawful possession and enjoyment of the suit property and whether the defendant number 1 interfering the possession of plaintiff by encroached the 9 into 20 feet public road which is situated in the suit property. Accordingly, these are disputed facts in the case. Therefore, for considering these facts, the commissioner report submitted by the Taluka surveyor is sufficient and it is not necessary to measure the property of the defendant number 1 as contended by the counsel for plaintiff, and further this court has not found any irregularities in the court commissioner report. Therefore, objections raised by the learned counsel for plaintiff is not acceptable one. Accordingly, commissioner report submitted by the Taluka surveyor is accepted. My very application for appointment of court commissioner was to measure my property, his house property and the public road. Now in his examination,
So what is that order passed by the court?
that is also what I have put. The court passed, allowed my application, or this is the copy of my application. What I requested is more to measure all the properties.
Where is it allowed?
22/8/2019,
You filed that order?
It is here. I have a certified copy. I just got it there for I could not. May I pass on the relevant portion of the order? This is in manuscript. I'll read and then pass on. Plaintiff present, defendant present. Counsel for plaintiff filed I number 11 under 26 rule 9 for appointment of jurisdictional Taluka surveyor for the measurement to know the availability of the actual facts and location. Counsel for defendant submits that he has no objection for allowing the application. Perused and heard. In my opinion, if the Taluka surveyor is appointed, then there may be disposal as satisfactory and the said prayer is just and supporting document to the suit, and both plaintiff in the suit it is necessary appointment. Hence, the Taluka surveyor is appointed and with the assistance of so and so.
The petition is before this court. Brief with the orders passed and agree with the order dated 12/1/2026, whereby the court had accepted the Taluka surveyor's report. Then counsel for the petition submits that when the plaintiff has raised objection to the surveyor's report and the fact that the same was done contrary to the order passed by the court in I number 2, where he sought for the survey. He sought for the appointment of the commissioner to measure the land of the plaintiff as well as the defendant, and to measure the public road as per the resolution passed by the Gram Panchayat dated 25/7/2022. Now the court had accepted the surveyor's report stating that it is not necessary to measure the property of the defendant number 1. It is submitted that the said order goes contrary to the warrant issued by the court, and where the defendant's house also has to be measured. Considering the sufficient, there shall be stay of all further proceeding pursuant to so and so. Same memo, we shall take out hand summons and file a memo by 23rd of February, or else the stay granted by this court stands vacated.
Please. I shall place that application and order typed copy along with the memo, my lords.
Yes.
Please. Great.
In the hearing, B group matters 113. Chetan Munwali.
I'm seeking for a mandamus to issue Millards the signed receipts for having supplied the materials and for Millards clearing the bill. The petitioner is Millards a transport company, which was,
Of 2016.
That's one
please,
submission, my lords.
this Millards,
That's last occasion, my lords. There was a direction to secure the, my lords, the inward book, my lords, to the, my lords, the AGA. My lords, since the records are with the, my lords, respondent number 2 and 3. My lords, the records are not with the Deputy Commissioner's office.
Have you filed your objections to the writ petition?
Objections are filed, my lords.
Filed?
Filed.
So you must have met to their, whatever their amendments in the writ petition, you must have answered to that.
Yes.
So what is your case?
My lords, the what they are seeking is, my lords, they have supplied August 2011 some articles to, my lords, the respondent number 2 and 3. They have lost, and they are seeking the direction to, my lords, kindly see the prayer, my lords. If you are writ of mandamus or any other writ order or direction directing the respondent number 1 and 3 to issue receipts for
having received the materials
having
for the
received
month of-
the materials for the
Who are
month
the
of August
respondents?
2011.
all government.
Food and Civil Supplies Limited.
Yes.
Hmm.
Respondent number 2 and 3 are the, my lords, the corporation, my lords, and they have been served and they are unrepresented. And records are with the, my lords, the respondent number 3.
That may not be necessary in view of my memo file, Millards. I have received that inward copies.
Who appears for the third respondent?
My lords, served and unrepresented. With the
Who appears? There are no panel counsels. for
panel
that.
advocates are there, my lords.
Then why their name is not printed till now in the writ petition of 2016?
Food Corporation.
Good call.
So and so is directed to take notice on behalf of R3. What is the name?
Find out, yeah, find out.
What is the name? कुछ पता कि उसका नाम लिखो. List, print his name. List this matter on Tuesday.
ಹೇಳ್ಬಿಟ್ಟು ಕೊಡ್ತೇನೆ, ಗೊತ್ತಿಲ್ಲ.
Favorite.
Yes.
114. In Hosmane.
Please. The petitioner, corporation is challenging the order passed by industrial tribunal, order passed by labor code, and setting aside the punishment order passed against the respondent.
Memo is moved for this.
Since because he is retired from the service. He is retired from the service, respondent is retired from the service. Now there is an incremental order is reduced. Now labor court has set aside that order. Tendency of this writ petition, my lord, the calculation of his gratuity and final settlement that has been sort of disturbed. Therefore, my lord, this matter is moved. It was a conductor.
Take it some other day.
Date may be.
Matter on
Date may be.
17th of February.
Please.
Yes, 115.
115. Jagdish Pat. Already action.
Week's time, my lord. Week's time.
Who moved the memo?
You know, the urgency is, my lord, I am the purchaser of the particular land, my lord. After purchase of land, my lord, they filed the writ petition seeking following relief, my lord. This is in civil nature. No, what they say that the particular land is already registered, they hold the agreement, but they have not paid any amount. But I have purchased the land in the January 2024, my lord, from the respond number 4 to 6, 7, my lord. Kindly see the prayer, my lord, page number 40. Issue a writ of order and direction in the nature of mandamus directing the respond number 2 to stop any further alienation or creation of any third party rights in the suit
Who
property.
is the second respondent? The sub-registrar.
Sub-registrar. And my name is entered by virtue of the said deed, my lord. That is income certificate, the produced at page number 113.
How can such a direction be issued by this court?
Next week, my lord, next week.
No, next week.
I do not have the.
Ask your concern. You are the one or your?
No, no.
This is matter on Tuesday as part heard.
Prayer is also not maintained. Prayer is also not maintained.
That's what, but an interim order is granted, which is running from 2024.
Tuesday. Third.
Yes.
116. 116.
Lordship, this is
Raj.
a petition filed by the victim of an online scam. Just a gist of the petition is, Your Lordship, I am a retired banker. After my retirement, my money was embezzled by some miscreants by giving an ad on Facebook regarding investment in online trading. I lost 73 lakhs odd, Your
Have
Lordship.
an interim order in this.
Please, Your Lordship.
Why did you move the memo then?
Now my urgency is, the petitioner is 70 odd and his entire funds are blocked, Your Lordship. For his even daily survival, it is a bit difficult. Now 35 lakhs have been recovered by the IO in my case. Now, if I may take Your Lordships to FIR and complaint at annexure A and B, which start from page 10, Your Lordship.
Issue a writ of mandamus directing the respondents to defreeze the accounts of the petitioner. With the respondent number 1.
My banker, Your Lordship, the bank in which I hold.
Why your account is freezed?
Now, Your Lordship. Now, on communication by respondent 1 and 2, just to bring facts, Your Lordship, to this honorable court. I lost my money. I registered an FIR, and in that case, 35 lakhs were recovered from the investigating officer in my case. Now, on the basis of orders at annexure E and F passed by the JMFC Hubballi, Your Lordship, part amount was recovered, and that money was transferred to my account by the order of the honorable JMFC. Now, after the money was deposited in my account, I was informed that an FIR was registered before by respondent 4, 5, and 6. 4 is West Bengal, 5 is New Delhi, and 6 is Uttar Pradesh. Now, I was informed that these 3 people have registered an FIR against the same accused in my case, the case in where I have registered an FIR. And the court, before some courts in respondent 4, 5, and 6 states have directed my bank to create a lien on the amount which was transferred to my account by an order of the honorable JMFC. Now, when that was created,
For the bank.
Lords, I appear for respondent number.
How can you accede to that request when you are doing something on the order of a court?
Lords, the subsequent freezing of his account.
To have an order from the court, is it not?
Please, my lords. Lords,
I can understand there is no court order.
Please.
You have received from the police some information with regard to this. You are doing it, I can understand. Now, in his case, that money is recovered and an order is passed by the court. Accordingly, the money is deposited in his account. How can you freeze it now?
Subsequent freezing, my lords, is also on. Well, I'll verify that, my lords. May have it in 2 days' time. My lords, get the documents on what basis if there was a court order, because several complaints was filed against this particular accused, who has, my lords, embezzled a huge amount of money. So now, if there is, my lords, this 35 lakhs that was ordered to be released to him was also proceeds of that crime, which is, my lords, a part of.
What happened to his money? How much money he lost?
But that, my lords, the investigating. Yes, part of the investigation, my lords, the criminal case is pending. I'll, my lords, ascertain on what basis, my lords, this subsequent freezing of his account, because that is also, as far as my.
One more thing, what you have to look at is,
Please.
Is it permissible? Basing on a court's order, when a particular thing, you can always tell the concerned
Please.
the investigating agency, get appropriate orders from the court.
But I'll very, please.
You can't do it, and you can't, already he is a victim. I mean, he has lost.
One
his,
of the victims, that is, my lords, the problem,
and
because
again you are making him further,
I'll, my lords, I'll ascertain on if there is any other court order, my lords.
on Wednesday,
Please.
as partnered.
Obliged.
Four, sorry.
Yes.
117. Sharad Malgoda Patil, Chetan Munwali.
Lordship, we need to withdraw. We have filed memo for withdrawal.
Your
Memo for withdrawal, Your Lordship.
it is, a memo is filed stating that the petitioner is not interested to prosecute the matter. Accordingly dismissed as withdrawn.
Yes, sir.
Memo is taken on record. Is 118.
118. Abhishek C. Patil. Avinash Pankar. Avinash Angadi.
For the respondent, my lord.
Lords, petitioner counsel has some personal inconvenience. May I request for tomorrow, my lords?
Lord, this
It might not be possible. Already there are so many matters to.
This matter is with respect to admissions of the Ayurvedic Medical College.
Yeah, on the basis of interim order, my lord.
Let's this matter on Tuesday.
Please.
This 119.
119. Sachidanand Babaji.
My lord, husband filed a divorce petition. In that, an IA under section 24 of the Hindu Marriage Act has come to be filed by the wife. Now that is allowed, and sum of 18,000 rupees has been ordered from the date of application till the date of petition.
Your income,
My lord, my in-hand salary is around 65,000.
65,000.
75,000.
How much the court has granted?
18,000, my lords.
What is wrong in it?
My lords,
What is wrong in it?
my lords, I also had I had taken some loans, my lord, hand loans, and my family
Whatever it is,
expenses also.
How much percentage is 80,000 of 65,000?
So it is small, my lord, since she is also well qualified and
And
she
is
is,
she earning? Is she earning?
my lord, at that point of time she was not earning. She has completed her graduation in law as well, my lords. After a year about marriage, she has herself has deserted me due to cruelty and suicidal attempts.
It's all not the consideration and an application under 24.
Please,
You are having enough income. She is not having income.
As
And
on,
what the
please.
court has granted, how much? 60? What did you say your income is?
My lords, in hand it is around 65,000, my lords. 80,000 is the salary. In hand after deductions, I'd get around 65,000.
25% of your salary.
Please, my lord. It's a little on a higher side. I agree that I have to take care of my wife, my lords, but since it is on a little higher side, I request some leniency from the court.
25% is what we generally do.
Please.
You said 17,000.
My lords,
17,000 is granted.
my lord, no, 18,000, 1/8.
Daughter is there.
There is
Daughter is also there.
there is a minor daughter, my lords. Daughter,
She
and
has sold.
12,000 plus 6,000 is awarded. Because the place where the respondent is staying,
We can't interfere. That's a basic thing for two people to survive.
my lord, the place where they are staying, the standard of expenses in that particular village are,
Don't forget about where they are staying.
Please.
Two people with 18,000, how can they live? Child has to go to the school.
Please.
That has to be taken care of. Minimum with 3,000-4,000 rent. That is a very bare minimum expenses.
Please.
The agreed with the order passed in I number 1 in MC number 79 of 2023 dated 5th July 2025 by so and so, whereby the court had granted maintenance of an amount of rupees 12,000 to the wife and 6,000 to the daughter. The husband is before this court. Parties are referred to as wife and husband for the sake of convenience. The wife has filed who has filed the MC?
My lords, I had filed a divorce.
Husband has filed the MC seeking maintenance. Wife had filed the IA under section 24 seeking maintenance of an amount of rupees
25,000.
25,000 per month. The court by order impugned had granted 18,000. While granting the maintenance, the court has observed that it's a duty of the husband to provide good health, wealth, education and a shelter to the wife and the child. Further, the petitioner, the husband is a government employee and he is having handsome salary since he is a class 2 officer. And in the affidavit, he himself stated that he getting monthly income of rupees 80,000. No doubt, he has a duty to take care of his parents, but he cannot escape from his liability to maintain his wife and the daughter. The court also observes that the wife is not having any source of income and the daughter is studying. Both the daughter and the mother require financial assistance to maintain themselves, and the husband is duty bound to provide financial assistance. Accordingly, the maintenance is granted. Then counsel for the petition submits that the wife is well educated. In spite of that, she is not working. Further, the husband is having his he is having other responsibilities to take care of the parents, and all these issues were not considered by the court. And the amount of maintenance of an amount of 18,000 that is awarded is on the higher side. Next para. Learned counsel appearing for the respondent submits that when the husband is earning 80,000, what the court has awarded is only 18,000, and there is no illegality with the said order, and there are no grounds to interfere. Next, having heard the counsels on either side, produce the material on record. The undisputed facts are the husband's income is 80,000. The wife is unemployed, though educated. Both the wife and the daughter have to, it's a responsibility of the husband to take care of both of them, considering the fact that they have no income. Considering the income of 80,000, the court had granted 12,000 to the wife and 6,000 to the daughter. In the considered opinion of this court, the said amount granted as maintenance is a reasonable amount, and there are no grounds to interfere. Accordingly dismissed. Yes, next.
Great.
120.
Maladi, 120.1. Maladi, I have been instructed to appear, my lord. I need some short accommodation.
Submission. Kindly pass on once. ASU will appear. ASU will appear in this case.
What is this matter about?
But this is regarding appointment of Maladi, heredity Archaka. Declaration
So
that
far as
my
20.1 is concerned.
heredity Archaka. Maladi.
So far as 20.1 is concerned, Lords, I am the hereditary trustee. I am so declared by Lords, a competent court of law, Lords, almost Lords, half a century ago. I am impugning before your ladyship, Lords, the order passed by Lords, the executive officer, purporting to be passing the order Lords, under section 25B of Lords, the Hindu Religious and Charitable Endowments Act, thereby appointing Lords, the contesting respondent as a hereditary archaka, hereditary priest, which in my humble submission, my lords, is not permissible on two grounds, my lords. One, my lords, I being, my lords, the temple in question, though is notified, my lords, is being managed by, my lords, a hereditary trustee. I have been declared as a hereditary trustee, my lords, by a competent court of law. When a temple, where, my lords, there is a hereditary trustee, my lords, section 25A, my lords, would come into operation, which says that, my lords, there would be no management committee, my lords, insofar as the hereditary trustee himself would, my lords, be the managing authority for the temple. That being the case, my lords, the executive officer, my lords, would have no jurisdiction to appoint, my lords, any person, much less, my lords, hereditary archaka, as my lords having been appointed in this. And my lords, on the merits of the matter,
No, whether this institution is a public institution or a private institution.
it's a notified institution.
Notified institution. Endowment department has its control over the affairs of it, because you're declared as a hereditary trustee. There won't be a trust board. There won't be a trust board to that institution. But otherwise, other affairs, you in consultation with the
Certainly.
other person, you have to do it.
I have to.
So, what is your difficulty? Hereditary archaka works in a different domain than a trustee.
Certainly, my lords. I'm not saying that, my lords, instead of me, my lords, he's been appointed as the hereditary
No,
trustee.
you says that they have no business to appoint. Why
Yes.
not?
But it's because the executive officer would cease ballots to have ballots the jurisdiction to appoint any person as hereditary Archaka. Under 25A, ballots, it would be ballots, I would be ballots, I would be having the authority ballots to do so.
No, in a notified institution.
In a
Malord,
notified institution.
executive officer is not appointed me, my lord. I will make a submission. I need some short accommodation, my lord.
When do you want?
My lord, any day convenient, madam, Monday or Tuesday, my lord.
Yes, Wednesday we'll have it.
Please.
That's one request. So for 120 is concerned, let there be a direction for them to produce the original record because there is a tampering of the impugned order itself.
They have not filed their objections.
No, they have not filed the objections. Let them secure the original records. I can point out that the impugned order which is furnished to us bears altogether a different signature than what is furnished under the right to information.
We will get the original records.
Which respondent you appear?
A week's time will be given so that I will.
That's easy, easy for
He appears for?
AG, additional
AG.
advocate general.
AG.
The AG seeks time to produce the original record pertaining to both the writ petitions or only one?
120.
Pertaining to 120.
Yes.
Pertaining to WP 106,994 of 2025. In 120.1, at the request of R5.
Please, R5.
R5, list both these matters on 16th February.
So one more request, if I may, lords. May I request the matters to be listed in preliminary hearing so that.
Let everybody,
Please.
everything will happen. It's difficult, yes.
Please, ballots. Because ballots, the fairs are ballots fast approaching. So ballots, the ballots Chatra is fast approaching.
When is that?
Ballots, I believe ballots 29th or onwards ballots. It's already commenced ballots. So.
Because they have to get the records, that's the whole thing. Only for hearing, I can hear it. Because they have to get the records, that's why I'm granting time.
Please.
This is a matter on 10th February.
Please, highly obliged. Read.
Yes.
120.1.
It's a matter pertaining to the reissue.
It's coming up on 10th. He's asking.
Please.
Advocate is asking, tell him it's coming up on, in the earlier matter.
Yes, VP Kulkarni.
Yes.
VP Kulkarni.
10 February.
Yes.
My lords, it's a matter pertaining to the passport, reissue of passport, my lord. Reissue of passport. My application is pending before the respondent number 2, my lords. I have filed an application seeking reissue of my passport, my lords. But it has been withheld on the score that we have to approach the concerned trial court and need an order from that trial court. But whereas, my lords, the offence under which I have embroiled, that is stayed at the hands of this coordinate bench of this honorable court. So, my lords, the issue stands answered by the.
Let me understand the facts. Let me
Yes,
understand the prayer.
Yes, madam.
And what is that, what are the facts of your case?
Yes, madam.
What is that you're seeking? Respondent 1 and 2 herein to renew the passport. We should tell them to renew the passport straight away.
Yes, my lords. I have filed an application and they have issued a.
It is within, if you fulfill the criteria, they will do it. Why should we tell them to?
Lords, they are insisting for the order from the concerned trial court.
So what should be the prayer and your writ petition?
My lords, there is no impugned order. There is no order from the trial court.
Impugned, I'm saying.
Yes, my lord.
Notwithstanding so and so.
Yes, my lord.
If otherwise my application is in order, let there be a direction to the respondent. It is now you seek a positive direction to them, sir, to renew their application.
Yes, my lord. But my lord, they have insisting for the order.
Court shouldn't do it.
But they are insisting from the order from the trial court, my lords, which is stayed by the coordinate bench of this court.
Proceedings are stayed.
Proceedings have been stayed, my lords.
My lord, covered by judgment of the divisional bench and single bench. And I have produced the notification.
Difficulty.
Notification, my lords, that is.
The difficulty what the advocates are not understanding is, judgment is not, it is based on facts and circumstances.
Please, my
of
lord,
each
please.
case.
Please.
Every case covered. No
No, my
facts
lords.
explained.
My lords.
No
I have
facts
produced
explained.
the official memorandum my lord, issued by the central government under section 22 of the Passport Act. That says, my lords, on my lords, First para, my lord. 2, GSR 570E, that's the relevant portion, my lords. GSR 570E dated 25/8/1980 is reproduced below for reference. So in exercise of the power conferred clause A of section 22 of the Passport Act 1967 and in suppression of the notification of the Government of India in the Ministry of External Affairs, GSR 298E dated 14/4/1970, the central government being an opinion that it is necessary in the public interest to do so, hereby exempt a citizen of India against whom proceedings in respect of an offence alleged to have been committed by him are pending before criminal court in India, and who produce orders from the court concerned permitting them to depart from India from the operation of the provision of clause F of subsection 2 of section 6 of the Act, subject to the following conditions, namely: A, the passport to be issued to every such citizen shall be issued for the period of specified in order of the court referred to above, if the court specify a period for which the passport has to be issued. The second is, if no period or either for the issue of the passport or for the travel abroad is specified in such order, the passport shall be issued for a period of 1 year. If such order gives permission to travel abroad for a period of less than 1 year, but does not specify the period validity of the passport shall be issued for 1 year. In reference to my lord's divisional bench passed the order in pair number 4 and 7. Pair number 4 and Kalburgi bench, my lords.
This is against which order?
It is not against the order, my lords. Page number 189 may kindly be perused of the writ petition, my lords. They have issued a letter dated 23/4/2025, insisting for the order from the trial court.
He's
No, my
referring on-
lords.
He's referring on some judgment.
What they say is, the criminal pending is the jurisdiction of the trial court.
See paragraph?
There is a 4 and 5, my lords. 4 and 7, my lords. 4 and 7. Pair number 4. Learn counsel for the complete petition would contain where the applicant is seeking to travel abroad and it would not apply to case for issuance of passport or renewal of passport. Learn counsel would also point out that decision of the Honorable Supreme Court in case of Ungala Kustur Ungalachalu versus CBI, which is an order passed by an interpol application in criminal appeal number 13 so and so, submit that the Supreme Court has held that passport authority can refuse to issue or renew the passport only in cases where an applicant is convicted during the period of 5 years, immediately preceding the date of application for an office involving a moral turpitude and sentence for an imprisonment for not less than 2 years. Per contra, DSJ would submit that the said case has been considered by the learned single judge in case of Atiq Muhammad and so and so. It was noted that provision falling for consideration in case of Ongala Kustur Ongala Cheru, clause E of the subsection 2 of section 6 of the Passport Act does not apply and not clause F. Having heard the learned counsel of the complaint, differential and learned JSS so and so. On perusing the petition paper, this court find that there has been a consistent view of this court that in cases falling under clause F of subsection 2 of section 6, even for the purpose of obtaining a passport or renewal of the passport, also the permission of the court where the criminal postings are pending against the applicant required to be taken. As rightly submitted by the learned DSI, this is not a case which falls under clause E of subsection 2 of section 6 of the Act.
This is a
Therefore,
correct law. This is a correct law.
yes, correct law, my lord, that is what section they have to approach the trial court. And this court has ordered the petitioner to approach trial court, and trial court shall consider the application. If not considered, then the approach against this honorable court.
What happens is ultimately the case is pending before the court. That is for the court to take a call whether this person, if there is any flight risk or not, what is happening and all. Why should the High Court grant orders of this?
Please, my lords, with respect to the crime which is pending against the petitioner, that is stayed at the hands of this court. The trial court will not entertain any application subsequent to the stay, my lords. That is the only my grievance.
Even in that case also, why are you in a better position? How are you in a better position?
My lords, if this honorable court, by virtue of this order, grants a direction to the trial court, they will entertain my application.
Please.
That is the only my grievance, my lords.
That we will do.
Yes.
But we will not grant any positive direction.
No,
to
my lords.
the-
No, my lords.
But why these kind of, how can the High Court grant direction to the Passport Authority? renew it? Case is
Not to the
pending
authority, my
before
lords. Not to the authority, my lords.
My lord, what happened, my lord?
But my prayer is that.
I make submission. Earlier, my lord, this court has passed the orders. That is what. Subsequently, the divisional bench.
That is like, I have passed several orders
Please.
because we can't interfere.
It is, no.
No, even in the cases like 41 years CRPC notice or a bail is issued, in those cases, let there not be any order saying that you can't leave the country, because that is for the court to take care. wherever the matters are pending.
Please,
Whether they can leave the country, they can't leave the country under the facts and circumstances.
please,
Even for renewal of the passport also should fall under it.
please.
The present petition is filed. Sing the following prayer. Extract the prayer. It is a case of the petitioner that the petitioner is a holder of passport bearing number Z2135412, issued at the Regional Passport Office, Bangalore, dated 16/10/2010. The date of the expiry of the passport is 15/7/2020. The respondent number 3 have registered a case against the petitioner and others in crime number 229 of 2018, dated 7/12/2018, for the offences under section 420, 465, 467, 471, 468 of the IPC. The allegation against the petitioner is that he has instigated the wife of the complainant to invest in their company and thereby cheated them on this score, and the affair came to be registered. The respondent number 3, after investigation, have filed the charge sheet against the petitioner and others before the principal civil judge and junior division and JMFC Batkal, and the learned magistrate had taken the cognizance against the petitioner and others on 21/12/2021 for the offences under 465, 468, 471, 406, 419, 420, 120B of the IPC, and they registered the case as CC number 2220 of 2022. In connection to the above case, the respondent number 3 police have seized the passport, and in consequences, the petitioner filed a memo before the trial court seeking direction to the investigating officer to return the passport. And the court, by the order dated 22/7/2019, was pleased to allow the same. When the investigating officer failed to return the passport, the petitioner had filed another memo dated 29/2019 seeking direction to the investigation officer. But the said memo came to be rejected by the trial court dated 5/2/2020 on the ground that the IO has submitted the passport to the regional passport respondent number 2, and now the passport authority has impounded passport under section 10 of the Passport Act. Then the petition has filed a petition in criminal petition number 102759 of 2023 to quash the entire proceedings in CC number 2220 of 2022 on the file of the principal civil judge and JMSC. And in the said petition, further proceedings are stayed, then how you can expect the court to deal with that?
My lord, sir, this honorable court in the single judge has passed the orders. Last paragraph, last otherly judgment. In judgment, I have produced the judgment. Last, my lords, that the trial court shall not reject the application permission for issuance of short validity of passport on the ground of pendence of criminal case before it.
Yes.
So that's third judgment, my lords. I have produced honorable my lord Nagaprasana judgment, my lords. That is in case of Shivkumar Matad. Shivkumar Matad.
No, in the pending quash petition, you should seek this direction. Now, one bench will stay all further proceedings. By virtue of that order, the trial court cannot do anything. And in another writ petition, another court will pass another order. How is it right?
Then they have to move that criminal petition.
What they are supposed to do is they can file the very same application before in that petition.
The criminal petition which is pending.
Which
Yes,
is
my
pending
lord.
because it is stayed for this reason.
Please, please.
No, there can't be two different
Yes,
orders
yes,
to
my
the
lord.
same court.
They move before that court, my lords. Otherwise,
The
judgment, my lords.
And by order dated 30/10/2023, was pleased to say the further proceedings so far as the petition and 2 other accused are concerned. Then thereafter, the petitioner has applied for renewal of the passport before the second respondent, and during the pendency of the application, the respondent number 2 issued a letter dated 28/6/2024. As a petitioner is involved in a crime, and the same is pending trial. Then the petitioner replied to the letter dated 28/6/2024, gave a representation dated 3/12/2024 to the regional passport officer, dated 3/12/2024. Thereafter, the respondents have issued another letter dated 23/4/2025, whereby the two shortcomings in the application for renewal of the passport of the petitioner copy of letter dated renewal of the passport of the petitioner. It is the case that till today the respondent 1 and 2 have neither acted on the application of the petitioner nor renewed the passport of the petitioner. Hence, the petitioner seeks a direction to the respondent to give a direction, notwithstanding the fact that the criminal cases are pending. Still, they can renew the passport. He relies on a judgment order passed by a coordinate bench of this court in WP number 24269 of 2023, arising out of in a case that is between Santosh Bejadi Srinivasa and Union of India and others, where
Last order, operative part of it.
Where the permission is granted to approach the court seeking issuance of a short validity passport, and the concerned court shall consider such application strictly in consonance with the Act, that is GSR 570, and its requirements. The court shall not reject the application permission for issuance of a short validity passport on the ground of pendency of criminal case before it. The petition in the application shall clearly indicate the reason and the intending date of travel from the shores of this nation and is returned to the shores of the nation. The Land Council submits that an order may be passed in the similar line. The Land Council appearing for the respondent submits that there cannot be a positive direction to the respondents to renew the passport. He has relied on a division bench judgment of the Kalburgi bench arising out of writ appeal contempt CCP number 200184 of 2023, topped with writ appeal number 200170 of 2022, arising in the case of Sanjay G. Kene versus Sri Krishna K. and another. He submits that the revision bench has categorically observed that in cases falling under clause F of subsection 2 of subsection C, even for the purpose of obtaining a passport or renewal of a passport, the permission of the court where the criminal proceedings are pending against the appellant is required to be taken. As rightly submitted within the DSGI, this is not a case which that particular case is not a case which falls under clause E of subsection 2 of section 6 of the Act. Therefore, since the case falls under clause F of subsection 2, which empowers the passport authority to refuse to issue a passport on any or more of the grounds enumerated therein, and clause F is a situation where proceedings in respect of an offence alleged when committed the applicant is pending before a criminal court in India, the submission is upheld and the court has directed the petitioner to approach the petitioner therein to approach the court where the criminal case is pending and seek permission for renewal of the passport. If such permission is granted, the same can be submitted before the passport authority. And if such permission is granted by the court, the passport authority shall proceed to renew the passport. Basing on this, Land Council submits that this is a case which falls under clause F of subsection 2.
2F.
As such, 2F.
Yes.
As such, the permission of the authority, permission of the court is required, and the petitioner is at liberty to approach in the light of the order passed by the division bench. Next paragraph. In response to that, Land Council for the petitioner submits that already as in his quash petition, the court had stayed for all further proceedings. As such, there may be a direction to the court to consider his application. Next paragraph. Having heard the counsels on either side, peruse the material on record. The judgment, the division bench judgment passed in Sanjay G. Kenny's case referred supra apply to the facts of the case, where As a criminal case is pending, they have to go before the very same court seeking this relief. But as the criminal proceedings were stayed by the High Court, and the petitioner wants those proceedings for the limited purpose to be opened and to approach the court, it is for the petitioner to file an appropriate application in the said criminal case. If this court passes an order directing the court to consider it, it would be contrary to the orders passed by the court in the criminal proceeding, in a quash petition. In that view of the matter, the writ petition is disposed of in the following manner, as per the following order. The writ petition is disposed of giving liberty to the petitioner to move appropriate application before the court where the quash is pending, and to entertain and seeking a direction to entertain his petition before the court as the proceedings are stayed.
From 22, dispose 123. Proceed shall.
Please. Lord's filing the withdrawal memo.
Take that.
Lord's liberty may be given to approach this honorable court to file a fresh petition.
For what?
Liberty to file fresh petition, my lords.
Before this court?
Before this honorable court.
Why?
My lords, the writ petition is maintainable. It must be read along with the 482, my lords. Yes, my lords. Of
You
CR.
say you want to file a quash petition.
Please.
Under 482, you want to file a petition.
Please.
Is it so?
My lords, it comes under the criminal roster, my lords.
That's what I'm saying.
Please.
Then they will, I'll give you permission to convert this.
Please.
A memo is filed for withdrawal. It is submitted that he has to file a petition he has to file a criminal petition. But he has filed by mistake, by oversight, the present writ petition is filed. Accordingly, the petitioner is permitted to convert this into a criminal petition
Grateful.
within a period of 10 days from the date of receipt of the copy of the order.
Grateful.
Yes. And for statistical purposes, the writ petition is disposed of. Yes.
124.
Also the petitioners, my lords. My lords, this is a partition suit and the petitioner is the defendant number 3. My lords, in 1989, there was a partition suit amongst the family members.
For the respondent.
My lords, they have not come on the previous date as well, and I don't have an interim order in this matter.
Kaujilgi.
Therefore, there is some urgency.
124. List 1.
Enough petitioner.
There is no representation for the respondent. Is this matter on
My lords,
Monday?
if lordships give me 2 minutes, my lords. There's no interim order granted in this matter.
No, anyhow, they're appearing. I can dispose it off on Monday.
Oh, okay.
This is matter on Monday, no representation for the respondent. If the respondents fail to appear on Monday, the court will hear the matter on the merits and dispose the same.
Please, my lords.
Yes, next.
Final hearing matter. Santoshas. Mattikatigi.
Yes.
126.
Where is he? Give that.
Santoshas. Mattikatigi. Santoshas. Mattikatigi.
Why even on the last occasion also no representation on appellant side? No representation on behalf of the appellant for dismissal next week.
Next.
Yes.
List 2. Sorry. Pass format.
Yes.
Pass format. List on passover matters.
76, my lords. Serial number 76.
76.
My, 76, my lords. My lords, both the cases 108, 232 connected cases, my lords.
Yes.
My lords,
70?
we had filed an IA number 76. 108, 232 and 228. Both are connected cases. AC matters. My lords, we had filed an IA number 4 before the additional MAC Bailongar seeking permission to file or additional estimate to the main petition, and the same was dismissed by the MAC court on ground does not disclose any sufficient cause, my lords. My lords, at the time of the cross-examination of the PW1, then only we came to know that there was the insurance of the motorcycle, and the insurance company is not even on record. So, my lords, as per the direction of this by Honorable Court, a copy for the other side was served to the counsel for the respondent in the MAC court, and the acknowledgement copy is already on the record, my lords.
A memo is filed as per the orders passed by the court. They have taken hand summons and served on the counsel appearing for the respondent. And a memo is filed in that regard. Where is that? Who is the advocate?
The ID 1 is appearing in the trial court, MAC court.
It is submitted that they have served the hand summons on so and so. And a memo is filed. Accordingly, notice to the respondent is held sufficient in both the matters. Yes, come to the impugned order.
Interim order, madam. Interim order kindly be passed, my lords.
Impugned.
Impugned order.
Impugned order.
The trial court, my lords, MAC court has passed the order on the ground that
Page number,
11
where
number.
is the order?
Page number 67, my lords. 67. Para 11, my lords. Having regard to the facts on the circumstances, they consider that present application is divided on merits filed on the protect the proceedings. Does not disclose any sufficient cause. My lords, kindly go through page number. He is admitted, petitioner is admitted, respondent is admitted in cross examination. The page number 59, second para. My lordship, can I read, my lordship?
Yes.
Last paragraph, two paragraphs, two lines, my lordship. Sadri motorcycle में विमा इतु. When we had done the cross examination of the PW1, she admitted there was insurance of the motorcycle. So my contention is that the present petitioner and the motorcycle of the insurance both are liable to pay the compensation to the respondent. When they filed the written statement before the trial court, MAC court, those facts we are not aware about those facts. For that reason, we filed an IA. So we have to file an additional written statement to the main petition.
Oh, that is the purpose of amendment of pleadings.
Yes, my lordship. Because the respondent is not record on the insurance motorcycle of the insurance company is not on the record. But we have done the cross examination. In that cross examination, she stated that there was a Sadri motorcycle in Ima Ittu. So she admitted that there was a insurance company, insurance of the motorcycle. But that respondent has suppressed the material facts, and that insurance company is not in the record, my lords. So my submission is in this case only that if this petition is not allowed, then it is going to be heavy loss to the petitioner. He has to pay the 100% liability to the present respondent. So if for this reason we wanted to add additional statement to that both the parties, that is petitioner plus that the insurance company of the motorcycle is going to be liable to pay the compensation to the respondent. So in spite of the notice already served, but there is no representation from the respondent side. So interim order kindly be granted till the next date of this hearing, my lords.
No, no, I'll dispose of your writ petition itself. Please argue.
Yes, my lordship. The respondent has filed a motor compensation case against the petitioner. Petitioner has appeared and done cross examination. And in cross examination, while the cross examination was going on, we asked a simple question to the petitioner, present respondent, that at the time of the insurance, there was insurance vehicle, motorcycle insurance was there or not. But she admitted that there was an insurance company of the motorcycle. In the, I'm relying the decision of the Honorable Supreme Court of India. My lordship, there is new ground of defense. In case of the Olympic Industries versus Mullah Hassan by Mullah and ORS, the Honorable Supreme Court held that even by filing an amendment or additional debt settlement, it is open to defendant to add a new ground of defense or to substitute and alter the defense in written settlement, so long as pleadings do not result grave injury or prejudice to the plaintiff. So, if seeking permission to file additional statement, there is no prejudice to other side, my lords. So, insurance on the motorcycle is also responsible to pay the compensation. So that is my only ground, my lords. And the writ may be allowed and kindly give a direction to the trial.
Please come to para 63. Page number 63, please come to.
Yes, my lordship.
Please read, what is the purpose of filing an affidavit along with?
Yes, my lordship. I am the respondent. I am the respondent in this case. I know the facts on case and I come to say this affidavit. Petitioner filed his false petition against by us creating a false concordant story in order to harass wrongful clause to us. That in top noted case fixes for cross of PW1. But due to as crucial information is left out, now it is not necessary to further bring to kind notice of the Honorable Court and file or additional statement to the main petition for it necessary for just and fair resolution of this case. So therefore, just legal necessary to allow the state IA permit.
Please stop there. Pausing there, what is that you want to say with that paragraph number 3?
File or additional written statement opposition to the main petition, my lords. That is top note fixable possibility due to crucial information allowed. For that reason, we filed the IA, my lords. Interim application before the trial court.
Please come physically to the court. Please come physically to the court, then we will decide. This is matter on Wednesday.
4.
Is next.
4th February. Seat number 86. Sangram S. Kulkarni.
No
86.
representation. This is the month of March.
Idhar.
Yes.
Sangram.
Do that. Why it is mute? So I'll ask him to unmute.
Unmute ಮಾಡ್ಕೊಳ್ಳಿ ಸಂಗ್ರಾಮ್ ಸರ್. ರೀಲಾಗಿನ್ ಆಗಿಲ್ಲ.
This is matter on Wednesday. Yes. Next.
Seal number password matter 106. 106. Yes.
Petitions. Well, Sanishar J. Mellots, wherein the elections were postponed, is under challenge before lawsuit. What has happened was on 4/7.
Who has postponed the election?
Respondent number 1 months, principal secretary.
Respondent.
First respondent, acting under section 121 of the Karnataka Cooperative Societies Act, which provides for exemption clause.
The 6th respondent society.
Please, 6th is the respondent society. Respondent number 6.
Elections are postponed.
Elections are postponed. Sanishar J. Mellots, and also pass on the translated copy of the impugned orders. G and J. Mellots. Annexure A. Mellots. Surprisingly, in Annexure G. Mellots, an intimation by way of an endorsement is issued stating that elections are postponed because the president or the chairman is not keeping well.
No. And as a final eligible voters list.
They say, Mellots. They
Has
say.
not been prepared and approved.
Electoral rules were prepared, Mellots. They were sent for the purpose of approval.
Become difficult to conduct the election.
Please, that is what their grievance is. My humble submission is section 28, Mellots, provides that for conducting any of the elections, my lords. The existing board should start preparation 6 months prior to that of the date which is mentioned for the, on the date of.
What do you say?
Your
What
Worship,
action has been taken by the concern when they're supposed to do it before 6 months?
please, Your Worship, and annexure J, Your Worship, where in page number 93.
Yes.
It was stated, Your Worship, in preamble of that order, Your Worship, it was stated on,
Correct. They have submitted a representation stating that they are not
Please,
well and they have not prepared the rolls is the reason.
please, Your
assigned.
Worship, please. Your
Are they, can they keep quiet without doing it?
Because,
Till the last date?
if at all, Your Worship, not
Then if
prepared.
they're not doing it, what is the, who is,
As if that under such circumstances, my lords, the present office bearer, the office becomes deemed vacant. The administrator has to take charge over the office, my lords. 28A, my lords, to that regard, 28A5, my lords, I'll take your lordship's kind attention, my lords. I'm sorry, my lords, I'm not keeping well. I might. 28A5, my lords, of Karnataka Cooperative Societies Act. If the new board is not constituted under section 29A on the date of expiry of the term of the office of the board, or if the elections are not held within the time limit specified under section 39A, the registrar or any other
28A,
28A5, my lords.
A5.
5, my lords. 28 means that.
Yes, if
please.
the new.
A5, my lords. If the new board is not constituted under section 29A on the date of expiry of the term of office of the board.
Term of office is expiring.
26(1) minutes is my instructions, minutes.
26?
1 minute.
Read.
Or if the elections are not held within the time limit specified under section 39A, 39A minutes provides for conducting of election 6 months minutes. That I'll come to that part minutes. The registrar or any other officer within whose jurisdiction the society is situated and who is authorized by the registrar shall be deemed to have assumed charge as administrator, and he shall, for all the purposes, function as a board of management. The administrator shall, subject to the control of registrar, exercise all powers and perform all functions of the.
Please, Your Worship, I will.
Then the ACA shall get instructions. In the light of the fact that the term of the committee completes by 26/1/2026, and in the light of section 28.
A5, my lords.
8A5. What are the steps that are taken by the respondent? List this matter on next Thursday.
Please, Your Worship.
What's the sort for interim order, minutes? For stay of the impugned order.
What will happen?
And that's this is exactly.
Yes.
My 6 months, my request is 6 months, my request is. Please.
6 next.
Great.
List 2.
Take notice for respond number 1 and 5, Your Worship.
AGA takes notice for respondent 1 and 5.
6 months, I'll take out hand summons. Please.
List 2. Orders matters. Seal number 1. B. Sharan Basava.
Appear for petition.
Sunjay's
Insofar as, my lords, respondent number 2 to 4 are concerned, the notice is not yet served. So I'll have to take notice, my lords. The other side has moved the matter.
Take out notice on the council appearing for the respondent before the trial court. Who
No,
moved the memo?
but 2 to 4,
I have moved the
but they have been placed ex parte before the trial court.
Then you file a memo to that effect.
Before the trial court, they were not appearing. I will file memo.
You can say that, as their ex parte before the court.
Because they are my vendors, my lords. My rights will be affected. They are my vendors.
It will be the same effect that they are here and unnecessarily, why should we install it?
They have been placed ex parte. Please, I will file a memo to that extent.
And what is your urgency?
For more than 3 years, my suit is stayed, my lord.
Suit is of which year?
2019, my lord.
Yes, let us see. Please argue.
Please. Here, the defendant number 4, your lordship may kindly peruse the order sheet, wherein, my lord, sufficient opportunity was not given to defendant number 4, that is the petitioner herein. Now, the suit is for the partition in separate possession. My lord, so plaintiff and defendant number 1.
You are a purchaser of the property.
I am the purchaser.
And your vendor is a member of the joint family.
No, not my vendor, my vendor's vendors. They were the members.
My lords, on
There is
20,
impugned order, let us see the
my lords,
impugned order.
I'm questioning that, my lords, sufficient opportunity was not given for me to file a written statement also.
When did
That is, my
you,
lords,
when did you
on
enter
29,
appearance?
please, on 29/7/2022,
29/7/2022. When did
22.
this order pass?
This order, plus the matter is posted, lots for arguments on 8/12/2022. Before that, my lords, the service in respect of R3 was, defendant number 3 was not yet completed. And a substitute service was taken.
Forget about all that.
Yes,
As
my
far
lords.
as you're concerned, your written statement, you have entered appearance on 29/7/2022.
Yes, my lords.
How much time according to you, you require for filing the written statement?
No, in fact, my lords, thereafter, your lordship may kindly peruse, my lords, that order dated 29/9/2022. The plaintiff has filed another application under Order 7 Rule 14. And for that, we have stated no objection. My lords, and thereafter, my lords, when the matter was, when the my lords, service was held sufficient in respect of defendant number 3, on the very same day, it was taken that we have not filed a written statement. That was within the period of 60 days. Within a period of 60 days, 60 days. And my lords, the court could have granted some more time or a week's time at least, my lords,
So,
to
for
file
the
us to, my
purpose
lords.
of granting some more time to you, the matter is pending from 23 to 26. For filing a written statement, a suit of the plaintiff.
Yes, my lords, the matter is not posted before this honorable court, my lords. I have taken, my lords, whenever the matter was posted, I have taken, my lords, notice to the respondents, but they have not served.
Come to the impugned order.
They have not filed any recall application.
Hmm?
They have not filed any recall application.
Order is, my lords, the entire procedure.
Let us see the impugned order. Where is it? Page number.
There is no impugned order, my lords, entire procedure, my lords, adopted by the, my lords, trial court in proceeding with the matter. My lords, without giving any opportunity.
You didn't even question any order of the trial court in the writ petition.
No,
We just said that it's a procedure.
please, we have questioned, my lords, that order of placing, my lords, that
Order dated 12/9/21.
12/9/2022.
Where is this order?
Please.
Typed copy is at page 42. Typed copy is at page 42.
12/9/22, 42 page number.
Page number 42.
Please. That is typed copy, my lords. Case called out before the court, advocate for plaintiff present and filed a memo with paper citation for service of summons to D3 by way of paper publication held sufficient, and D3, defendant number 3 called out absent and placed ex parte, kept by, case called out, no representation for D3 since the remaining defendants have not filed any WS.
You don't
Call
have a
on for
remedy to
plaintiff's
satisfy
evidence.
this order before the very same court.
No, we are not
No.
questioned by.
Remedy is available to you or not? When you
Yes,
set
we can-
ex parte to set aside the ex
We
parte
can file
order.
application. In the meantime, what has happened is this, my lords. Lords, on next date, your lordship may kindly peruse. That is 31/10/2022. The same page, my lords. Page number 43. Page number 43. Case called out, no representation, call on for further chief of PW1 as a last chance by 8/12/2022. And my lords, on 17/11/2022, in the next date, my lords, before the next date, the, my lords, plaintiff's advocate files an application seeking advancement without serving notice on us. And he completes, my lords.
The notice on you were set ex parte on 12/9 itself.
No. We have not been placed ex parte.
Then who is that?
So
ex
we
parte?
have appeared. Defendant number 4.
You are
I
defendant
appear for
number
defendant number 4.
Oh.
Defendant number 3 was placed ex parte. And, my lords, without serving any notice on the other advocate, the case was, my lords, advanced from the date which was fixed, my lords, on 8/12/2022. It was advanced to 17/11/2022. And, my lords, on that day, the evidence of the plaintiff completed and the matter was posted for arguments, final arguments.
I'm not able to understand the facts clearly. the prayer that you sought is quashing the impugned order dated 12/9/2022.
Yes,
Please come to 12/9/2022.
yes.
Advocate for plaintiff present and filed a memo with proper citation for serving summons to D3 by way of paper publication, held sufficient.
Yes.
Defendant number 3 called out absent and placed ex parte kept by.
Insofar as, my lords,
Advocate for
taking,
petition file hence submitted, case called out. You are D4 according to.
yes, D4.
And how are you executed by this order?
No, because now the written statement is not, is taken as not filed by us.
Where is that?
The, my lords, remaining defendants have not filed any WS. That is defendant number 4 is also, my lords. 1 and 2 were already placed ex parte. Defendant number 3.
Did the court say anything? Remaining defendants have not filed any WS.
WS.
So,
WS is
because
not.
you have not filed, it is recorded.
And the
it
matter
is
was
not
posted for the evidence on the next date. Next date. And my lords, the case was advanced.
I am going to dismiss this writ
My
petition.
lords, the case was advanced.
Yes.
The case was advanced without, my lords, issuing any notice to us on the next date of hearing. What was such a,
Not able to understand what is your, if that is so, you should have asked the trial court. You should have filed an application before the trial court.
Yes,
Why should you come before this court?
no, before that only, my lords, the case was, my lords, adjourned and plaintiff's evidence came to an end and the
that
matter
be
was
asked?
posted for the
Can't
arguments.
that be asked at that time? Can't you ask the court?
Yes,
That why you
we
have
did
not
not
done
file
it?
any application before the trial court, my lords, I do it. But without giving, my lords, any opportunity,
I'll record all that. Please come.
or, my lords, a liberty may be given for us to, my lords, file an
Not
application.
give any
necessary.
liberty. I will in fact, I'm going to dismiss it with exemplary cause.
Because-
For wasting, without any reason coming before this court, seeking stay of the order. And you don't file your written statement, somebody's suit stayed from the last 3 years.
No, I am the purchaser, my lords, I will be affected. I will
No,
I will
you
file
can-
the written
you have-
statement, my lords, I have not said.
Remedy before the trial court. Why should,
Lords,
why should you
I have
come
not
before
said,
this court?
my lords, I am not for going to file the written statement. We will file the written statement, my lords.
The
We'll
present
file the
petition
written
is filed.
statement and liberty may be given, my lords,
All
for
right,
us to file the written statement.
The petitioner before this court is the defendant number 4. The suit is filed seeking partition and to put the petitioner plaintiff in possession thereof. The suit is filed in the year 2019. The petitioner is the purchaser who has purchased the property? 3 has purchased, from 3 you have purchased.
Yes, 3.
Defendant
Defendant
number
number 1
and
has
2.
sold to defendant number 2. Defendant number 2 has sold to defendant number 3.
Defendant
And
number 1
I
has
have
sold the
purchased.
property to 2, 2 in turn to 3, 3 in turn has sold the property to 4. So petitioner is a purchaser. Now the impugned order that is before this court is, the order that is impugned before this court is page number
10.
My lords, 42, that is the typed copy. Order sheet.
dated 1/9/2022 at page number 42. Please extract as it is.
12/9.
The present, this order is passed on 12/9/2022 and this writ petition is filed before this court on 30/1/2023. And by virtue of the, where is that order? Order sheet. The coordinate bench of this court had granted
4th January
interim
20.
order on 4/1/2023 by staying all further proceedings in OS number 44 of 2019. Liberty is reserved in favor of the respondents to seek vacation, modification of the interim order. And that interim order is extended.
Not extended.
extended, it was extended.
from time to time. Then counsel for the petitioner submits that enough opportunity is not given to the petitioner to file the written statement. And the court had posted the matter for plaintiff's evidence on 29/9/2022. On 29/9/2022, case is called out and kept by. On 15/10/2022, plaintiff was examined as PW1. Then the matter was posted for the further chief of PW1 by 31/10/2022. Then on 31/2022, case is called out. There was no representation. And on that day, an order was passed, call on for the further chief of PW1 as a last chance by 8/12/2022. This writ petition came to, then on 8/12/2022, the case is advanced to hear,
No,
taken on record.
before that only, on 17/11.
On 17/11, the case advanced to hear, taken on board, kept by. Then on 18/8/12/2022, case again called out, advocate for plaintiff present, no representation for defendant side, further examined and got marked documents exhibit P1 to P27. Since the defendant number 1 and 3 placed ex parte and defendant number 4 has not filed the written statement, course of cross of PW1 is taken as nil. Further, 2 witnesses in support of her case examined as PW2 and PW3. Since the defendants uncontested, the suit cross of PW2 and PW3 also taken as nil. The land counsel submits that no opportunity is given and he has to file the written statement. Land counsel appearing for the respondent submits that his suit, which is of the year 2019, it stayed from the last 7 years. The petitioner has a remedy to file an application before the court. And without filing the same, he comes before this court and obtain the stay of all further proceedings. Next para. Having heard the counsels on either side, peruse the material on record. This court is not able to appreciate any of the contention that are raised on behalf of the petitioner. In an order dated 12/9/2022, there was an observation that the defendants have not filed any WS. Right from 12/9/2022 till 31/2023, what the defendant is doing, defendant number 4 petitioner is doing, nothing is on record. Why did he not file his written statement? Why did he not seek the leave of the court to file the written statement is not known to this court. By order in an order dated 8/12/2025, the court observes that the defendant uncontested the suit, uncontested, cross of PW2 to PW3 is taken as well. This order dated 8/12/2022 is not questioned. And the questioning an order dated 12/9/2022, where the court doesn't even say that the right to file the written statement is forfeited, is questioned before this court. It appears that the whole endeavor of the petitioner is only to stall the proceedings. If there is any bona fides on the part of the petitioner, he could have filed an appropriate application before the court immediately, but he couldn't have approached. He wouldn't have approached this court. This court finds no bona fides on the part of the petitioner. However, as a litigation has to be taken to a logical end, this court was of the view that the defendant may be permitted to file, the court shall grant reasonable time. The defendant shall file the written statement within a period of 1 month, within a period of 15 days from the date of receipt of the copy of the order. However, on the condition that the petitioner shall pay an amount of rupees 10,000 to the plaintiff. Accordingly, the writ petition is disposed of.
Please.
Seal number 2?
Yes.
List to seal number 2.
My lords, I appear for the respond number 3, Navalgunj Shirsangi Trust, my lords. It's a private trust.
Yes. On the last occasion, the issue was raised as to the maintainability
May I
of
submit in this regard, my lords? What has happened is, I have received an RTI reply from the Office of Deputy Commissioner, which does not say that it is a private trust, my lords. The problem is, I have received the copy in the morning, my lords, and it is not in a readable condition. I want to place it on records, my lords, so that I want to counter the submission. What they're submitting is that it's a private trust, but their records are saying that it is not a private trust. It is a philanthropic trust and charitable, registered under Charitable Endowment Act, my lords.
Where do you get that?
I've got it received in the morning, my
No,
lords.
that it is registered as a charitable institution, that you will get it from them.
My lords,
If it
that,
is registered,
please,
you
my
don't
lords.
require a negative answer from them. Bombay Public. Require a positive answer saying that, please specify whether this trust is a notified trust as per the Endowments Act.
It is notified trust, my lords. That's the order.
Okay.
That is the order, but it's not in the readable condition for now, my lords. If one short accommodation is given, my lords, I'll get it typed, my lords, because there is a lot of history to this trust, my lords. Right from,
Where did they say? I can see this.
my lords, for
What is your query?
my query is that, my lords, they are saying it's a private trust, my lords, but the very will that has been constructed, my lords, it is not.
If you say that it is a public trust, it should have been notified under the Endowments Act.
It-
That's the only thing.
It is in,
Where is it? Where do you get that?
my lords, in my writ petition, my lords.
This trust was registered under the so and so, and the property of which is vested in the treasurer of charitable endowments under the government notification bearing number dated 28/4/1988, and is engaged in philanthropic work for the upliftment, development, and dissemination of education to people of the society.
In fact, my lords, there are statements in the forthcoming pages, my lords, wherein the creator of the will has specifically told that what he has given to his legal heirs, and out of the rest of the property, what is to be done. And there are also the audit reports, my lords, which are the audit.
No, all that is not at all material. Only thing that material is whether, as per the provisions of the Endowment Act, a particular trust is notified. If it is notified, what is the notification number? That is only relevant.
My please, my lords, page number 31 of my writ petition, my lords. There's unnumbered paragraph, my lords.
30?
Notification number 3708, my lords, page number 31. So this is the notification which has come in the year 1928, my lords. Prior to this, there was a scheme, there was a transition of scheme that was brought for the administration and the functioning of the trust. In this, my lords, now therefore,
Matter on 10th by the time.
My lords, I have a
Who appears?
I'm for
The-
respondent number 6 now.
The second is you appear for the second, you're taken notice, accepted?
third
AGA.
respondent.
AGA shall get specific instructions, and also as a specific instruction whether this particular trust is notified as a public trust as per the provisions of the Karnataka, what is that?
It was registered under Bombay's Trust Act, my lords,
No.
previously.
No, you are concerned with if it is, it's an endowment, it's a, as per the
Charitable endowment.
So it has to be under this act. Public Trust Act, we are not concerned with that.
Please, my lords, please.
Whether it is registered under Karnataka Hindu Religious Institutions and Charitable Endowments Act Endowment Act. If the same is registered, the AGA shall place before the court the date on which that is notified as a public trust.
Much obliged.
Grateful. Yes. See, this 23-24 matter also objections are not filed.
Yes. We'll file, my lords.
I think there needs to be a change in the way the government is looking at these cases. Otherwise, courts will have no other alternative but to pass orders against your officers who are parties to the case. Yes, next.
Seal number 3, AP Hegde.
Respondent number 4 is not yet served.
Respondent number
4 is not yet served.
not known.
Not known at the,
Not known to whom? You
my
must
lord,
have stated.
the Lok Adalat decree is challenged. The address shown in that Lok Adalat decree,
But then how do you expect that notice will be served on him? When you have mentioned that the registry will not find out who is he?
sometimes, my lord, if a second time notice is taken, likely it is served. I'll take a chance once again. The address which was shown before the court below,
Radha Kuruva 64 years, household, resident of Ashok Nagar, Hubli, Dharwad district.
Yes.
It says address is, no such address. See?
Yes. Lord, in Annexure G, page 41, the address was, this was the address shown. She appeared.
Relationship between these people.
Respond number 2 is the mother. Respond number 3 is the mother. Respond number 2 is the brother of this respond number 4.
4.
Family members, yes.
4.
2, 3, 4 are family members. 2 has appeared. Lordship may direct respond number 2 counsel to appear for respond number 4. Because before trial court, the same counsel appeared for all the 3.
Chetan S. Piraj for R1.
It is for R1. For R2, one Patil has appeared.
R2 doctor, Sadananda, it's served, nobody is appearing
No.
for R2. R3 also served, nobody is appearing.
Lord, R2 appear agidare. When some Patil had appeared. His name is not shown. In the daily orders, I am seeing it, my lords.
Look at it. Anybody filed Wakalat?
Filed Wakalat.
In the name of Mr. Sharad M. Patil for R2. This is matter after 2 weeks.
My lord, he may be directed to take notice for respond number 4 also.
How can we direct him? Let him come, we will ask him.
Because in the trial court, the same counsel appeared. They are all family
We'll see
members.
once he comes.
Please.
Yes, 4. Non-taking of steps in respect of deceased outside. Steps shall be taken. Steps shall be taken within.
My lord,
within
is
10 days.
LRs are already on record.
Where are they?
Memo, respondent number 6, my lord. His son, sole son.
Did that. Memo is filed stating that the LR of respondent number 5 is respondent number 6, who is already on record. Memo is taken on record. The petition shall make necessary amendment to the cause title. Next, what about
Respondent-
notice to R3?
R3 is
Fund as
unclaimed, my lord.
unclaimed,
Deemed to be
amounts
so.
to deemed service of notice. List after service of notice to R1 and R2. Next 5.
Still number 5.
Process shall be
Carry.
paid within a week or else the
Notices.
petition shall stand dismissed against the respondent. 6.
Still number 6.
Well, I have already.
My lords, I
paid
represent the respondent.
Deficit is there
D-Shep is also paid.
in 5.
Yes.
It is submitted that the deficit.
Last
the-
occasion, last.
The
5
needful is done.
Yes,
List
madam.
after service of notice. 6.
Number 6.
My lords, I represent the
Stay, madam.
respondent, my lords.
My lord,
My
stay
lords,
may be
matter
continued.
has to be,
The stay is operating till today 5th.
Is there.
Yes, my lord.
Whatever is there will
Yes,
be
madam.
extended. Yes. 6.
Appearing
my
for
lords,
the
serial
petitioners,
number
my
6,
lords.
my lords, I represent
Connected
the
matters are
respondent.
listed on 25th, my lords. Maybe
No, my
this
lords,
matter may,
on 2 to 26 they are.
To the number, what are the
Please,
connected
my lords.
matters on 25th?
Interim order may be
Please, my
kindly
lords.
extended.
Yes.
On
Highly
2 to
obliged.
26 they are
7.
listed, my lords.
Yes.
Number kudi.
109291 of
Next,
25, my
number
lords.
7.
Please.
J. Shetty.
Please appear for
Patil.
filed application for vacating the interim order.
Lord, senior is held up in court hall number 7, my lord. May I kindly have it on tomorrow.
They have obtained, they have obtained the interim order and they are
No,
causing
your,
disturbance.
your senior shall be engaged in other court at the time of granting stay.
No.
Causing
Not
dis-
at the time
May
of
I kindly have it on
vacating stay.
tomorrow, my lord. Sure, he will
Thursday.
make a submission.
Next Thursday.
Please,
Interim order may
For no
kindly,
further adjournment
please,
interim order may kindly be extended.
at request of learned counsel the petitioner.
please.
Yes, 8.
Obliged.
Still number 8. Srikant T. Patil.
This matter also will not appear for respondent.
Prakash Bimali.
No representation for the petitioner.
Suit
Counsel the
is-
respondent present. This is matter for dismissal next Thursday.
Please,
Yes, 9.
obliged.
Still number 9. Srinivas Naik. Shuraj Mudhol.
Next week, Lord.
Who moved the memo?
Lord, I filed, my lord, I filed an application for vacating interim order. I moved the matter. Lord, you lords may kindly.
Since Lord, there is, he has filed the statement of objection. I am required to file rejoinder to that.
Lord, the petitioner has.
Any date, Lord, I will file it and Lord, your Lords may. Finally, it could be heard and decided.
Lord, the petitioner has challenged Annexure C. Issue has been decided by this honorable court.
What
Lord,
is
Annexure
that? Let us
C.
see.
Lord,
Without looking at his rejoinder, if this petition can be disposed of, we can dispose it
Lord,
of.
it can be disposed of, Lord, the issue is, Lord, in favor of the petitioner, Lord.
Let us see.
Please, Lord. Lord, improved,
Lord, your lordship.
Lord,
May I
Annexure
just,
C,
Lord,
page 22.
may I just apprise certain facts, my lord?
Impugned order dated 21/7,
Yes.
2025.
Page 22.
Asked by the first respondent. Where is this?
Lord, what happened is, some of them, Lord, members said to,
It's in Kannada,
yes,
Page 22, my lord.
22.
My lord, the Deputy Registrar of Cooperative Society accepted, my lord, the inquiry report and forwarded the same to the society. The contention of the petitioner is the Deputy Registrar can't accept the entirety. He has to apply his mind and pass an order. But this issue has, my lord, they come up before this honorable court and holds that the Deputy Registrar, he is not a post, it is not a post office. He has to, after receipt of the inquiry report, he has to consider it independently, take a decision either to accept the inquiry report or to reject it. This is a law laid down by this honorable court.
In his favor.
yes,
But that is the interim order, not that is not, you also may allow the writ petition, set aside the annexure C, let the authority pass a fresh order after hearing not both the parties. Not page, para 7.6 and not.
And why you, when you want
no,
some matter
he
to
has
be
made
allowed,
certain, no, there were certain allegations in the statement of objection.
the presented petition is filed, seeking the following prayer. The petitioner society is a educational, society is running education institution. Initially, there were about 62 members. Since the members did not get actively involved and did not get the membership renewed, the membership of those members got terminated. 20 members expired, and upon death of such members, their membership got terminated. Then the respondents number 3 to 6 have filed separate complaints to the first respondent on 3/5/2025, 5/5/2025, and 15/5/2025 regarding the functioning of the petitioner society. The first respondent, based on the alleged complaint said to have been filed by the respondent number 3 to 6, by order dated 6/6/2025, appointed the second respondent to conduct an inquiry into the affairs of the society under section 25 of the Karnataka Societies Registration Act. The second respondent conducted the inquiry and submitted a report stating that as regards the membership is concerned, there are certain discrepancies. Further, presently there being no valid members, the existence of the petition society itself is in question. So far as the other aspects are concerned, there are no discrepancies found. The first respondent, in pursuance of the inquiry report submitted by the second respondent, without even taking note of the fact of the inquiry report and without there being any application of mine, not even accepting the said report or rejecting the report, has simply forwarded the same to the petition society, directing to initiate further proceedings. Agreed thereby, the petitioner is before this court. Coordinate bench of this court on 28/2025 had passed an order
29,
28/2025. This order.
yes,
Interim order.
Huh?
interim order.
Interim order.
28/25, my lord.
28/2025, an order is passed, wherein it is observed that the inquiry report has been mechanically forwarded by respondent number 1 without application of mine, and accordingly, it is stayed till the next date of hearing.
Lord, item number 3, my lord, in view of interim order, my lord.
That's what I recorded.
WP number mentioned. In view of the order dated so and so.
29/7/2025
Yes.
passed in WP number 104/203 of 2025. The inquiry report has been mechanically forwarded by respondent number 1 without application of mine. Accordingly, there shall be stay. The
Yes.
order, impugned order is stayed till the next date of hearing.
That is judgment.
When the matter came up for hearing today, land counsel appearing for the respondent submits that the very same writ petition, which is quoted in the interim order, was allowed. And
7.6 to 8, my lord. The fact that,
the
may I read, my
court,
lord?
by order dated 29th July 2025, at paragraph number 7.6, 7.7, and
7.8, my lord.
7.8, as observed as follows, extract that. It is submitted that in view of the said order, the writ petition may be allowed and the matter may be remanded back to the first respondent for consideration on the merits of the matter, for considering the report and for passing appropriate orders. The next para. The whole grievance of the petitioner is the first respondent, basing on the report of the second respondent, without application of mind, has forwarded it to the petitioner society, which ought not to have been done. The said contention of the petitioner is strengthened by the judgment of this court by order of this court and coordinate bench of this court in WP number 104203 of 2025, dated 29th July 2025. In the light of the light of paragraph number 7.6, 7.7 and 7.8, this court is passing the following order. Accordingly, the order impugned dated so and so is set aside.
Annexure C, my lord.
Annexure C is set aside and the matter is remanded back to the first respondent, and the first respondent shall consider the report of the second respondent in the light of the order passed by this court and pass appropriate orders.
After providing opportunity both.
After providing due opportunity to all the concerned.
Please. Much obliged. Please.
Yes.
Serial number 10. Mr. 210.
Sorry, my lord, on submission. List to serial number 4, interim order may extend.
It all will be extended. Please don't ask every time the same request. Yes, 10.
Lakshman T. Matagan.
I am Pradhan petitioner.
Prashant S. Kesmani.
Lords, I have filed, Lords, I have for vacating the interim order. So case, Lords, where the petitioner, Lords, was a successful bidder. He had, Lords, obtained in a tender called by the corporation. He had obtained, Lords, the toilet and other facilities, Lords, provided in the bus stand. Lords, there was an agreement wherein, Lords, he has to charge only 5 rupees for use of toilet and nothing for the use of the urinals. He was, my lords, charging double the amount. Instead of 5, my lords, he was charging 10 rupees. And for the facility he has to provide free, he was also charging there also. Several complaints were received. It was even published in the newspaper that these activities are going on. Accordingly, my lords, we had issued him several notices. Thereafter, my lords, we had also, my lords, as a warning, we had there is a provision. We have imposed fine upon him. He accepts that, pays the fine on 4 occasions. My lords, he accepts the fine, but continues to do the same thing. Ultimately, my lords, under the agreement, my lords, we have cancelled his tender, his agreement. That, my lords, is challenged. But your lordship kindly see, my lord, the tender was, my lord, given on 1/9/2025. The work is allotted for a period of 2 years, up to, my lord, 31/8/2012. Immediately within 12 days, my lord, at the instance of the, my lord, previous, my lord, contractors, the notice, my lord, started giving the notice, my lord, every 10 days.
When was it cancelled?
Now it has been cancelled. Your lordship kindly take, my lord.
Date of the cancellation.
And date of cancellation 27.
25/11.
25/11. 25/11/2025, my lord. Madam. Yes. But here, your lordship kindly see the conduct of the, my lord, the authority. They have, my lord, they have passed an order on 25/11/2025. However, my lord, by issuing notice, by final notice, they filed a caveat petition before this honorable principal court on 19/11/2025 itself, my lord. But they are bent upon to, my lord, cancel it. That at the instance.
Let's not go into all that.
Yes.
Please tell the court what is the irregularity in the doing.
Yes,
this.
they are without there being any, my lord, complaint, my lord, I was, my lord, doing, my lord, at the instance of the others, and also, my lord, they have, my lord, conducted the Panchanama, wherein it was not at all conducted Panchanama in my presence. Your lordship kindly take, my lord, they have produced the Panchanama along with the statement of objections. Only, my lord, the persons who are known to them, my lord, they have called for them and the Panchanama has conducted, and it has been based on that, my lord, cancellation order came to pass. My lord, I have 5 lakhs rupees, 45,000 rupees. I am the highest bidder. I paid this.
We'll hear it next Thursday.
Next Thursday,
Lords,
madam.
he has filed,
12th, my lord. 12th.
Yes, well.
One submission, Lords, he has filed a contempt petition
Now it is coming up
Madam,
tomorrow.
List this matter on 12th.
Please.
Such time the petition shall not precipitate the contempt proceedings. Yes.
Please. Cell number 11, list 2. MV Hiramat.
Filed application for vacating stay.
For petitioner, my lords, may kindly permit to file the rejoinder to the statement of objections, my lords.
File
I have
before the-
served the copy, my lords.
File before the registry, not
Please,
here.
my lords.
My lords,
I
what has
request
happened,
next week, my lords.
After, my lords, the work order has been issued, my lords, before passing the interim order by this honorable court. And thereafter, the successful bidder, my lords, has supplied the, my lords, food grains for 1 month. To the, my lords, they,
Rejoinder, they want to file, we will
Please.
pass on.
now they have filed a contempt petition saying that though the interim order has been passed, we have issued the work order. Work order issued, my lords, prior to, my lords, passing of the interim order by this honorable court. And in pursuance of the work order,
So also on Thursday, the court will hear the vacate petition and the petition shall not precipitate the contempt proceedings.
my lords,
Yes, next.
in the meantime, my lords, in the meantime, my lords, the successful bidder may permitted to supply the food grains to the, my lords, the students
an
of the
interim order, my
hostel
lords.
students. Because of the interim order,
I'll not do it now. Yes.
Interim order may kindly be extended.
Interim order only granted is extended till then. Yes, 12.
Preliminary hearing matter, cell number 12. Malikan Swamy
Petition-
P. Hiramat.
Respondents have moved the amendment.
Yes.
In
who
fact, the
appears-
interim order was modified after hearing the application for vacating stay. I was permitted to only operate.
Pertaining to 17, 18, 19 will be
I
pending
understand.
there. 25 matters, interim order to be granted, interim order to be vacated, for that a memo.
It was, in fact, it was coming up in B group. They made a request to get it listed in preliminary hearing.
Yeah, though a memo is moved, the petitioner, the respondent is not ready for the arguments, list this matter in the month of March. Interim order only granted is
No,
extended.
I am ready, my lord. They have moved and they are seeking time. I am ready.
My lord, senior engage them at.
Them only said, they filed
I'm
the
sorry.
vacate, they filed the vacate.
Yes, ma'am. In fact, that was heard and interim order was modified.
Yes, yes. Yes, 13
March. Cell number 13,
Interim order may kindly be extended.
Sunil S. Desai. SH Mittal Court.
For the respondent,
My lords.
the petition is filed
Lords, I
challenging the
request a week's
reinstatement
time, my
order.
lords.
Sorry. The petition is filed challenging the reinstatement.
Have an interim order in your favor.
Please.
Have an interim order in your favor.
Interim order.
It's there. It's there.
It's there.
List this matter finally on next Wednesday.
Please.
Yes.
Cell number 14.
Yes,
next week.
May I seek 2 weeks accommodation, your lordship, because similar set of matter is already pending before the Supreme Court. By virtue of whatever interim order is passed, your lordship, in this court also we have a protection by virtue of interim order. So now still SLP is pending before the Supreme Court.
What do you say?
Yes, my bad.
List this matter in the month of March.
Yes, interim order may be extended. Please, grateful.
This next.
Cell number 15. ML Matti. SL Matti.
I'm undertaking the wakalat on behalf of the petitioner, my lord. The earlier council has given the NOC.
Submitted that so and so has instructions to file the NOC vakalat. This is matter in the month of
So
March.
kindly be extended.
Interim order is there extended.
Interim order.
Yes, 16.
16.
Ma'am, Your Honor, kindly give the next date.
I am Mullah.
Kindly give the.
Yes,
RK
next.
Kulkarni.
16.
16.
Yes, in the month of March, look at it. Interim order is there extended. 17.
17. Gurdev Gachinmat.
Serial number 17, my lords, 17.1 to 11, my lords, are totally unconnected with serial number 17. 17.1 to 17.11, my lords, it is unconnected with serial number 17. I don't know why it is tagged.
What is unconnected with 17?
Main petition, my lord, serial number 17, I am appearing for petition. It is not connected with the rest of the petitions.
Yes. Who gave the numbers?
Who don't know, my lord.
They are also surprised.
It's a
my lord.
tender matter and this is a cooperative society.
Link, delink 17 from all other numbers.
Lord, may I make another
17
submission?
interim order, my lords, needs to be extended.
17 interim order earlier granted is extended. Yes.
Lord, from 17.1 to 17.11, except 17.2, all 10 matters, I appear for respond number 7. All the writ petitions have become infructuous. My lord, if your lordship permits me,
But seeking a,
we are a society, cooperative society. All petitioners are members of our society. In their 2021, some natural disaster took place in that village. So they are contending, they gave a representation to the government that their loan raised in our society be waived off and government pay the amount to society. They made a similar request to us, requesting us to move an application to the government seeking waiver of loan. We also submitted on their behalf. Now the government, after filing of this writ petition, has passed an order rejecting their representation.
Not my.
So, in fact, the representation filed by us on their behalf.
No, 17.2 is unconnected again.
Yes, 17.2 is
same, but same relief one and the
Then
same.
all these 17.1
To
till
17.11.
11, list these matters tomorrow as part heard on the top of the list.
Please.
We'll hear it tomorrow.
Please.
18. 18.
My lord, the petitioners have filed the suit for partition and separate possession, and the respondents WS came to be not filed. Thereafterwards,
Well, it's a short accommodation. May I seek for short accommodation?
There is no date. Why you are listed 24 matters? Who is doing that? बोलो, सबको बात करेंगे. Yes.
yes, the petitioners have filed the suit for partition and separate possession. The respondents
I seek for a short accommodation, my lords.
You have a stay?
tomorrow.
You have a stay in this?
Stay.
This is matter on 26th of February, interim order earlier granted is extended till then. Yes, 19.
So we request for Monday, my lords.
Why? You have a stay?
Tomorrow.
It is our own suit, my lords.
Then why did you state it?
Because of, there is already.
The matter on Thursday, next Thursday. Yes, 19.
19.
Yes, name, yes.
Next. Seal number 20, urgent. Seal number 20, dispose. Seal number 21.
My lords, here the petitioner.
2 weeks time, lordship, interim order there, lordship.
My lords, here the petitioner has taken the stay for the counting of the votes, my lords. Here, I take only 5 minutes of time, my lords. It's been fourth time which has been coming before this court, my lords.
Tuesday it will come, Mr. Counsel. S22.
My lords, kindly have it, a small request, my lords, kindly have it on top of the list, my lords, because always the matter is coming at the last of the list only, and the matter is not reaching.
All these matters on the top of the list.
My lords, it's just a request, my lords.
Top of the list.
Because it's an artless at my lords, you know.
Yes, 622.
22.
Kindly have it in the preliminary hearing at least, my lords.
Yes. 22.
Please,
Interim order.
for responding, my lord.
23.
Lords,
Ahmad.
number 22, my lords. This is matter has been posted for judgment, my lords. At that time, they have filed the application for amendment of plaint, my lord. Seal number 22, my lords. I am for respondent, my lord.
There in this.
Please, my lords.
Stay is there in this.
Stay is there, my lord.
This matter also Monday as part heard. 20 part heard. All these part heard matters I'll take up at 2:30. Whatever part heard is said, no? Top of that is 2:30 list you make it. Yes, 23.
Lords, one
Lordship, I
submission.
appeal.
One submission. The impugned order is in Kannada, my lords. That may be.
Then what do you, what the court has to do now?
I will file, my lord.
By the time you file,
Please.
you can't file it on Monday, then I'll give it some other day.
Please, my lord.
Monday or some other day.
Please, I will file within Monday, my lord. I will.
Yes. 23.
Your Lordship, in this case, senior counsel from
Lord,
Bangalore is
representing
appearing, Your Lordship.
respondents.
The
The
issue in
respondent
this case is, Your Lordship, the trial court has ordered all the respondents to file assets and liabilities in a DV case. Your Lordship, it is a unique case wherein mother-in-law has filed case against daughter-in-law and grandchildren. And the trial court is saying that all the grandchildren are also necessary, should file their assets and liabilities, which they are having their personal properties and they are residing separately, Your Lordship. So that is the issue which has to be answered. And in case of Rajneesh versus Neha, the word respondent is used, Your Lordship. That is, it was incorporated for husband, Your Lordship. Even in case wherein wife files a case against husband, it is only the husband who has to file assets and liabilities, not the other respondents as well.
So interpret what is respondent, what is respondents.
Yes, Your Lordship.
Yes. What do you want? Who moved the memo? You
I
have
am
moved.
representing first respondent, Your Honor.
Vacate is,
She is
interim order
82 years old.
Intermission is there, Your Lordship.
Does this matter on Tuesday? In this 2:30 matters?
Next week, your lordship, any date, your lordship.
Tuesday is next week.
Or Thursday. 12th would be proper, your lordship. We will not take any further arguments because senior counsel has to come from Bangalore. 12th, he has instructed.
They wait up to the Supreme Court, their petition has not been admitted in the Supreme Court.
Let
They are
your
challenging
senior counsel
similar
come.
issues.
It would be,
Through VC. Yes.
we will try, your lordship.
24.
Interim order may be extended.
Interim order will be extended in all
Please.
the matters. Please don't ask for it.
Please, please.
RM Javed, please. 24.
Next week, Lord.
But there are two suits filed, my lord, one by the present petitioner and one by his mother, my lord, both against the daughter-in-law. So both suits could be clubbed and taken up on the same date, my lord, because both are before the same court. Instead of, my lord, he seeking impleading to come into the other suit, he independently also has filed a suit, my lord.
What do you say?
Next week, no, I'll just convince it. It'll take some time.
Why? No, it will take, why both suits can't be clubbed together?
It can be clubbed. I have no issues, my lord.
He also see agreeable for that.
My lord, that would solve, my lord, his problem also and my problem
I have
also.
filed an impleading application in their suit.
This also 2:30 is Tuesday.
Tuesday, my lord.
Yes. Yes.
Yeah, please, interim order. Please.
My lords, a small submission, my lords.
Yes.
Serial number 21. Serial number 21, second list, my lords. Kindly have it in the top of the list, my lords, because it's been fourth time, my lords, which has been at least in the first list, my lords, because the matter has been stayed, my lords, and the ballot papers have been kept.
Serial number 8. Serial number 18, date of.
3. 21, 22, ಎರಡು ಪಾಠ ಎರಡು ಸೇಮ್ ಇದೆ ಅದು ಅಲ್ಲ, ಬೇರೆ ಬೇರೆ 21 ಒಂದೇನಾ 22 ಪಾಠ 22 ಕೇಳ್ತಾ ಇರೋದು 230 ಇಲ್ಲ 22 ಯಾವುದು 21 23 ಏನಾಯ್ತು 23 ಮೇಡಮ್ ಮೇಡಮ್ ಇದರಲ್ಲಿ ಒಂದು ಡಿಲಿಂಕ್ ಮಾಡಿ ಉಳಿದೆಲ್ಲ
Sir, serial number 18, date.
19 ಆಲ್ರೆಡಿ ಆಗಿದೆ ಅಲ್ಲ
22 file ಬಂದಿದೆ. Serial 22.
Sir, serial number 18. 18.
ಇಲ್ಲೇ
18
ನೋಡ್ಬೋದು.
ನೋಡ್ರಿ.
ಏನ್ ತರ್ಸಡಿ ಏನ್ 19 and 18 18 20 ಅತ್ತಲ್ಲ ಎಷ್ಟು 18 ಡೇಟ್ ಅಂತ ಆಗಿದೆ 20th ಅದು 20th ಫೆಬ್ರವರಿ
20th February.
ನಂದ ಸೂಟ್ ಅದು ನಾನು ಸೇಫ್ ಫೋನ್ ಮಾಡಿ ನಾನು ಜಲ್ದಿ ಬೇಕಂತ ಇದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ಅಂತ ಹೇಳಿದ್ರು
20th
ಇಲ್ಲ 20th ಹೇಳಿದ್ರು ಅವರು
ಇಲ್ರಿ 20th ಮೇಡಮ್ ಬರ್ಕೊಂಡ್ರು ಕೇಳಂತಾಡ್ರು ನೀವೇನ್ ಬರ್ಕೊಂಡ್ರ ಮೇಡಮ್
ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ಹೇಳಿದ್ರು
ನೋಡುನ್ ತೋರಿ ನೋಡುನ್
ಈ ಸಲ ನಾನು ಭಾಳ ಅರ್ಜೆಂಟ್ ಇರ್ತದೆ ನಂದ ಸೂಟ್
ನಾ ಬರ್ಕೊಳೋದಿಲ್ಲ ಅವ್ರು ಬರ್ಕೊಂತಾರ
ನೀವು ಅದನ್ನ 19 ಅಂತ ಹೇಳ್ಬಿಟ್ರಿ
ಸೀರಿಯಲ್ ನಂಬರ್ 19 ಕಾಲ್ ಮಾಡಿ ನಾನು
Serial number 18 call ಮಾಡಿ.
18 ಆದ್ಮೇಲೆ 19 ಬರ್ತದಲ್ಲ
ಹೌದು ಅದನ್ನ ಮಾಡಿ.
ನೆಕ್ಸ್ಟ್ ಥರ್ಸ್ಡೇ ಅಂತ ಹೇಳ್ತಾರೆ ಮತ್ತೆ ನಂಗೆ ಪರ್ಟಿಕ್ಯುಲರ್ ಡೇಟ್ ಬೇಕು ಓದ್ಕೊಂಡು
ಹಂಗಂದ್ರಿ ನೀವು ಹಿಂಗ ಮಾಡ್ರಿ